The chairperson for the session is Dr. Neeru Chedda. She is the first Indian woman to be elected as a judge in ITLOS. Dr. Neeru Chedda is a distinguished lawyer and one of the leading experts on different aspects of international law. Dr. Chedda has the distinction of serving as the first woman chief legal advisor to the Government of India. She has advised the government on diverse issues relating to the law of the sea, involving interpretations of various provisions of UNCLOS. I now request the chairperson to take over the
Great pleasure to be here today to chair the session entitled From Shore to the Ocean Floor, International Law and Law of the Sea. I thank ISIL for giving me this opportunity and putting together an impressive list of speakers who will address the current developments on the topic. There are many experts here, but just to set the tone, as you're all aware, the adoption of the United Nations Convention on Law of the Sea is considered a seminal lawmaking event of the United Nations that codified and provided a universal legal framework for all human activities relating to the oceans. The convention addresses and governs all aspects of ocean space. It provides a jurisdictional regime prescribing the rights and obligation of states in different maritime zones. It also contains a substantive legal framework for all uses of the oceans and compulsory mechanism for settlement of disputes. The convention's substantive regimes, which apply to various areas such as fisheries, navigation, protection of the marine environment, and marine scientific research, are complemented by a number of specialized agreements and institutional arrangements at the global and regional level, some of which predate it. Together, the convention and related agreements provide the legal framework for the oceans. The convention was negotiated with foresight and is seen to have stood the test of time and has been described as a living instrument which can adapt to changing circumstances. The amendment procedures of the convention provides a number of formal amendment procedures which are subject to stringent requirements and have never been used. To address new challenges and change circumstances, and modality of implementing agreements has been used, which have de facto modified or amended the convention or the law of the sea framework. As you all are aware, there are now 3 implementing arrangements. The first instrument in this category is the 1994 agreement relating to the implementation of Part 11 of the convention. This instrument addressed several difficulties which many industrialized countries had raised with respect to seabed mining provisions contained in Part 11 of the Convention. And these amendments paved the way for universal participation in the Convention regime. The title, of course, refers to implementation and not amendment. The 1995 Agreement for UN Fish Stocks Agreement is the second implementation agreement. Its objective was to ensure long-term conservation and sustainable use of straddling fish stocks and highly migratory fish stocks through effective implementation of the relevant provisions of the convention. A third implementing agreement, as you all are aware, was adopted last year. An intergovernmental conference convened under the auspices of the United Nations adopted the agreement under the convention on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, or BBNJ agreement as it is shortly called. It addresses 4 main issues: marine genetic resources, including the fair and equitable sharing of benefits; measures such as area-based management tools, including marine protected areas; environmental impact assessments; and capacity building and transfer of marine technology. The BBNJ agreement also addresses a number of cross-cutting issues, including the possibility for obtaining an advisory opinion from the tribunal, that is, Tribunal for Law of the Sea. In addition to implementing agreements, the convention also uses several other mechanisms through which adaptation to conform to new changes in circumstances may take place. It provides, for example, the obligation of states acting through competent international organizations to establish relevant international rules and standards or to work through appropriate international organization. In many cases, the rules and standards adopted by these organizations are incorporated by reference to the convention These are called rules of reference. The two most relevant international organizations in this respect are the International Maritime Organization and the Food and Agricultural Organization of the United Nations, both specialized agencies of the United Nations predating the convention. The IMO is the global standard setting authority for the safety, security, and environmental performance of international shipping, and therefore addresses a wide variety of issues covered under Part 7 of the convention, which relates to high seas, and Part 12 of the convention, which relates to protection and preservation of marine environment. Therefore, the FAO, as you're all aware, is competent international organization in the area of fisheries. It has adopted several agreements and soft law instruments in this field, which complement the fisheries provision of the conventions. And the latest there are several agreements, but the latest in this field was the 2009 agreement on port state measures to prevent, deter, and eliminate IUU fishing. The convention provides in its Article 399 for the convening of meetings of state parties of the convention, and it has created three international institutions: the International Seabed Authority, the Tribunal, and the Commission on the Limits of the Continental Shelf. The convention entrusts a regulatory role to these institutions in their respective areas. Last but not the least, the international courts and tribunals, including ITLOS, help in clarifying and developing the law of the sea framework. The main task of these tribunals is, of course, to settle disputes concerning the interpretation or application of the convention. In so doing, the tribunal has to apply the convention and other rules of international law not compatible with it, and through its decisions in contentious cases, as well as through its advisory opinions, the tribunal has the chance to clarify and develop the law of the sea, which not only benefits the state parties, but the international community as a whole. Now, having briefly outlined the structure of the convention, I'll call on the first speaker to kindly speak. And I will also request the speakers to kindly briefly introduce themselves after they take the floor. Thank you.
Okay. So, as told by Madam, first of all, welcome, Madam. After a long time, I am actually, it's a pleasure to meet her. In fact, last time we traveled together to Hamburg, and afterwards she became now the ITLOS judge. So it is pleasure to speak in her presence on my topic on undersea cable. I have a kind of expertise or skill in under this law of the sea affairs as a strategic analyst as well as a legal expert from 2005 onwards, starting with the Rhodes Academy in 2005, attending and subsequently attending various maritime academies, including the very famous Nippon Fellowship at ITLOS. In fact, I think I was the first Nippon Fellow at ITLOS. So that gives me a kind of, provides me a kind of insight into the affairs. And today I'm basically dwelling on the evolving my submarine cable governance regime and UNCLOS. In view of the recent US proposal regarding the New York Principle on Undersea Cable Protection. So, with this background, I start my presentation. As we know, undersea cables are basically backbone of global internet and critical infrastructure. And in fact, these submarine cables or undersea telecommunication cables carry around 99% of the transoceanic digital communication, including voice, data, internet, as well as the financial transaction involving SWIFT transactions. These are thus the critical component of global internet infrastructure, what we call it the critical information infrastructure, vital for the communication system connecting different regions of the world and the global economy, and widely used by individuals, government, as well as the intelligence agencies across the world. According to telegeography, there are around 600 commercial undersea telecommunication cable systems globally, which includes both domestic as well as the international cable systems connecting every continent except Antarctica. In fact, according to TRAI, our Telecommunication Regulatory Institute of India, that there are around 17 international submarine cables landing in 14 cable landing stations across India, including in Mumbai, Chennai, Cochin, Tuticorin, Trivandrum. So we have the 5 major global landing stations in India, and that is why it becomes very important from the Indian perspective also to discuss and dwell upon these issues. Now, there has been some increasing threat to the submarine cable network. As we know, from 2013, we witnessed there was a revelation known as the Snowden revelation, which revealed that the UK's government communication headquarters had tapped into the network of internet cables to access vast quantity of communication between entirely innocent people as well as targeted suspects. That is what is known as the Global Five or the Five Eyes. They are into these affairs. Anyway, and recently in October 2023 also, the gas pipelines and the telecom communication Baltic Sea, which connects Finland and Estonia. If you see the geography of Finland and Estonia, they are very near. In fact, you can reach to Finland via ship from the Estonia in within 1 hour. We are damaged. So these communication systems were damaged allegedly by the Chinese ship known as the New Polar Bear. Now, there were suggestions from the Estonian sides that the damage were basically deliberate. It's not an accidental damage, deliberate. So that gives a geopolitical context to the whole issue now. Now, these incidents have brought to the fore the issue of vulnerability of undersea cables to disruption and sabotage by adversaries in both state as well as the non-state actors, and also underscore the fragility inherent in the global undersea data cable network. Now, from the Indian perspective, India's strategic location in the Indo-Pacific, specifically in the Indian Ocean, is the focal point for undersea cable connecting countries across Europe, West Asia, East Asia, Southeast Asia, and West Asia. And thus, these cables are critical for India, and protecting them is strategically vital for Indian security interests. Now, there has been emerging area of concern for Quad states also regarding undersea cables. And in this context of this geopolitical environment across Indo-Pacific, there exists a potential for similar incidents in cable-dense Indo-Pacific region, in particular the states of Malacca, arguably one of the world's most critical cable choke points, where numerous undersea cables converge to power Indo-Pacific's states' digital economy. Any kind of disruption to undersea cable in region would potentially disrupt communication, internet connectivity, and financial transactions in this region. And this situation is likely to exacerbate threat to regional security and stability in view of the ongoing tension in the South China Sea. And in this context, there is an enhanced kind of concern regarding the protection of submarine cables which has become a kind of an emerging area of concern for Quad states. Quad is basically loosely we can say an organization composed of the US-led organization composed of US, Japan, Australia, and India. All right, and they're in the geopolitical context, they are the one who are basically trying to counter South China Sea in Indo-Pacific area. Now, on 21st September 2024, the Quad leaders joint statement recently. Mr. Modi also attended this summit, Quad summit. So there the Quad leaders' joint statement underlined the need for quality undersea cable network in Indo-Pacific, guided by the principle of development and deployment of digital public infrastructure, important quadrilateral security dialogue. This is the full name of Quad. Initiative on submarine cables in Indo-Pacific includes, some of them is including the establishment of Cable Connectivity and Resilience Center in Australia. And with respect to India, India has commissioned a feasibility study to examine undersea cable maintenance repair capability in Indo-Pacific. So these are the point is there is an emerging area of concern for Quad as well as the international concern for safety and protection cable, undersea cables. There are a number of UNGA resolution on protection of undersea cables, and in fact, the UNGA resolution 58/199/2002, other resolution 66/231/2011, and the UNODC's second expert meeting on submarine cables 2019 have recognized the importance of these cables as critical information infrastructure and emphasized the need for states to adopt national laws and regulation to protect submarine cables. Coming to the cyber perspective, because that is also very critical, I think our naval officers know about these things. The Rule 54 of Tallinn Manual 2.0 provides that standard provision of the law of the sea apply to the cyber operation to submarine cables as well. Recently, the UNGA resolution A/78/L.15 2023 also recognized the critical role of international cooperation, need for, that is the emphasis on the cooperation in combating threat to marine security, including submarine cables and other critical infrastructure through bilateral as well as multilateral instruments. So the emphasis on international cooperation through bilateral as well as multilateral instruments and mechanism that aimed at monitoring, preventing, and responding to such threats. So there is now a kind of evolving mechanism or diplomatic initiative targeted at entering into negotiating some sort of bilateral or multilateral instrument regarding the protection of submarine cables. And therein, this is the topic of my presentation also. Prior to getting into that initiative, US initiative, let us look at the legal framework, international legal framework of submarine cables. The international nature of submarine cables creates legal difficulties at many levels. All right. In addition to the question of rights and obligation imposed on the states, owners and the installers of cable crossing several states, there is also a question of protection of these critical infrastructure. The international legal framework applicable to the laying of submarine cables comes from the basically the UNCLOS governs the legal framework as far as the protection of undersea cable is concerned. The UNCLOS incorporated the essential provision of the 1884 International Convention for the Protection of Submarine Telegraph Cables, that is known as the Paris Convention 1884. It is currently in force for 48 states parties to the Paris Convention, who are obliged by its terms of to protect submarine cables. In fact, India is not a party to this convention. India is a party to UNCLOS. But India is not party. In fact, you can see US is not party to UNCLOS, but it is party to that Paris Convention. Whereas India is party to UNCLOS and not party to, say, the Paris Convention. Some of the prominent provisions of Paris Convention that protects the submarine cables on high seas are Article 2, 4, and 7. Article 2 provides declare that it is a punishable offense to break or injure a submarine cable willfully or by culpable negligence in such a manner as might interrupt or obstruct telegraphic communication either wholly or partially. Article 4 provides that owner of a cable who on laying or repairing his own cable breaks or injures another cable must bear the cost of repairing. All this is about the criminalization and the compensation for the break kind of a disruption to the cables, submarine cables. Article 7 provides that owner of a ship or vessel who can prove that they have sacrificed an anchor, a net or other fishing gear in order to avoid injuring a submarine cable and receive compensation from the owner of the cable. So all these things are there. Primarily, the vulnerability of the undersea cables, as we know, emerge from two sources. One is the fishing activities, and another is a kind of a disruption by non-state and state actors. So one is the accidental, another is the deliberate act. In fact, there are around 150 to 200 around accidental damage to the submarine cables, and we have the dedicated ships only they are doing the repairs. Unclose the I take 5 minutes. Unclose and the right to lay submarine cables. Unclose provides for some maritime zone regime. As we know, we have the maritime zone regime divided into the territorial sea, the EEZ, the continental shelf, etc. Now, this Article 21 provides that coastal states may adopt laws and regulations in conformity with UNCLOS, etc., with respect to protection of submarine cables. Beyond this territorial sea, we have the freedom of high sea, which includes the freedom to lay down the submarine cables. In fact, the Article 79 of UNCLOS specifically deals with the submarine cables, where it is provided that all states are entitled to lay submarine cables and pipelines of continental shelf, and similar thing is provided is kind of a mirror into the EEZ regime also. All right, I am just skipping certain portion here. Now, all these rights are subjected to due regard obligations of the cable-laying states or the ships. All right. However, the UNCLOS does not incorporate certain provisions of the Paris Convention, including the civil liability, as well as the criminalization and the inspection of the vessels, etc. Particularly, Indian legislation, we have the Indian Telegraph Act, and it is implemented in form of the TRAI guidelines and the DOT licensing regime. All right. Coming to the recent move of the US on the New York Principle for Undersea Cable Protection, it has proposed 9 these principles for protecting in undersea cables, including the designing the undersea cable infrastructure with resilience, redundancy, and security, and built in with cybersecurity based practices, as well as to promote selection of secure and verifiable submarine cable providers. This is where lies the problem here, because this is the primary reason the China has opposed this kind of proposal by US, in fact, because China has accused US of kind of securitizing the undersea cable protection. All right. Now, it also talks about the public-private partnership for undersea cable deployment, etc., as well as to encourage alternative submarine cable routes. Because of some sort of disruption, you need to develop some alternative submarine cable routes also, as well as sharing of best practices. Encourage undersea cable network service provider to have transfer of ownership. This talks about the ownership of the service providers. That means they are targeting basically the Chinese companies which are increasingly involved in the submarine repair, etc., and supply of the equipments. It also talks about the security risk assessment regularly, as well as the data risk mitigation framework and data security measures in compliance with the international law as reflected in UNCLOS. So I just conclude here by saying that in view of today's geopolitical environment, especially in Indo-Pacific, protection of submarine cables has become a strategic imperative, as they are increasingly exposed to security threats from hacking to surveillance. And in this regard, this US call for endorsing this principle, New York Principle, has assumed quite significance. These 9-point principles are kind of a non-binding principles aimed at ensuring security and resilience of undersea cable infrastructure. These emphasis on reliability, sustainability, resilience, and security of these infrastructure. The Joint Declaration on Security and Resilience of Submarine Cables has been endorsed by the US, EU, as well as some of these US allies at the recently held UN General Assembly in New York on 26 September. In fact, and that is where the China has opposed it very fiercely. They have opposed it for politicization of submarine cable protection. As far as India is concerned, I would like to point it out here that India's strategic location in Indo-Pacific makes it a focal point for undersea cables connecting countries across in this region, and it is important for India to formulate a national policy on undersea cable protection to protect its strategic and national interest in this region. With this, Madam, I conclude my presentation. Would be happy to have question and answer also. Thank you very much for listening.
Thank you very much. I think submarine cables are not only important strategically, but also for our day-to-day life. Unlike our assumptions that most telecommunications is through satellites, but I think it has been reported that almost 90% of world's communications are through submarine cables. So not only strategically it is important but in this digital world for our survival also it is important. And I also want to bring your attention to Article 113 of the Convention,
Yes, yes.
which requires states to criminalize
Yes.
willful or negligent breaking of submarine cables
Yes.
by ships flying their flags or for persons under their jurisdiction. And I think in India we don't have any such law.
Yeah,
as far as
currently
I'm
we
aware.
don't.
So I think we need to work on this. And I think we'll take the questions at the end of the
Yeah.
session, and I will now request, because we are missing two speakers, so I will request Ms. Niluka Damayanti from Department of Legal Studies, the Open University of Sri Lanka, to take the floor. She'll be speaking on analyzing fishing policies of Sri Lanka and India, adequacy of utilizing Sustainable Development Goal 15. Here's the floor, ma'am.
Thank you, ma'am. Very good morning, distinguished panel members and guests. I am Niluka Damayanti, lecturer from Open University of Sri Lanka, and today it is honor to hear and present my ongoing research analyzing fishing policies of Sri Lanka and India and the adequacy in realizing Sustainable Development Goal 14. This is part of my ongoing research, and I would be much appreciate for your comments, and I think I will improve my research. When it comes to the transboundary fishing challenges, the Pork Bay region is an important area for the fishing industry in both countries, and it has been considered as a shared heritage. And fishermen from both countries have engaged in fishing activities over the centuries, and this is largely impact on the economic GDP of the countries as well. So, however, past few decades, issues such as coastal insecurity, illegal fishing, and overfishing have occurred and affecting the bilateral ties between the two nations and posing threats to marine ecosystem, food security, and sustainable fisheries. So, before moving to my presentation, I will present my objectives of the research. That is to analyze the policies adopted by Sri Lanka and Indian government for the fisheries governance, with a particular emphasis on how these policies align with SDG 14, and to evaluate the adequacy on these regulatory frameworks, and to examine how international agreements such as United Nations Convention on the Law of the Sea influence national policies in order to address transboundary fishing challenges, and to identify the key policy gaps and to suggest policy recommendations as well. Coming to the discussion parts, that we know that Sustainable Development Goal 14, that is SDG 14, titled Life Below Water, is one of the 17 global goals established by the United Nations as part of their 2030 agenda for sustainable development. So it is dedicated to conserving the sustainable using the oceans, seas, and marine resources to ensure the health and sustainability of marine ecosystem and the livelihood that depends on them. So we can see that the objectives of SDG 14 include several specific targets aimed at addressing critical issues affecting marine environment worldwide. That is reducing marine pollution, sustainable management of marine and coastal ecosystems, minimizing ocean acidifications, and regulating fishing practices, conservation of coastal and marine areas, and so on. So I am focusing on IUU fishing practices continued in the region. We know that the SDG 14 is very much important as it covers the biodiversity protection, economic value, and climate regulations as well. So, despite this importance, due to certain issues, now it became as a challenging task in implementing SDG 14, as these challenges includes overfishing and illegal fishing. That is one of the most pressing challenges we faced, and which in my research I will be focusing on the illegal fishing activities. That is one of the most challenging issues in the Pork Bay region. And the other one is marine pollution and climate change and ocean acidification and weak governance and enforcement mechanisms. As many regions in Pork Bay as well, there are inadequate laws and enforcement mechanisms to protect marine resources. So this gap allows unsustainable practices to continue. When it comes to the global and regional cooperation in realization of SDG 14, it is important to note that there are a number of initiatives that can be identified, that is international agreements. SDG 14 works in with several international frameworks and conventions such as UNCLOS, which provides a legal framework for managing marine resources, and the regional initiatives. Collaboration among countries is essential to address shared challenges like illegal fishing and pollutions, and also private and public sector engagements are there. So we know that the UNCLOS plays a critical role in shaping the national fishing policies. So both countries have signed and ratified the convention, but yet challenges arises in the practical implementation and enforcement of these laws, especially in Pork Bay area, where boundaries are always contested. Additionally, there are regional initiatives are there, Bay of Bengal program and cooperation through SARC, like this. Coming to the next important point, that the role of Sri Lanka and India in achieving SDG 14, we could observe that both countries have extensive coastline and rich marine ecosystem, but these countries have faced common issues such as overfishing and shared waters like Pork Bay. And by strengthening national policies, enhancing regional cooperations, and align with international agreements, both nations have can play a significant role in achieving those targets. Then, when it comes to the Sri Lankan perspective, Sri Lanka government has implemented several policies to manage the regulate fishing activities. That the umbrella act is the Fisheries and Aquatic Resources Act and the Coast Conservation Act. Measures such as restricting the use of destructive fishing gears and bottom trawling, those are implemented, but despite these regulations, challenges remain in the enforcement and procedures regarding the IUU fishing activities. And When it comes to the Indian perspectives, I could see that Sagarmala projects and national plan is there, and marine fisheries regulations and management act is there, and coastal regulation zones are declared. But despite all these mechanism, actually, when I visited certain areas in my country, I could see that collect primary data on enforcement mechanisms, I could see that the legal proceedings are very much complicated and takes a lengthy process, and language issues are there. So because of these things, and ultimately those issues depends on the geopolitics and diplomatic relations. So when it comes to the policy gaps and challenges in achieving SDG 14, I could see that the enforcement mechanism is very weak, and existing regulations leads to conflicts with the illegal fishings, and lack of regional cooperations, and the economic pressures are there, because often prioritize given to the short-term economic gains over the long-term sustainability due to inadequate livelihood alternatives. Coming to the conclusion part, even though Sri Lanka and India have made great progress in bringing their fishing policies in line with the SDG 14, there are still several issues that needed to be resolved, especially regarding the enforcement, regional collaboration, and financial strain on fishing communities. To achieve SDG 14 by 2030, a concrete effort involving creative solutions, regional cooperations, and community support is essential. In addition to improving marine conservation, this will guarantee the long-term viability and well-being of fishing communities in both nations. Thank you very much for hearing.
We have 3 speakers on BBNJ. In the list, Dr. Virendra Kumar is listed as the first speaker. He'll be speaking on evaluating complexities and challenges in protection, utilization, and benefit sharing of marine genetic resources in areas beyond national jurisdiction. So I'll give you the floor first, or do you want that there should be a critical analysis of the treaty first and then we'll take the floor? Okay. So first I'll request Tanya Ahuja, because she's speaking, she'll give us the framework for BBNJ treaty. She's providing us she's speaking on legal protection to marine biodiversity in area beyond national jurisdiction, a critical analysis of the BBNJ treaty. So the floor, madam.
Good morning, everyone. My name is Tanya Ahuja. I'm a LLM student from DU, Law Faculty of Law. So it's a great opportunity for me to present before Neeru ma'am. So the topic of my presentation is legal protection to marine biodiversity in areas beyond national jurisdiction, a critical analysis of the BBNJ Treaty 2023. So, almost after 2 decades of discussion and negotiation, a new legally binding instrument on marine biodiversity in areas beyond national jurisdiction, that is, the BBNJ Treaty, was finally adopted on June 19, 2023. It is a historic achievement which has a potential to contribute to better manage global ocean and biodiversity. The initiative is a broader part of UN SDG 14, which focuses on conserving ocean and marine resources. Now, talking about the marine biodiversities in areas beyond national jurisdiction, that is the ABNJ, they support marine ecosystem, regulates Earth's climate, provide vital resources including raw material for various purposes, medicinal support, and essential services such as air purification, and they also support cultural values. A legal discussion around marine biodiversity in ABNJ is important as ABNJ covers approximately 43% of Earth's surface, and thus it is necessary that there is an effective governance framework for that. Now, moving on to the current state of marine biodiversity, the growing human activities such as fishing, shipping, installation of submarine cables, mineral resource exploration has led to a decline in wildlife populations, unsustainable fishing practices, and also has endangered various marine species. Now, it was with the objective of conservation of marine ecosystem and sustainable use of marine resources in ABNJ that BBNJ was formally conceived as third implementing agreement under the UNCLOS. The existing legal frameworks were fragmented, incomplete, and inadequate. So BBNJ was adopted with the object to facilitate collaboration among states and stakeholders for effective governance of the marine biodiversity. Now, coming to the important provisions of the treaty, first is the regulation of marine genetic resources of the ABNJ, which is dealt under Part 2 of the treaty from Article 7 to 13. The provision provides that the significant benefits from the activities involving marine genetic resources and their associated digital sequence information, for example, the DNA data, is to be shared fairly and equally among the nations. Also, there is a provision for mandatory sharing for traditional knowledge associated with the marine genetic resources found in the ABNJ. Under the Part 3, that is from the Article 14 to 21, provision for area-based management tool, including the marine protected areas, is provided to regulate human activities for conservation purposes in ABNJ. Also, it provides for implementing, monitoring, and reviewing MPAs with focus on supporting developing countries. Under the Part 4, the environmental impact assessment is outlined. It is a 4-stage process consisting of screening, scoping, impact assessment and evaluation and prevention, mitigation and management. The EIA report is to be made publicly available. In certain circumstances, EIAs may be conducted in accordance with national laws or other international instruments. Under Part 5 and 7, capacity building and marine technology transfer provision is provided, with a focus to support developing states in enhancing their marine scientific and technology capabilities. It promotes transfer of marine technology on fair terms. A dedicated committee will oversee the implementation of these. A special fund is established to provide financial assistance to the states. Further, the dispute settlement mechanism and advisory opinion is provided under Part 9 and 7 of the BBNJ Treaty. Dispute settlement follows other laws of sea treaties. Parties can choose a method for dispute settlement such as mediation, negotiation, arbitration, or other judicial settlement methods. Now, coming to the critical analysis part of the treaty, firstly, under the marine genetic resources, there may be a challenge to maintain freedom of high seas and at the same time regulating access and use of resources. Talking about fair and equitable sharing of benefits, monitoring compliances and ensuring equitable distribution can be a challenge, especially for developing countries. Treaty provides for clearinghouse mechanism with a web-based platform to provide open access to MGRs. Here, the open access can have different meaning to lawyers, scientists, and it can have different cultural meanings. In this context, IPR issues could arise because if these rights are restricted, it would exceed the flexibility which has been allowed under the international rules such as the TRIPS. No reference to IPRs under the BBNJ could give rise to uncertainties about which activities can be viewed as commercial, leading to commercialization and exploitation of genetic resources. This could also hinder innovation in marine biotechnology. Next, the treaty mentioned about marine protected areas, but specific guidelines on their establishment, management, and protection level is absent. Example, the treaty may not be fully able to prevent deep sea mining, as International Seabed Authority can still authorize mining in areas designated as area-based management tools if it has its own environmental plans. It is not clear yet how ABMTs will be integrated with other international agreements related to fisheries, shipping, and climate change. Also, the treaty requires monitoring and evaluation of ABMTs, but the specific guidelines as to the type of data to be collected, frequency of monitoring, and uses of indicators to assess the effectiveness is absent. As regards the environmental impact assessment, treaty doesn't address transboundary impacts. Thus, it doesn't ensure that EIAs consider potential effects of planned activities of other states or the ecosystems. Also, how the impact of climate change on planned activities will be assessed is absent. Treaty also falls short of recognizing clear guidelines for the use of traditional knowledge in EIAs. Also, since national procedures may be adopted for the activities impacting ABNJs, then there can be varying standards and practices. Then, under BBNJ, EIAs should be conducted based on expected impact rather than on the type of activity. If a planned activity has a minor or transitory effect, EIAs may not be compulsory. Now, the interpretation of minor or transitory effect can be subjective and it is open to interpretation, which could be an issue. Now, within the capacity building and marine technology transfer, there is no mention of broader issues related to sustainability or climate change. Also, while the mandatory nature of some of the funding for capacity building and technology transfer is provided, given the large gaps that exist in ocean governance, funding might not be enough. Thus, developing countries might face excess issues. Another issue is how the needs assessment would be done. Under the dispute resolution mechanism, though flexibility may be there as a strength, but it could also lead to lack of consensus among parties, and this could lead to delays, and it can also lead to forum shopping and other jurisdiction issues. Now, what are the recommendations for enhancing marine biodiversity protection? As I have analyzed the issues, these issues need further deliberations and clarifications through the interpretation of certain unclear terms, and there needs to be a better coordination among states. There is a need to strengthen enforcement mechanism and increasing funding for research and conservation, and most importantly, there is a need to engage all the stakeholders and especially the local communities, as their traditional knowledge may be very useful for the implementation of the treaty. Lastly, it is the international cooperation of all the stakeholders which will be essential for the effective implementation of this treaty. To achieve its objective, it is important that the major developed states ratify the treaty. The effectiveness of BBNJ can only be verified after it enters into force in the implementation phase. It is only then that the behavior of parties regarding the obligations will be revealed. So now I conclude my presentation. These are the references which I've used for my research paper and presentation. Thank you.
Thank you very much for highlighting the challenges before the states in implementing the convention when it comes into force. At the moment, I think there are around 105 states that have signed the agreement and only 14 state parties. And only it will come into force after, I think, 60 states ratify the convention, the implementing agreement, sorry. And the challenges are many because there are a number of institutional mechanisms that have to be set up before the convention is or the agreement is implemented. So we have 2 more speakers on this subject. I will now request Dr. Amreni Kumar from Faculty of Law. He'll be evaluating the complexities and challenges in protection, utilization, and benefit sharing of marine genetic resources in areas beyond national jurisdiction.
A very good morning to all of you. First of all, I'm thankful to ISIL for giving this opportunity, and I'm thankful to ma'am also. When I saw that I'm going to present this paper in the chairmanship of ma'am, so really it is a great privilege to me. What Tanya has said, I will go beyond that because she has covered the treaty as a whole. My focus point is only MGRs, marine genetic resources, and why this is so important these days. We have already history of debating, protecting about the biodiversity. Now human beings are going to explore the new biodiversity which is in deep seabed area, and for that purpose there is about this emergence of this treaty in this form. So MGRs are very promising source of for biotechnology, and till this data is up to 2016. Up to 2016, 862 marine species and approximately 13,000 genetic sequence associated with that is already patented under PCT. First patent with respect to marine genetic resources came in 1988, and since then we are moving forward. I will show you this diagram also later on. But what is the importance? Why this BBNJ is so important? That is I'm reflecting here. The majority of patents were registered in last 15 years, and the growth is approximately 12 to 15% per year in this. 10 countries representing only 20% of the world coastline won 90% of patent in marine genetic resources. A single transnational corporation, BASF, registered 47% of the genetic resources sequences. And 73% of patent were for microbial species, which account for 20% of marine life. So more than 1600 sequences from 91 species associated with deep sea and hydrothermal vent system. Hydrothermal vent system, just I will explain that at deep sea, it is very different to survive in that kind of condition, any kind of living thing. So these MGRs had a very unique type of adaptation skill, that they can survive at the highest pressure, they can survive at the lowest temperature, they can survive without light. Okay, and why this? Because they have certain kinds of genetic information, and there are number of protein which make them adaptable at that stage. So they are so commercially important, and it is now known to, after this completion of genome project of human being, now world is moving towards sequencing for all the living creature of the earth. So by 2025, the global market for marine biotechnology will be approximately $6.5 billion. Then MNC have a unique ability to capitalize and monopolize the market through these IPRs. So this is about the MGR occurrence record outside the EEZ and hydrothermal vent. This is also the data of 2016. that it suggests that this is actually in high seas, and where there are hydrothermal vent means where there is a suitable condition at deep sea level, where there is a living creature is surviving of that kind of any kind of species. So first of all, I'm going to discuss the legal framework, international legal framework prior to BBNJ, and mainly it was governed through UNCLOS and CBD. Okay, so this UNCLOS does not explicitly address biodiversity. It talks about only the common heritage of mankind and silent on MGR from the area. From the area, that means seabed area. And even in UNCLOS, when we go for the freedom of high seas, this was the debatable issue that seabed area that will fall under the common heritage of mankind or not. So provides for environmental conservation in area beyond national jurisdiction. It does not talk about the this, but at least conservation measures are given under UNCLOS 3. Obligation for states to protect and preserve the marine environment, and indirect protection of MGR, which is completely insufficient and inefficient. Then CBD talks about the genetic resources and genetic material. And it is defined under CBD, that is genetic resources are defined in genetic material of actual or potential value. Material is intended as any material of plant, animal, microbial, or other origin containing functional unit of heredity. And it excludes biodiversity in area beyond national jurisdiction. That means earlier we have started with national sovereignty principle over biodiversity, but later on, earlier we have started with this common heritage of mankind principle. But when the biopiracy grown faster, then we have started putting it under the national sovereignty principle. And biodiversity convention also talk about the national sovereignty principle. So what rules about those biodiversity which are beyond national jurisdiction? So however covers activities and process under the jurisdiction and control of states anywhere, including area beyond national jurisdiction. That means there are certain provision in beyond national jurisdiction, states may do certain activities, and that can be regulated under CBD. Now I am coming to the BBNJ. This is a unique treaty specifically for high sea biodiversity, passed by General Assembly, decision 78 by 560. The complete name and nomenclature of the treaty I have referred here. Agreement under the United Nations Convention on Law of Sea on the conservation and sustainable use of marine biological diversity of area beyond national jurisdiction. Adopted on 13 August 2024. This agreement is open for signature up to 20th September 2025. Till now, as ma'am suggested, there are 105 signatories and 14 parties. India signed just 1 month back on 24th September. And after 120 days of signing the 60th party, then it will come into force. Just as Tanya covered already, there are number of issues covered under this. That is mainly for its substantive element. First is area-based management tool. That is including marine protected areas, environmental impact assessment, MGRs, fair and equitable sharing of benefit, capacity building, and the transfer of marine technology. I am going to cover only that MGRs. In MGRs, first of all, in this treaty, BBNJ, that which was the doubt earlier, that whether the area is going to be covered under that this high sea or not. So first of all, in Article 1.2, it has been referred, area beyond national jurisdiction cover both, that is high sea as well as the area, and conflict was resolved about the areas MGRs. Then marine genetic resources also defined any material of marine plant, animal, microbial or other origin containing functional unit of heredity of actual or potential value. However, they generally also cover derivative of living organism in ABNJ and digital sequence information of MGRs. Derivative of living organism is sometimes become more important than the organism itself. So after going through the definition of Biotechnology Act, which is provided, as well as the utilization of marine genetic resources, accordingly, biotechnology, according to this convention, means any technology application that uses biological system, living organism, or derivative thereof. That is very important, or derivative thereof, to make or modify product or process for a specific use. When we go through the utilization of marine genetic resources definition, it says that means to conduct research development on the genetic and biochemical composition of marine genetic resources, including through the application of biotechnology, which cover the derivatives of MGRs. Okay, so in that way, derivatives are currently sometime may become important. What is these derivatives? Just like any kind of protein, lipids, or component of that particular organism which is found in that, for which due to that there is a specific characteristic in that organism. So that become very important. So fair and equitable sharing of benefit provision is dealt under Part 2 of the Convention between Article 9 and 16. According to the Section 9A, which talks about the fair and equitable sharing, it says that this benefit sharing arising from activities with respect to marine genetic resources and digital sequence information on genetic resources of area beyond national jurisdiction for the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. Another thing is that DSI is not defined under the convention. Agreements provision apply retrospectively, that those who have already came through or already invented this DSI of MGRs, then collected before entering into the force, unless the party make an exemption in writing. That means this convention will apply retrospectively unless and until party at the time of the signing this treaty or ratification, they are not making that kind of the exemption. So the provision, however, do not apply to fishing activities or government vessels unless living marine resources collected by them are later utilized as MGRs. So general fishing is exception, but when you are doing the fishing for the purpose of DSI or MGR resources, then this convention will apply. Fair and equitable sharing of benefit measures. So in that there are 4 major parts which cover under the convention. First is notification system. Notification system for activities concerning MGR and DSI. In this, there is a requirement prior to going to take MGRs, during taking the MGRs, and then after qualification, that means something already information you get, then communicating those information. So for that purpose, there is a requirement of notification. Then non-monetary benefit sharing, access to samples of MGR or excess DSI generated from MGR. So non-monetary benefit sharing is also given under this, that not only monetary sharing benefit, that is we perceive as the actual benefit sharing, but it has been given under this convention that no non-monetary benefit sharing is also the part of this. In case of monetary benefit sharing, aid by developed states, 50% of and in addition to assessed contributors. Option for the conference of parties to determine an alternative monetary benefit if it is not suitable in futures. That option has been given already here. And then IPR protection in 3 separate articles. Then MGR sharing provision, benefit sharing and benefit, what I have already discussed this in this form. Then BBNJ inherent challenges with respect to MGRs. So first of all, there is a common provision under Article 5.2, that is non-determined provision. I'm sorry, non-undermined provision. It says that this agreement will only apply when other agreements are properly functioning. That means it will not interfere with the other agreement which is already in existence. So this agreement shall be interpreted and applied in a manner that does not undermine relevant legal instrument and framework and relevant global, regional, sub-regional, sectoral bodies, and that promotes coherence and coordination with those instrument, framework, and bodies. Potentially large impact on the future application of BBNJ treaty, because if other treaties are working, they are not in conflict with this. This treaty should not be in conflict with the existing treaty. So that is a kind of negative aspect of this. Key concept of UNCLOS, common heritage of mankind, freedom of high sea, and an application in BBNJ. That is this within high sea, that is freedom of high seas, are available with respect to MGRs or not, it is still not clear. Then no clarity that MGR and DSI are distinct from one another. No language stating that MGR are the common heritage of mankind. No applicable in military use. That is also one kind of things, that in case of military use, this BBNJ will not apply. Now these days, the purpose of military for future has been completely changed. Yesterday we are there in one session, there was discussion about the automated weapons, automated vehicle also. So if there is automated vehicle for using this and accessing MGRs and doing the research without under the military provisions, take the example of for making the weapons of mass destruction and all, biological warfare and all, that will be not covered under this. So these are the data with respect to the patents of marine genetic resources, which is available on the UN website. And most of the private companies are holding, you can see this applicant side, Genentech Incorporation is number one, holding with more than 3,000 patent over it. Then BBNJ external and practical challenges. 2 minutes now, only 2 minutes. BBNJ external and practical challenges. First challenge is about global south versus global north. Mainly it is about the technology transfer, that most of the country is still not able to explore the sea. So this treaty, to what extent it is for the global reach, or it is going to become only the tools for the users who are the able to explore the sea. Maximum utilization and minimum sharing. In case of technology transfer, technological advancement allow access to the global common, but it may happen like that how the technology evolved in the West earlier, there was greenhouse effect, and now there is a climate change. Okay, so and now in the 21st century, those provisions are going to be applicable on the whole country of the world about the carbon trading and all. Same may happen in future with respect to the marine genetic resources. Those who are able to it, they are going to get all resources. And in future, only thing is that there is this under IPR, there is a years limitation. After 20 years, it will go into the public domain. But between those 20 years, they will have exclusive right to use it. The same sequence of utilization of another global common high seas on the similar path, few countries are not able to explore due to the high cost also, even though there is a technology, but the cost is so high that they cannot use. These are the number of patents by the country in the of the MGRs. You can see USA has 44,000, and this is the data of 2016. And rest of the country you can see, whether it is the South America, whether it is Asia or African countries. Then suggestions. Last part is, so first of all, there should be a proper detailed guideline about benefit sharing, and most probably I think it would come once it will be implemented. Further guideline with respect to the benefit sharing will come. Then proper utilization of benefit sharing fund. Why I have kept that even in the biodiversity convention, CBD Act also, that is the Biodiversity Act, this is the main lacuna, that is utilization of the benefit sharing fund. Encourage collaborative research between different country, different companies, taking the common interest into consideration. Recognize traditional knowledge, respect traditional knowledge. Then proper monitoring and evaluation of impact assessment, that what they are doing, what will happen and all. And then facilitate capacity building measures worldwide. Those who are the member of the TT, they should come to this, that capacity building measures, and foster public awareness and engagement in exploitation of sustainable exploitation of marine genetic resources. So thank you all.
Thank you very much for this enlightening explanation of marine genetic resources, as well as the challenges that the international community faces before these benefits are realized. We have another speaker on the subject. I'll call on Bhavya to come and speak. She'll be speaking on towards a new regime for biodiversity in area beyond national jurisdiction, interaction and influence of legal regime of seabed area on BBNJ agreement.
Good morning, everyone. I'm Bhavya. I'm currently in my 5th year of law school. The title of my paper is Towards a New Regime for BBNJ, Interaction and Influence of the Legal Regime of the Seabed Area on the BBNJ Agreement. The agreement under the United Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, which is the BBNJ agreement, is the third implementing agreement under the United Nations Convention on the Law of the Sea. It's adopted in the June of 2023. The objective of the BBNJ agreement is to ensure that the conservation and the preservation, sustainable use of marine diversity in areas beyond national jurisdiction, which is the ABNJ. However, ABNJ also includes the high seas and the international seabed area. The BBNJ agreement regulates the marine diversity in the area, and the International Seabed Authority, which is the ISA, has the mandate to regulate the activities of the non-living resources in the same zone, which is the area. ISA regulates, controls and manages the seabed mining in the seabed, and also protects the marine environment from the harmful effects of the mining. Therefore, there's an existence of two different regimes, which is the ISA, the institutional framework for the seabed area, and also the institutional framework of the BBNJ agreement. And there's a regulatory overlap. Article 5 of the BBNJ agreement provides that the BBNJ institutional framework would not undermine the other existing frameworks. However, seabed mining could directly undermine the objectives of the BBNJ agreement, because BBNJ agreement talks about the conservation and the sustainable use of the resources that are available in the high seas and the area. BBNJ agreement cannot pose direct obligations on the International Seabed Authority, but the decisions about the seabed mining will have a major impact on the states' obligations to meet their obligations. States who are also party of the BBNJ agreement and the ISA have to ensure that their actions do not undo the conservation and the sustainable use of the BBNJ. And also, some states, while discussing about the BBNJ agreement, like Belgium, went as far as to say that the seabed mining shouldn't be done until the target is achieved that at least 30% of the ocean is protected, which also includes the high seas and the seabed. The IPCC reports say that the impact of climate talk about the impact of climate change on oceans and its biodiversity. The recent ICLOS judgment on climate change also interpreted the UNCLOS in a wider sense to expand the meaning of pollution to include the impacts of the climate change. The seabed mining could immensely impact the obligations and the objectives of the BBNJ agreement. We need to see, therefore, how the seabed mining would impact the marine environment in the light of the scientific knowledge and the impact on the small island states. Hence, a synergistic reading is therefore important to harmonize different aspirations under the international law, which is the International Seabed Authority and the BBNJ agreement. Thank you.
Thank you very much, Bhavya. And I think this is one of the more challenges now for the International Seabed Authority. As you all are aware, the exploitation regulations are about to be adopted. That's what we have been hearing for the last 2 years. But many states are opposing the exploitation of seabed resources. They are asking for a temporary hold or a moratorium on seabed mining unless its environmental impacts are fully known. And one now new objection is that it might, be not in conformity with the BBNJ agreement. So I think some of the states have already raised this issue. So thank you very much, Bhavya, for highlighting this issue. Now I will request Nandini Paul from University of Calcutta. She'll be speaking on law of the sea in relation to international environmental law. Sorry, Nandini, to keep you waiting, because I thought all the papers on BBNJ should be handled together so that people have an idea about this new subject. So you have the floor, ma'am.
I am Nandini Paul, and today I stand before you to discuss a matter of utmost importance: the relationship between international sea law and the environmental law. These two bodies of law, though are distinct, but are interconnected, forming a powerful framework for protection and sustainable management of our oceans. International sea law, enshrined in the United States and United Nations Conventions on the Law of Sea, UNCLOS, provides a comprehensive legal regime governing all aspects of the ocean use, including navigations, fishing, resource exploitation, and marine scientific research. It establishes a delicate balance between the rights of coastal states and the common heritage of mankind, ensuring that the oceans remain accessible for all while safeguarding their delicate ecosystems and their own diversity. Environmental law, on the other hand, focuses on the protection of environment, encompassing a wide range of issues such as pollution control, biodiversity conservation, and climate change mitigation. It recognized the value of environment and the need for its preservation for our future generations. The two bodies of law are particularly crucial in addressing the pressing environmental challenges in facing our oceans and their pollutions. Overfishing, habitat destruction, and the climate change induced ocean acidification are just a few of the threats that the health and productivity of our marine ecosystems. International sea law provides the legal foundation for addressing these challenges. UNCLOS established a framework for pollution control, including provisions on dumping, land-based resources of pollution, and marine pollution from vessels. It also mandates the conservation and management of the living resources and promoting sustainable fishing practices and the protection of marine diversity. Furthermore, UNCLOS recognizes the importance of marine scientific research and encourages the international cooperation in this field. This research is essential for understanding the impacts of human activities on the marine environment and developing effective conservation and management strategies. However, the implementation of international sea law and the environmental law presents significant challenges. Many states lack the capacity to enforce these laws effectively, and international cooperation is often hindered by the conflicting national interests. Additionally, the rapid pace of technological advancement and globalization had led to new forms of marine pollution and exploitation, which require innovative legal approaches. To address these particular challenges, it is imperative to strengthen our international cooperation system and the relations, and also capacity building efforts. States must work together to develop and implement effective monitoring and enforcement of mechanisms. Regional and global organizations such as the International Maritime Organization, known as IMO, and the International Seabed Authority, which is known as ISA, play a crucial role in coordinating the international action and setting forth the standards for marine environmental protection. Moreover, it is essential to promote public awareness and education about the importance of the ocean and the threats we face. By fostering a sense of stewardship and responsibility, we can inspire individuals and communities to take actions to protect our marine environment. In conclusion, the integration of international sea law and environmental law is essential for the sustainable management and protection of our oceans. By working together, we can ensure the future generation will inherit a healthy and vibrant marine ecosystem. Let us now commit ourselves to upholding the principles of international law and environmental protection, and let us strive to create a future where the oceans may thrive healthily and vibrantly. Thank you, everyone.
Thank you very much for your presentation. I think we are now at the end of our presentations. I'll now open the floor for questions, if there are any. Please.
I can ask about the, you were on here. Well, I will come this side and take the microphone. Yes, my question is for Ms. Tanya. With your criticisms of the EIA part of the BBNJ, specifically the cumulative effects of climate change, the role of capacity building and technical assistance under Articles 202 and 203 of UNCLOS, and the transboundary effects. I was wondering your thoughts on how much the advisory opinion on climate change from ITLOS filled in those gaps, or is more necessary? What is the interaction between those two?
Thank you so much for your question. So my opinion was that the cumulative effect should be addressed more, and we are still lacking behind the analyzing the what will like the climate change impact is to be more analyzed, and there needs to be more discussion that how the climate change impact will be done on the environmental impact assessment, and what are the specific guidelines that we should consider that should be highlighted. And I think that those will be clear when the treaty enters into the implementation phase, and the issues when they arise, then the we'll get more clarity on this issue, because the treaty hasn't touched about the climate, specifically about the climate change impact, and this is the rising issue. So I think this answers.
Thank you very much, Tanya. I think what she also wants to add is that because the template has to be provided or for a particular activity, so that is still, I think, in the preparatory, not even at this moment as regards BBNJ, not even in the preparatory phase. So once the template is there, so then only the states would know that what kind of impact assessment they have to carry out. So the legal framework as well as the templates for particular obligations have to be there for the international community to expect states to follow those guidelines or those parameters. So the templates are still to be developed as far as BBNJ is concerned, though there are templates for seabed mining, but the states are saying they're not enough. So I think I hope that answers your question. Any other question, please? One at the back, then I'll take you. Can you please take the microphone in the back?
Curtis Dobler, research professor of law from the University of McKinney. Thank you all to all the presentations. I found this a very interesting panel. I'd like to ask Judge Chadha, if I may, what, in your view, is the expectation of the impact of the advisory opinion on climate change on the advisory opinion that the International Court of Justice will give? Do you have any expectations? And just, I know in your personal capacity, would you have any expectations on how that should influence, or how the judges would like it to influence the International Court of Justice decision? Thank you.
I think that's not a very politically correct question. But, in the larger framework, to prevent fragmentation, we expect that there will not be too much fragmentation of international law. So I can only say that. Thank you.
Hello. Hi, sir. My name is Ridhima Kaul, and I'm currently an independent maritime consultant. So my question was to Amrinder, sir. It was just a general understanding of how a country is harnessing these marine genetic resources. Are they environmentally sustainable practices? What are the current scientific resources or the machines that we are using? Has anyone dwelled into it? And aren't countries concerned more about harnessing them, because we are talking about seabed mining? But this is also a concern that, what is it that's happening? And I think ecocide is also now coming up, that saying that, we are supposed to kind of make it make environmental pollution. Now it should be like criminalized. So what do you think about it? I just wanted you.
In my understanding, first of all, there was a debate under the CVD prior to BBNJ itself, okay, that about the protection of these resources. But we have seen the area of high sea, that was the conflicting area. Anyway, these resources are available to the multinational companies, because being under the high sea, no regulation was there. So there is the number of, I have given the data that they have already taken patent. Okay, more than 13,000 patent has been already awarded out of, even in DSI and all. With respect to the sustainable use and all, unless and until we are not going to develop proper stringent legal framework, international legal framework, till then I think this is going to continue. Even after the BBNJ, we cannot guarantee that things are going to reflect as it is discussed under the BBNJ. So how it will come in future, only the time will tell. Even after the creation of CBD, take the example, okay, biopiracy is still prevalent. In same way, it may happen in future with respect to the marine genetic resources also. So taking the experience from CBD, I think that all those measures should be made at the beginning, just after implementation, because there are so many things, including what ma'am said also about those draft. So there are requirement of so many things after the implementation of BBJ it will come. Prior to that, we can only assess the things.
Thank you. Any more questions?
Well, thank you for giving me this opportunity. Firstly, I would like to thank the chair and all the panelists for their presentations and their remarks. On the very first presentation by Mr. Sunil Agarwal on subsea telecom cables, well, the importance of the subsea telecom cables cannot be overemphasized. As you all know, we depend so much on the telecommunications for the internet services, which provide a wide range of services to us, both commercial, shopping, personal contacts, information, research, and any disruption in the cables means a significant loss to the economy and to general users in general. Now, the importance of the submarine cables and the freedom of laying submarine cables has been recognized without controversy since 1884. And in fact, the language of this convention has been followed in subsequent conventions, including in the 1982 UN Convention. The most important aspect, however, is the maintenance and repairs. Deliberate damage to submarine cables, of course, is required to be made punishable as an offense. But most cases of damage are not intentional. They can happen by ships dragging anchors, by fishing vessels, the nets get entangled in the cables, even by sharks biting into the cables, and even the movement of the wave action can move the subsoil and cause damage to the cables. But then the need is the urgent repairs to restore what is now recognized by everyone as a vital infrastructure, because communications is vital in this globalized world. And here, the cable companies face problems, especially in India, in getting the necessary approvals to undertake repairs. So I would ask Mr. Agarwal, what steps are being taken to ensure that cables are restored at the earliest? Because these are vital not only for the companies themselves who own those cables, because it's a big source of income for them, but those cables are vital for the population in general. Now, under Indian law, of course, the submarine cables are treated together with all other cable telecom networks, whether it is satellite-based or terrestrial or submarine. They're all taken together as telecom networks, and the same rules apply. So the deliberate damage is punishable under Indian law, but of course, as I said, in most cases damage is not deliberate. So now coming to the other presentations regarding overfishing in the oceans. Overfishing has been a major concern for several decades. started with the cod wars, the fish in the North Sea in the 70s. And for nearly half a century, the FAO has been highlighting this issue of overfishing in most of the world's fisheries. Now we have another difficulty with fishing. Fishing is a very important source of food all around the world, especially for communities who live near the oceans. And increasingly, this source of food is in danger from marine pollution, especially the dumping of plastics in the oceans. According to one study, there are plastic patches in all the major oceans. The largest patch being in the Pacific Ocean, which is said to cover an area of about 1.6 million square kilometers. And to put this in perspective, this would be about 3 times the area of France. And it is greater than the area of India's 4 largest states taken together. That is Uttar Pradesh, Rajasthan, Madhya Pradesh, and Maharashtra. If you add up the total area of these 4 states, this plastic patch is bigger than that. Of course, there are those who are in denial. Some scientists even go to the extent of saying, we went to look for the Pacific patch but didn't find it. So how long can we be in denial? Because the plastic, it does not degrade, but it breaks up. And it breaks up into smaller and smaller particles. And in one study where samples of water were taken from the east coast of Africa up to the Maldives, every sample was found to have dissolved plastic, microscopic plastic in it. And this microscopic plastic is entering the food chain, and we are consuming plastic. So this is a matter of great concern. Now the effects of deep sea mining in relation to BBNJ. Deep sea mining is something which the world has been looking forward to ever since the issue of the presence of manganese nodules at that time was called. Later they're called the polymetallic nodules. When this issue was first raised in the UN General Assembly by Ambassador Pardo, the developing countries of the world have been expecting to participate in the benefits of the seabed mining, in particular because that was also a time when there were shortages expected of various minerals which are available in the sea, and prices had gone up. But till today, seabed mining is not yet a reality because states have not invested in the necessary technologies, and besides, it has not been found to be economically viable because the minerals which we were expecting to get from the sea, more resources have been found on land. But of course, the question of conducting seabed mining with the minimum damage to the environment has been engaging the attention of the International Seabed Authority. They have been working on the mining code. And now how this will work together with the BBNJ convention is something which we will have to see in the days to come. And just one small issue for the chair. This has already been raised in another question. The President of the International Court of Justice, while addressing the UN General Assembly, had raised the issue of the fragmentation or the proliferation of international courts and tribunals. His concern was that all international courts and tribunals are independent, and all of them, all their decisions and awards are final and binding. And his concern was that if there are judgments which are in conflict or which are at variance with one another, then how do we handle that situation? I am aware that there's a dialogue between the courts and tribunals, but we would like to hear more from you, from Dr. Neeru Chadha.
Thank you. I think fragmentation has been a concern. I'm taking the last question first, if you don't mind. But I think till now, it has not really materialized. And under the convention itself, the cases are binding on the as between the parties only. So, in strictly legal sense, even if fragmentation happens, that should not be a matter of great concern for the international community, because the judgments are binding as to particular parties only. But as we all know, that these judgments don't operate in isolation, and they do have a precedentary value, and they are used as precedents. But we hope that each case is unique in itself, and the courts, to the best of their capacities, give a decision or a advisory opinion on a subject. And advisory opinions, I had a question earlier on what were we expecting from ICJ. Advisory opinions by their nature are not binding. But in our case with Mauritius, in Mauritius versus Maldives, the tribunal has held that though they may not be legally binding, but the principles have a legal value, So while using the ICJ judgment in the Chagos advisory opinion, the tribunal did accord a legal value to the opinion of the ICJ. So I think we'll see as we go along. Till now, there have not been major cases of fragmentation of law so as to affect the parties. And I hope in future also, the courts will interpret the law according to the best of their capacities, and perhaps new issues arise, and perhaps different opinions will be given on different issues. But each case is different, so perhaps the courts and the tribunals will take care to distinguish if any established legal principle is being deviated from. So I think that's our expectation. Thank you. And you'll talk about submarine? Okay. And I think most of the comments on plastics and seabed mining, I thank you very much for your comments. As such, we all are aware of the challenges for seabed mining, and particularly the challenges which now the International Seabed Authority is facing, because on the one hand, the states are enthusiastic that with the adoption of the exploitation regulations, perhaps seabed mining would be a reality. And on the other hand, other states have a concern regarding its effect on marine environment, and they are asking for a moratorium or a pause. So let's see how the states parties decide in the coming days, whether there is going to be seabed mining, and there is an application by Nauru also. They have, initiated the mechanisms under the convention. And if they submit a plan of work, how the International Seabed Authority goes around handling that issue. So these are interesting times for Seabed Authority. And I'll give the floor to Mr. Agrawal now.
Thank you, madam. Yes, this question regarding the repair and the maintenance, very critical, but I think that we have moved little bit more away from those issues now. It was an issue during 2010s. I remember going through files, there were pressures from American companies regarding the delays in getting the approval from the DOT. Primarily the DOT regime which governs the regulations, especially in the territorial sea as well as the EEZ. All right. But as we know, how the system functions in India, it is not the DOT which is involved directly only. It is the MOD also which has an important role because of the security issues. Whether this is a kind of an internal process. All right. So that was the primary reason that wherever there was some sort of request for approval for repair, etc. And as you know, this undersea cable repair has to be done in a timely manner. So there it got delayed by 15, 20 days, etc. So there was a request from the American companies mostly to kind of create a timely, time-bound kind of a framework, and I think still we have not achieved much on this issue. Still, it is because of the security reason. MOD continues to do kind of a veto, etc. I would say, but as I had mentioned in my presentation, sir, the Quad countries, it is because of the geopolitical environment now, at the present context we are talking about, this is no longer the kind of accidental damage which is of concern. The more so, it's now the things have changed to the kind of intentional damage, which is because of the adversaries and both the state as well as the non-state actors. And we have seen recently in the issue in Ukraine crisis also, during, as I mentioned, in the Finland, that issue also, and increasingly the Indo-Pacific because of the rise in China, etc. This is an important issue of the geopolitical kind of a dimension of undersea cable protection. In that context only, the US has proposed this New York principles, which has been fiercely opposed by China. In fact, they made a statement, therefore, I think Foreign Office made a statement specifically saying that Americans are trying to politicize all these issues, and which is not in accordance with the international law as reflected in the UNCLOS. So I think certainly repair, maintenance are the issues, but now we have moved to the other issues like geopolitical dimension. That is also increasingly being, has assumed very important role in kind of evolving nature of this undersea cable governance. And sooner, I think, we will be seeing another kind of a sui generis regime, something like BBNJ. I remember, madam, this BBNJ was an issue in 2010s in the beginning, and it took almost 20 years to get it adopted. Now it is in the process of implementation, subject to the ratification. So international lawmaking, as we know, it's a long time taking process. And now I think there's a lot of emphasis by Americans, especially, to go for some sort of regime, because there are gaps between these UNCLOS and the Paris Convention, and they want to address these issues in terms of negotiating a multilateral kind of a framework for protection of undersea cables. I think, yeah. Thank you very much.
Thank you very much. I don't see any other hands for questions, so the task for me is to thank all the panelists for their very informative presentations, and I thank the audience also for the questions. And finally, thank you at ISS for arranging this panel on a very important subject. Thank you.
I now request Ambassador Narendra Singh, Secretary General of ISL, to facilitate the chairperson of the session, Dr. Neeru Chheda, ma'am.
Yes, sir. Yes, sir, ma'am. Wait. Wait, sir. Take off. Thank you, sir. Thank you. There was more long to see than you. Thank you.
I now request all the panelists to please occupy the stage. Good morning, everyone. This is the second session of the day. The session is on international refugee law. The chairperson for this session is Ms. Margriet Venema. Ms. Margriet Venema studied social anthropology at the University of Leiden in the Netherlands and has worked abroad ever since she graduated. Since 2002, she works for UNHCR and has served in many different operations. In the Democratic Republic of Congo, she worked with refugees from Central African Republic. In Guinea, she worked in refugee camps at the border with Sierra Leone, and in Pakistan, she traveled frequently to the border areas where Afghan families had settled. During her time in Sudan, she was involved in programs supporting internally displaced persons and Darfur and Eritrean region refugees in the east of the country. Her post in Egypt had a regional coverage and required travels to Yemen, Iraq, Jordan, Lebanon, and other countries in the region. She was based in UNHCR's headquarters in Geneva as the senior advisor on sexual and gender-based violence. And before her appointment as Deputy Chief of Mission for UNCHR in India in July 2023, she was the Senior Protection Officer in China. We also have Ragini Jutshi ma'am. She is a lawyer by profession who has been working on refugee issues for over 2 decades. She started her career as a litigating lawyer and then moved on to work for refugees. She has also co-edited a book on refugees and the law in India. I now request the chairperson of the session to take over the session.
Good morning. I'm very happy to be here today, and I'm looking forward to the presentations of the different panel members, but also to the questions and discussions that will follow it. So what we'll do is we will start with the presentation of Ragini, who will present on operationalizing international refugee law in a national context. And that will be followed by an online presentation by one of our colleagues based in Bangkok, Jesper Widdel. Who's not online yet, he will come soon. And he will talk about protection at sea. This session, then after those 2 sessions, I propose we have a moment to ask some questions because it's very much related to international law, international refugee law. And then we move on to the next presentations, of which will be first Dr. Bala Jinaika of the Faculty of Law. And this will be out the principles of non-refoulement and the rights of refugees in international law. And then we will have, I see I only have 2 panel members actually, next to me. And then we have Snehale Fatnavis, who I just met, who does a session on human rights implication of climate migration, a global response towards a comprehensive solution for the protection of migrants. And then normally we would have the last one, Rajshri Singh, on climate, refugees, and legal paradoxes. So then we have 2 sessions on climate, linked to climate and displacement. So we have separate questions on that. Please go ahead, Ragini.
Thank you very much. A very good morning to everybody. It's a pleasure, as always, to come and attend or speak in any of the conferences organized by ISIL. We go a long way together with ISIL. Some of the faces are very familiar. And from UNHCR perspective, we know there are already a lot of experts, but it's just to remind a little bit to each one of us, in the context of India, that what the broader international refugee law is, and how we could operationalize that in the context of India, because often we come across the narrative that, oh, we have not signed the 51 convention, or we don't have a law, so it seems that probably there is nothing, but actually there's not, it's not like that we have a vacuum or there is nothing. What we want to say, and together with the people sitting here, is to come up with, maybe there isn't enough, but there are certain things that we can look at which helps us operationalize the international law. But before we go into the more an Indian context, just a broad overview of what UNHCR is, what we do, what is the broader international framework, to set a little bit of context. As I'm sure most of you would be aware that as the UNHCR was created in 1950 by the UN General Assembly. We are an intergovernment organization, and why the governments at that point of time would have thought that there is a necessity of having a specialized agency to deal with displacement, which it was because also of primarily the displacement created by World War II. And the initial idea was to create us for 3 years to deal with refugee situation in Europe. But unfortunately, we are living in 2024. And the reality is that world is not really a better place. Actually, the forced displacement we have has reached unprecedented levels. And over the years, the UN General Assembly realized that the temporal limitations, the geographical limitations that UNHCR was set up actually does not work. And we have a broader mandate of working on refugee issues. We also work with other people. We work with asylum seekers, stateless persons, IDPs. Even though the mandate may be a little bit different, for refugees, we have a mandate to work on the humanitarian issue caused by conflict. While for stateless persons, who are people who are not recognized as citizens by any country, we also have a mandate to work on prevention, which is unlike our mandate, the refugee mandate, where we don't work on the issue of prevention. We respond to a refugee crisis. Similarly, IDP situation, it depends if we are invited by the government or we have a specific request to work. We work in many countries on IDP issues. So UNHCR and we are currently working in almost 136 countries or territories with over 20,000 staff. And because of the nature of our work, which has been humanitarian, non-political, impartial, independent, we have also been given Nobel Peace Prize twice for our work. And these are just a bit of the statute and the 51. What exactly is the mandate is that we work with the governments. It's to support the governments and fill in the gaps. And it is very important to talk about it, because sometimes there is also a narrative that if the 51 convention is not signed, does the state have any responsibility? But the fact that states together and collectively have given us a mandate, and our mandate is not questionable, nobody questions the mandate, which the states have provided to us in our 1950 statute. So in a way, signing also independent of other international law or customary law norms, the fact that the world created UNHCR, the governments created, they signed on the statute, gave us a mandate, also is a fact which is very important to keep in consideration when there's sometimes an argument made by certain states or entities that 1955 signature convention has not been signed. So there is the statute which is binding for everybody and which created us. And normally what do we do as UNHCR? Because it's also linked to the rights that refugees have, which have then also to be operationalized and implemented in a domestic setting. So we work with displaced people, and the first thing we work together with the governments is to ensure everybody, those who want to seek asylum, have a right to ensure they are able to seek asylum. Also, they have access to basic rights, whether they are their socio-economic rights, other rights, basic access to basic assistance. They are able to live in safety, security, and with dignity. And then it's linked to these facilitating access to rights. We may do things together with governments, or sometimes we may have certain aspects of the work that we do ourselves, which could be, for example, registration, RSD. In an ideal situation, the governments have the responsibility to do it, but sometimes we do it together with the governments, or we may have our own systems, while a national framework for registration and RSD, or a national framework for asylum is established. Advocacy is key to our work, because across sector, whatever we do, we advocate with relevant stakeholders to do advocacy. And certain things we have also seen globally, maybe sometimes out of ignorance, or maybe there is also a little bit of by default or by deliberately sometimes, the two concepts of who a refugee is or who a migrant is also conflated, because often refugees may be described as migrants, or migrants may be called refugees. IDPs are called refugees are called IDPs are called migrants. It could also be sometimes because people are genuinely not aware about the difference between these different groups of people. But often, sometimes there's also possibilities the legal concepts are mixed up, because being a refugee also means there are specific rights guaranteed under international law, which may be different compared to others. Similarly, IDPs have different rights as citizens of those countries, which are going to be different from refugees who are foreigners. So as part of our work, it's also very, very important, including anybody who's a student of international law, to also clarify and clarity that these are different distinct categories of people who have distinct needs, distinct rights, and obviously as duty bearers, all of us are also responsible to ensure that we those duties that we have are also met, so that the people who have these rights are able to access those rights in the manner. So the international refugee definition, which is the key definition that UNHCR advocates, that states, this is the bare minimum that the states consider, is provided in Article 1A of the 1951 Convention, which looks primarily at 5 elements. The first is that a refugee is only a person who is outside his country of origin or habitual residence. And why outside? Because they have a well-founded fear of persecution, again on because of 5 grounds, which are race, religion, nationality, membership of a particular social group, or political opinion. And most importantly, the state is unable or unwilling to protect that person. And this is the key definition, which is the foundation of refugee law or refugee protection. In many situations, for example, sometimes in Latin American region, or maybe in Africa, certain countries may decide to expand on this definition. In the Indian context, we may feel we don't have a refugee definition in law, which is reality. The foreigners are governed by Foreigners Act or other immigration-related laws, which are primarily the Passport Act, the Passport Rules, Foreigners Act, Foreigners Rule. And the law does not define refugees or does not distinguish between a foreigner or a refugee. But we also have seen that we have traditionally been hosting refugees. We may have had state practices. We may have also have certain sometimes policies even though for particular refugee groups. But interestingly, we do have a visa regime, which there's also a document available on MHA website, where the state has created a policy where if the state wishes, they can provide stay visa to those who claim to be refugees, and the FRROs, who are the immigration officers, use the same definition. This is the definition given in the visa policy for grant of stay visa for those who claim to be refugees. And interestingly, there is a 6th ground in the definition that we as India have used, and we have added sex. Even though as UNHCR or globally, it is now well settled that sex is part of a particular membership of a particular social group, even though it may not be articulated in the definition. But the definition that we as India, we have operationalized the international definition of refugee in this visa document is also by adding one more, clearly another ground. So we don't have only 5 grounds in that definition, we have 6 grounds. And this is also way when you look at international standards and then use it domestically. So in the interest of time, I'm not getting into details of who an IDP is or who a stateless person is, but this is just to give an idea that as UNASIA, we do also work on with in many countries with IDPs, not necessarily in India. Again, how their protection can be operationalized is very clear, because IDPs are citizens of any country. They have all the rights that any citizen may have. Stateless persons, we also, as I mentioned earlier, as UNHCR, we also have a mandate to work on prevention of creation of statelessness, also on resolution of situations. And primarily, this work is very interlinked and together with the governments, because there are often reasons which could be laws or policies which may create statelessness, and that is to work on those citizenship related issues to ensure those laws and policies are corrected in a way or amended to reduce statelessness or to resolve wherever these issues are. And as I also mentioned, that it is very important to have these discussions and continue to working on not only looking at what the international law is, what the customary international law is, but also looking at how to operationalize it at a domestic level in every state, because looking at the trends of what's happening in the world, where there are more and more conflicts arising, more and more displacement being created, not only within states, but outside, refugee flows with more than 122 million people being displaced globally. It's very timely to even have these kind of discussions in this context, to see what can we do in our context, what can we do in our situation to ensure that if we have any forced displacement, if we have refugee situation, how can they be better protected or better So in that context, when we talk about refugee protection, obviously it's in the context of access to rights. And the broader framework that we look at is international law, international customary law, treaties, conventions, state policies, practices, and then also in the domestic situation, how do we operationalize it? So I think the time is running, so I'll just go fast. From a broader international perspective, we have the UDHR Article 14, which talks about everybody's right to seek asylum, but we also see at other conventions like the ICCPR, Article 9, 12, 14, 13, because these are all linked to rights given in the 1951 convention, which talks about the right to freedom of religion, right to access to courts, right to not to be expelled, not to be sent back, which is the cornerstone of refugee protection, principle of non-refoulement. We also have a speaker who's going to talk about non-refoulement specifically later. But what is very important to also keep in mind that non-refoulement is not only about land borders. It is also about sea. Because now in the changing world, we are also seeing a lot of movement by sea, and my colleague Jesper is going to talk about.
This sound is quite. But I can see that there's not too many participants, and we're also missing one panel member. So if it's okay with the organization, I let Ragini finish her presentation for another maybe 5 minutes to avoid that we keep on having the beep in our ear. And is that all right with you? And then we move to Jesper. Please go ahead, Ragini.
Yeah, thank you. So he's also going to talk about the protection at sea in the context of refugee movements, non-refoulement. So I'm not going to talk a lot about it. But how do we actually operationalize it in the domestic legal regime? That is the main topic. In India, since we are in India, Article 21, which is the right to life, we all know how Article 21 has been expanded by the Constitution. So a lot of rights the language is very clear. The word used in Article 21 is not citizen, it's person. And it's now well settled principle in law that Article 21 applies to everybody, which means applies to refugees. And how has Article 21 been interpreted over the years? Article 21 is right to life, right to dignity, right to access to food, right to access to health, basic services. So in a way, it's the umbrella, Article 21, which is used to operationalize a lot of rights that refugees have. And we do have a plethora of judicial precedents where Article 21 has actually been used to support and protect refugees in India, including the principle of non-refoulement. So that's been a key. And what also a lot of advocates or people who speak about refugee laws, they use Article 51 in the arguments. Also Vishakha judgment, because Vishakha judgment may have come in the context of a gap in the law in the context of sexual harassment. But the main ratio is when you have a gap in law, you look at, especially when it is in the context of human rights, what do? You look at international conventions, you look at norms. And we do have international norms, we have international law, we have customary international law, especially in the context of non-refoulement. And we have the Vishakha judgment, which clearly says, and there is definitely a gap in domestic law when it comes to refugee law, but there's still enough precedents and Article 21 to help us. And also using all these arguments, the Indian courts have created the jurisprudence where a lot of rights of refugees have been upheld, whether it's been right to refoulement, right to access to services, basic amenities, right to bail, leave, voluntary repatriation. But nonetheless, it's not that everything is perfect, because definitely due to the gap in law, you sometimes do get adverse judgments, because ultimately these are court precedents. Sometimes the courts may follow, sometimes they may not. So in an ideal situation, to operationalize anything, you need a very clear domestic legislation. But if you don't have a domestic legislation, probably a clear-cut, consistent refugee policy, which also we do not have. We may have a Tibetan policy, we may have state practice. Again, state practice has been sometimes different for different groups. The state practice for Tibetans may have been different compared to those for refugees. But this is collectively that we have used, not only as UNHCR, but everybody who's a refugee advocate, refugee protection advocate. There's also a compilation of judicial precedent. I am sure some of you may have got. If not, we can also circulate it. ISIL can circulate it, the soft copy. And that's just a bit of a gist on how those advocating for refugee laws have used precedents, Article 21, and also other laws. For example, for right to education, the Right to Education Act, because it applies to children. Similarly, refugees are human beings. They are men, women, elderly, persons with disabilities, children, and they're all policies, there are laws, there are things that are there for those groups of people, which is also being used to operationalize international refugee law. And thank you, and sorry for eating a little bit of time.
Thank you so much, Ragini. Thank you very much. There was a very comprehensive overview of international law linked to domestic, how do you operationalize that in a domestic setting? So thank you for that. And now we're going online to our colleague, but I'm not managing any of this. So I hope...
I'll manage his PPT.
Yeah, you manage PPT, but is he online? Jesper?
Yeah.
Yes.
Hi, Jesper. Can we see your face as well? Or is it not possible? Let me introduce you in the meantime, Jesper. Yes, here you are. Hi. So Jesper Whittle, he works for us in the bureau in Bangkok. He's calling in from Bangkok. And he's covering this region. And he really focuses on route-based approaches, onward movements, human trafficking. He does it now in this region, but he has experience in different regions, be it in the Middle East, North Africa, but also in East Africa and in the Americas. And prior to UNHCR, he worked actually for the Swedish Migration Agency and also for the Foreign Service. So yes, I will give the floor to you, Jesper, and then after your presentation, then we will open the floor for some questions linked to yours and Ragini's presentation. It's about protection at sea in the refugee context. Please go ahead. And Ragini will manage your PowerPoint, so let us know, give us a sign when it needs to move on.
Perfect. Thank you so much, and hello everyone. Thank you for inviting But also, I would say I'm not really an expert as such on maritime laws, but rather a protection generalist. I've been working some 10 years on these issues. So I will try to maybe building on a little bit what Ramin was talking about, the kind of intersection with international refugee law as it relates to other human rights bodies and laws, and also the kind of intersection of these, especially then the laws of the sea and how it relates to international refugee law. But I will start with a little bit of overview, that is a regional overview of how we see these protection at sea and the onward movements of refugees, mainly here in this region, but also of migrants. So as you can see, this is focusing on the movements that is going from the Andaman Sea, the Bay of Bengal. I'm sure you might have read about it in the news and in other contexts. So there's both land and sea movements. Very often these movements combine to quite complex subroutes in the region. Most boats depart from Myanmar and from Bangladesh, Assar, where we have a significant number of Rohingya refugees that fled from Myanmar. If you look at the last 13 years, there's almost 200,000 people that have embarked on these dangerous maritime movements. And we have seen, if you look back at the Andaman Sea crisis in 2015, that was one significant peak. And now we are seeing another peak, going back to the last 3 years. Next slide, please. So here are just some figures. I will not dwell too long on these figures. But if you look at this graph here, there is a significant peak happening now, which is a little bit off the kind of usual trends that we see. And the reason for this is because there's a lot of people fleeing from Myanmar, crossing the Naf River into Bangladesh. So this is kind of making the figures go up quite significantly for this year. Just looking at the last years from 2021, we have a 795% increase in these maritime movements of mainly Rohingya refugees trying to find effective protection within the region. And we also see a lot of people gone missing or confirmed to be dead through shipwrecks, etc. And this we expect to be even higher this year. We are now in the so-called sailing season, which means that the monsoons have kind of calmed down a little bit, and it's more the seafaring conditions are possible. And it's usually on these longer movements that is happening all the way towards Indonesia and Malaysia that we see these accidents happen. Next slide, please. I think it's also important to mention a little bit about why these people are fleeing. It's quite complex factors that interplay with each other, but overall, we see insecurity, of course, in Myanmar. The situation there has deteriorated significantly, not least the last years, since the coup in 2021. But also in Bangladesh, people have very difficulty living a meaningful life, having livelihoods, education, etc. So they tend to embark on these very dangerous journeys along the seas. From a protection perspective, there is significant concerns what the people on the move over the seas and land face during these journeys. We have gender-based persecution, violence, enslavement. The situation for Rohingyas or irregular migrants in general might be the default responses of detention, indefinite detention, with very limited ability for due process of the law, deprivation of food and water, especially on the boats, theft, fraud, extortion is common, trafficking, we have medical issues. Next slide, please. So just to give one example here of all the different protection issues that people face on the sea. When it comes to detention, we have more or less 6,000 people in total that are in detention currently, in a very difficult situation where they don't have access to the process of the law, but also where they are not even sometimes considered as victims of trafficking. So they are just put in detention and stay there until some kind of solution is found. Yeah, this is quite obvious kind of slide, but just to highlight it, because this is what it's all about in the end, responsibility of states who do have a primary responsibility to ensure the enjoyment of the rights of all individuals. This also includes, of course, refugees who are moving when they are within their jurisdiction. Next one. I will just list here, I mean, goes along the same kind of lines that Rahimi spoke to, but just so to make sure that even though we might not, there are some states that have not signed the Refugee Convention, human rights law works in a complementary manner, reinforcing one another. So there is significant kind of space and legal obligations that do apply to refugees in this situation. And of course, I will go soon into a bit more what applies specifically for protection at sea. But we have the International Refugee Law, that is the Convention and the Protocol, and the African Union Convention, the Cartagena Declaration, which is not itself legally binding, but still very much incorporated into national laws in the Americas region, and then the General Assembly resolutions, etc. Rohini already mentioned the international human rights laws, which is very important, and that we need to ensure that states adhere to those as well. Next one, please. And then the laws of the sea. We have many states, even though they haven't signed the Refugee Convention, they have signed many instruments related to the laws of the sea, like UNCLOS, SULAS, and the search and rescue coordination that binds them to certain obligations as it relates to sea movements and engaging in search and rescue, for example. Also important to highlight that this is not only a responsibility for states, but rather all shipmasters have also obligation to rescue individuals that are confirmed to be in distress at sea, regardless of their nationality or status. So in this case, it's a clear case where if they are confirmed to be refugees, for example, Rohingya refugees who are moving onwards from Bangladesh, they do have a clear obligation to intervene if they have information indicating that the boat is in distress, for example. And they should be disembarked to a place of safety, and I will go into a little bit more later what that means. International labor law should also apply to refugees. Next one, please. International humanitarian law in cases of armed conflict. I put here a question, civil, humanitarian, military coordination at sea, because this tend to happen quite often. I mean, we do have a lot of frameworks and collaboration with, as Unitarians, with the military when it comes to land. For example, I was working in South Sudan and was supported by the Indian armed forces there who were deployed to the UNMISS mission there to provide escort, etc., and safety to humanitarians. But when it comes to doing this at the sea, there's quite a big gap. If there should be a kind of factor X happening, a major conflict where people have to flee by boats, how do we do that? What would be the kind of approaches to protect people fleeing by boats in large scales? So that's also something that would apply to humanitarian law. Would definitely be one aspect to look into when it comes to those situations, even if it's happening at sea. International criminal law, as you know, when it comes to smuggling and trafficking in persons, unfortunately, when people who might be victims of trafficking, for example, again, the example of Rohingya refugees, are very often not seen, do not have the possibility to get the needed protection as victims of trafficking. Instead, they're perceived as, in some states, even as a security threat, and their default response is detention. But this is also something that applies to people arriving by boats. Protection at sea. So now we'll go a little bit into the details, how we see...
Jesper, just to interrupt. Sorry, just to interrupt because probably you don't hear. We hear a beep here that your time is up. But please go ahead, take a few more minutes to finalize your presentation.
Yeah, thanks. From UNISHA's side, we look at protection at sea with a slightly different kind of approach than for the loss of the sea. For our priority is always to, from a humanitarian perspective, to limit loss of lives, basically saving lives at sea. And then the second point relates to what happens afterwards, in a sense, upon disembarkation, to ensure that protection-sensitive response or protection-sensitive systems are in place to receive refugees and also migrants. Protection at sea can be divided into these other kind of subjects: interception, place of safety, rescue at sea. So those are kind of what constitutes what we would see as key areas of protection at sea. Here, I just want to highlight that this goes back into even ancient seafaring traditions, and modern international law requires that all people in distress should be rescued. And this should also be extended to those who are maybe not yet in distress, but will likely become so if help is not provided to them in the short term. So this is a key kind of point that needs to be adhered to. Distress here also applies to both people and to boats. It should be interpreted quite broadly in the sense that, for example, a boat that is unseaworthy, uncrewed, or poorly equipped, overcrowded, or people who lack food and water, that we often see in the case of these refugees moving on in the region. Next one. When it comes to place of safety, this goes back to the cornerstone of international refugee law, which is the principle of non-refoulement, a place where the survivor's safety is no longer threatened. So This is what we always insist on as UNHCR, a principle that must be respected, and it of course also applies to when people are moving by sea. Safety meaning here there's no threat to life, they should be provided with food, shelter, and healthcare in place of safety, and there should be no risk of refoulement again or other types of serious harm. A ship is not a place of safety, it can be a temporary place of safety until you reach a permanent place of safety in land. Next one. Interception, this is something that we see. Interception is in itself not a legal term, but we also have what we call these pushbacks at sea, which is basically the interception or return of refugees from international waters or the high seas to ports of origin. As such, could be a violation of the principle of non-refoulement in the case of refugees moving. So what happens when you do pushbacks is you effectively place refugees in a situation of orbit at sea, and we do consider this to be inconsistent with the principle of non-refoulement and the provisions of the SAR Convention, for example. Next one. Rescue at sea. This is basically where the rescue operation terminates. Again, once disembarked, you need to make sure that those disembarked don't risk any type of persecution, torture, ill treatment, or refoulement. And the state here, in this case, have a very clear responsibility to inquire independently on the protection needs of those on board, whether or not those passengers have articulated such an assignment, for example. So states do have this responsibility, regardless if they have signed a convention or not, because it goes into the principle of non-refoulement again. I will just mention this, not going to, because I know time is very short, I'm sorry about that. So, UNCLOS, that's a key cornerstone of the laws of the sea, and the states, regardless of the status of people who are on board, have to follow these UNCLOS provisions. Next one. And then the same here in the SOAS Convention and in the SAR Convention, there is specific provisions here that is calls directly to the need to intervene for the rescue of people at sea, again, regardless of the nationality or status that they may have, and to deliver them to a place of safety. So when we talk about operationalizing certain laws that should also be applied to refugees, as Rodin mentioned, in the end, these are human beings, and as such, they do have these rights. Just very briefly on the last point that I mentioned on protection at sea, which is relating to protection-sensitive responses. There's a range of different activities to do here. Just want to highlight, for example, this screening and referral toolkit that is part of what we're doing with the Bali process and the regional support office of the Bali process to develop practical tools that can assist entry officials to identify and refer asylum seekers, but also, of course, victims of trafficking and other person-specific needs to the responsible authorities. I won't go into all the other elements of protection-sensitive systems. That is not only upon disembarkation, but also actions that we take before and after a specific protection at sea intervention. Next one.
Sorry, Jesper, just to interfere because we have more speakers to come and questions to come. So can you wrap up? Is that okay?
Yes, 30 seconds and then I can wrap up. Thank you. So just to zoom out a little bit and to see this, talk a little bit about how we see from the regional office as a more broader strategic direction and also globally. We have 5 main routes where migrants and refugees are moving. It's a key priority for us to ensure protection of those people moving along these routes. What we need is what we call a route-based approach or panoramic approach to mixed movements and movements. Basically, it recognizes that it's not only we can't work in isolation, we have to look at the countries of origin, countries of transit, the countries of destination, but also to work along these specific pillars that you see listed here and see how they can work together along the whole route, as well as specific enablers and cross-cutting elements that are listed here. Just for your reflection and look forward to the questions. Many thanks.
Thank you so much, Jesper, for this very comprehensive overview of what it means and what it entails to have protection at sea. I open the floor now for questions for Ragini. Jesper, please go ahead. Yes, go ahead. I don't know how the microphones are organized by the organizers.
Actually, I raised this question in the previous panel.
I won't hear you. I'm so sorry. And Jesper will not hear it either.
Hi, I'm Shrita from the University of Adelaide and I'm from India. I raised this question in the previous panel, but I think it's more apt for this panel. Do you think it's time for India to legalize the Sri Lankan refugees? Because when we go to places like Australia and America, we are treated so humanely. So I think should we also, under the non-refoulement principle or any of the principles under the convention, should we think of granting them citizenship status?
Thank you for the question. Let's take 3 questions, if any, and then we do together. No further questions?
Hello, this is Karishma. My question is to Ragini. So, as the presentation specifically also highlighted on the soft law aspects, I was wondering around how do UNHCR accommodate the GCR in its working aspects?
Can you put your microphone in front of your...
Am I not audible?
Now you're audible.
Okay. So should I repeat my question?
Yes.
Okay. So my question was, how do UNHCR try to accommodate the GCR in its workings for the promotion of refugees? Thank you.
I think I saw one more hand, and then we take those. Please go ahead. Here in front. Ma'am, here.
Thank you, Ragini and Yirel, for the presentation. I have 2 questions. One is for Ragini. What are the challenges faced by UNHCR to implement their mandate? And second one is for Yirel. What kind of role does UNHCR play when it's trying to train government officials in trying to, protect people at sea? Thank you.
All right. Let me take the first question on the Sri Lankan refugees. So UNHCR has an office in Chennai and an agreement with the government where we support return to the country of origin for those who voluntarily have declared that they want to go back. So that's one main role that UNHCR has in this country. And of course, we work very closely with the government of India and the government of Sri Lanka to facilitate this. But among the ones, the Sri Lanka Tamils in Tamil Nadu, in the south of India, not everybody has declared that they want to go back home, and that is already many people are there for many, many years. So there are indeed also discussions ongoing with the Tamil Nadu state government to see what kind of local solutions could there be in the sense of livelihood, citizenship, how people can stay on a long-term basis in India with a legal status. But this is something that is not only at state level that these discussions can take place. Since you all have a legal background, I assume, that you also know that in India, issues related to citizenship is a central government decision. So these things are also discussed at the central government. So at the Tamil Nadu state government, there's at the moment, since 2 years now, there's an advisory committee who gives recommendations on how we can find local solutions in addition to supporting the return of people who want to return, because solutions should stay broad. People need to be able to have those solutions in hand. So that is definitely going on. But it also requires discussion on the central level to move on that. It is definitely on the agenda. I don't go into detail if Ragini, I don't have a legal background myself. As I was introduced, I'm a social anthropologist. But if there are legal issues that Ragini would like to further explain, she can do so. Then on the GCR, the Global Compact on Refugees, this has been a compact that was signed, endorsed by the member states in 2018 in New York. And to be able to And there were objectives of the Global Compact of Refugees are fourfold. First of all, finding a way to improve the self-reliance of refugees and asylum seekers in order for them to take care of themselves and not be dependent on humanitarian aid. Secondly, that jointly we need, as states, we need to find ways to create conducive conditions to be able to return home. So return, how can we facilitate that? Thirdly, how can we share responsibility? That not only the countries who receive the refugees from neighboring countries, who do a lot of effort to host them, should also be supported by countries who are maybe the US, Canada, Europe, who don't have a neighboring country, who are not a neighboring country, but they should help. That could be through finance, but it could also be through offering solutions in their countries. We call that resettlement, that is through with the bilateral discussion with UNHCR, or as we call it, complementary pathways. It could be labor mobility, that could be educational pathways, different ways for people to have a new life from the asylum country where they are to a third country. And then the fourth one is, so I had livelihood, I had self-reliance, I had solutions. What did I miss now? The fourth. Sorry, it will come. I don't have it in front of me. The fourth is somewhere in my head. So anyway, the idea is that jointly we find ways to move forward as an international community to find solutions, and don't let it only do to the asylum countries. That's the most important. And we have we just said in 2023, we had our Global Compact on Refugees, a global forum on refugees, and we had it also in 2019. We have it every 4 years in a way that countries, governments, but also private sector or institutions like ISIL itself can put pledges forward, pledges to support the refugee cause, to be able to achieve those objectives. So there could be a pledge to offer educational pathways to refugees, or like ISIL does, offer courses on international refugee law. So the capacity is built in the country itself, or a pledge to, as a host country, as an asylum country, to have policies in place that people can actually work or have access to healthcare. So all these kind of pledges are done by states and institutions in the private sector. So that's how we move forward with the Global Compact of Refugees, through these forums that we have on a 4-yearly basis. And then in 4 years and then in between, we have a high-level officials meeting to already take stock, like where are we on those pledges? How much have you done? So we're following it very, very closely, actually.
So on the question of challenges that UNHCR faces, I think as I mentioned in my presentation, this is indeed a challenging time, because if you have 122 million people displaced in the world, it's not going to be easy for anybody, neither the states nor organizations working for those people, or not for the people themselves. And in the last few years, UNHCR has had multiple emergencies, as I'm sure all of you know, what's happening in different parts of the world. For example, in the recent times, the Sudan emergency has created the most fastest number of people being displaced. So in this context, not only are the states themselves getting engaged more and more in these emergencies to respond to those, but also as UNHCR. So one of the biggest challenges that we have from a UNHCR perspective is that globally there's a huge resource crunch. The number of people who fall under our mandate are increasing, but the resources are not proportionally increasing, because obviously the numbers are going high up, and a lot of states are also devoting their resources directly, because a lot more people are approaching them directly. Then also these are difficult times, because often when you have a lot of people getting displaced, there could be anti-immigrant sentiment which could impact the refugees. Also because there are foreigners in the other country, there could be a lot of, in different contexts and countries, they may have their own development challenges or development deficits. Globally, climate changes are also impacting, especially the most vulnerable, who are often the displaced people. We have a lot more floods, we have a lot more famines, droughts. That also impacts not only the host population, but has a greater impact on the displaced people, because they're already vulnerable. So these are the broader challenges. Then you have political challenges. Lot of countries had elections last year. A lot of countries have elections coming up. So elections are also linked to domestic politics. It may influence the policies there. There could be change of governments. They may shift their immigration policies, refugees policies. And most importantly, solutions are very, very limited. So not only are there protracted conflicts where people are not able to go back, the countries are probably getting there are hardly any countries which are stabilizing. So refugees end up being in protracted situations. And then you have lot more new crises erupting. So definitely a lot of challenges, including for UNHCR's work, and most importantly for the people who get displaced and are in these situations. That's why, as there was a reference to Global Compact, this is what Global Compact says: a whole of society approach. Nobody can deal with this situation alone. It is all of us who can make a difference at an individual level, at a professional level, or even at an institutional level. So if a school principal allows refugee children to be admitted in the school, that principal is doing his or her bit in promoting refugee inclusion, refugee protection. All of you here who are academicians, researchers, teachers, when you conduct research on a refugee situation, or you start teaching refugee law course in your colleges, you are also doing your bit in promoting refugee protection, whether it's building knowledge, building capacity, building the future advocates. So it's all of us who can only collectively come and make a difference. Otherwise, globally, the challenges are quite big for anyone to deal with it. Yeah, thank you.
Thank you, Ragini. Jesper, go ahead. You're on mute.
There we go. Sorry, the question was related to our mandate as relates to protection at sea. Was that the question?
And the challenges in training government officials on this. Yeah, it was more about challenges on training governments.
Okay. I would say that, the training themselves, we do this especially through the regional support office, the body process, and bilaterally. But the challenge is how to implement this for states that have not, for example, ratified the conventions. So there needs to have these breakthrough policy shifts, and the PCR, of course, is one avenue to have those policy changes, and some kind of comprehensive response that can have clarity and predictability on how to, what would happen in a situation when we disembark people. Even when it comes to the search and rescue, it's quite, even though states have signed search and rescue conventions to a large extent in the region, there is not that kind of coordination that we're looking for to respond to distress signals, etc. So there is we continue to do capacity development, but unless there is this policy behind it, it's very difficult for the usually frontline officials that we give the trainings to implement the new skills and knowledge that they have gained from the training. So those are some of the challenges that we. I was making a reference to the rules-based approach to see how a comprehensive system can maybe ease up a little bit, opening up some doors for these policy changes if there is predictability on if not state X do ABC, then state Y can do ABC. So we put the whole puzzle together because it's a very complex kind of situation going over, in this case, for Rohingya refugees involving some 6 countries. So how can states work together to have a comprehensive response? We have the consultative mechanism in the body process. There is possibility in the future to build such a response. But yes, there is indeed challenges, and capacity development is there, but needs to be interlinked with other measures.
Thank you so much, Jesper. I would like to close this part of the questions now and move on to the presentation of Dr. Balaji Naika. Please go ahead, talking about the principles of non-refoulement and the rights of refugees in international law. Jesper, I don't think he will stay online with us, so thank you so much for being with us, and we'll be in touch. Go ahead, Doctor.
Thank you.
Okay, thank you, respected chair and fellow panelists and dear participant. So before begin, I would like to thank the Indian Society of International Law for this opportunity to share my view on the principle of non-refoulement and the rights of refugees in international law. So before begin, so I want to, so this my structure of today's presentation follows the 6 different parts. The first, I'll be discussing the issue, what is the problems of refugees, or what is the refugee crisis we are talking about. And second part of my presentation is what are the laws we have with respect to the refugees, and particularly the principle of non-refoulement. So what are the laws or the international legal regulation recognize the principle of non-refoulement? So these includes international refugee law, international human rights law, and the range of the regional human rights convention. The third part of my today's presentation is also about whether the principle of non-refoulement has attained the status of customary international law or not. And there are different arguments whether this principle has attained the status of customary international law or not. The fourth part of my presentation is what is called the principle of or the rule of no entry, non-entry policies, and the politics of non-entry policies, and the principle of non-refoulement. The fifth one is what is India's response towards the principle of non-refoulement. So what is the role of judiciary when we talk about the principle of non-refoulement in India with respect to the judiciary, and finally the conclusion. So this is the brief structure of today's presentation. So first is, the refugee. We know the refugee is one of the burning issue today. It is not just an human right issue, but also a political issue for many countries. If we talk about today, the refugee crisis, so the refugee crisis is burning issue for all the times. Even if we talk about whether it is the election in US or in UK, all the time refugee is one of the main important issue. So that's why the refugee issue need to be tackled seriously at the international level. So when you talk about refugee crisis, there is always a debate about North-South divide. Why there is a debate about North-South divide? Because the 87% of the refugees today, they are in global south, or what you call the developing countries. But we know that developing countries do not have financial resources to take care of these people. The developing countries are already in a poor country, and they are the one who hosting 87% of the refugees. But interestingly, most of the developing countries are not party to the 1951 Convention on the Status of Refugee. But most of the Western countries are party to the 1951 Convention on the Status of Refugee, but they are not willing to allow refugees to go to their land. So that's why it is important to discuss the problems of refugees with respect to the developed and developing countries. As far as the India is concerned, so already Ragini ma'am has already highlighted what is India's position with respect to the refugee. India is not party to the 1951 convention, but we are hosting a large number of refugees. This is just an introduction about this topic. So moving forward, so we know who are refugees already. The definition part is already highlighted in the previous speaker. So I will not go into these details of the definition of refugees. I just read out the definition. So the 1951 Convention defines refugee as someone who is outside the country of nationality or habitual residence, is unwilling to return due to the well-founded fear of prosecution. The prosecution must be based on 5 grounds: race, religion, nationality, membership of particular group, or political opinion. And fear must be well-founded, and person must be unable or unwilling to avail themselves of the protection of this country. So what is the summary of this definition? The summary of definition is a person who is unwilling to move to the, move to the other country. There is no other option, but he has to leave their home. So we can understand what is the condition of refugees. They want to settle in their home, but there is no situation they can settle there. They had to leave their country unwillingly. So that is one of the important, the point of this definition. And the next, moving to the main, the argument of today's presentation is the principle of non-refoulement. So the principle of non-refoulement means, a country cannot send back to the person where the person faces threat to his or her life. So that is recognized as one of the rights of refugees under Article 33, subclass 1 of the 1951 Convention on the Status of Refugee. It says, no contracting state shall expel or return a refugee in manner whatsoever to the frontiers of the territory where his or her life or freedom would be threatened on account of his race, religion, nationality, membership of particular social group, or political opinion. So why I am picking this particular rights of refugees? Because the principle of non-refoulement clearly says a country cannot send back to the person when they go for asylum. So they cannot forcefully send back to the person where there is a threat to his or her life. So that's why this principle is cornerstone of the most important rights of the refugees. So this right is not absolute. The principle of non-refoulement is not absolute, but there are restrictions on the principle of non-refoulement that is contained in Article 33, subclass 2. The Article 33, subclass 2 says, the benefit of present provision may not, however, be claimed by a refugee whom there are reasonable ground for regarding as danger to the security of country in which he is or who have been convicted by a final judgment of a particular serious crime constitute a danger to the community of that country. So that means the protection of non-refoulement is not available to the person in two grounds. So the first one is where the person is threat to the security of the country, or where the person is threat to the community of that particular country. So these are the two grounds where the country can refuse to recognize or guarantee the rights of non-refoulement. So this is very important because the most of the countries are utilizing this particular provision to negate the principle of non-refoulement, including India. Okay, so the principle of non-refoulement, we can understand, when the refugee goes to the country, the majority of the refugees are women and children. When they go to the country and the country treating women and children as threat to their country, and on that basis, they are not allowing refugees to step in. So that is, the important we have to understand why these grounds are mentioned here. So next, moving. So what are the laws we have today, which apart from the international refugee law, so recognize the principle of non-refoulement? So for example, the Article 3 of the United Nations Convention on the Torture, Convention Against Torture, is also talks about the principle of non-refoulement. The Article 3 says, no state party shall expel, return or extradite a person to the another state where there are substantial ground for believing that he would be in a danger of being subject to the torture. So that means the most important aspect of Article 3 is Article 3 is not subject to the derogation. So that means the exception which are available under Article 33 of the Refugee Convention, that is not there in the UN Convention Against Torture. So that means the Article 3 of the CAT Convention is absolute. There are no exception to this. So similar to this, we have another important provision which recognizes the principle of non-refoulement, that is Article 7, Article 6 and 7 of the International Covenant on Civil and Political Rights. So Article 6 and 7 of the International Covenant on Civil and Political Rights also recognize the principle of non-refoulement. So moving forward, the Article 14 of the UDHR, Universal Declaration of Human Rights, also talks about the right to seek asylum, or right to asylum. So everyone has a right to seek and enjoy in other country asylum from prosecution. So all these provision, apart from this, there are so many other conventions. For example, OAU, the regional convention, OAU Convention on the Refugees in Africa, the Cartagena Convention, and also the range of human rights convention in a region. For example, European Convention on Human Rights, the American Convention on Human Rights. All these laws recognize the principle of non-refoulement. So if all the laws are recognized the principle of non-refoulement, the next question is whether the principle of non-refoulement has attained the status of customary international law or not. Because why this question arises? Because whether this principle is applicable to those countries who are not party to the 1951 Convention or not. So if the answer is yes, if the principle of non-refoulement has attained the status of customary international law, then the country has to abide by the principle of this non-refoulement. So there is no other option, because the customary international law, we know that irrespective of whether the country is party to the convention or not, they had to abide by the principle. So there are two schools of thought when we talk about the principle of non-refoulement, whether this principle has attained the status of customary international law or not. So the first argument is, the Article 53 and 64 of the 1969 Vienna Convention on the Law of the Treaty says a peremptory norm is accepted by the community of states as a norm from which no derogation is permitted. So that means there should not be any exception to the principle, or there should be a wide practice of the state as well as the opinio juris. So in that circumstances, a particular the principle can be considered as attained the status of customary international law. But when we look at the principle of non-refoulement in different conventions, so for example, in 1951 Convention, the principle is not widely accepted because somewhere the state go for the exceptions which are mentioned under the Article 33 subclause 2. But as far as the the CAT Convention is concerned, or the International Covenant on Civil and Political are concerned, these principles, there is no derogation is available. So that's why some scholar argued that the principle of non-refoulement has attained the status of customary international law. But some other scholars argued that since there is a derogation available under the Refugee Convention, the principle has not attained the status of customary international law. So these are the different arguments. But some observation of for example, the United Nations High Commissioner on Refugees Executive Committee mentioned that the non-refoulement as a peremptory norms of international law was recognized by the UNHCR EXOCOM. And also the 1984, the Cartagena Declaration went step further and declared non-refoulement with regard to the refugee to be jus cogens. So that means these documents recognize the principle of non-refoulement as attained the status of customary international law. So the next is, on the one side, the principle of non-refoulement. We have the principle of non-refoulement, and majority of the developing countries are party to the 1951 Convention. So that means, whether the principle has attained the status of customary international law is a different argument. But most of the developing countries has to abide by this principle because they are party to the 1951 Convention. But what is happening is now the developed countries are not interested to receive the refugees, or they are not interested to respect the principle of non-refoulement. But on the other side, they are party to the 1951 Convention. So what they are doing now, on the one side, they want to say that we are party to the Refugee Convention. They will tell the global southern country that we are party to the Refugee Convention, but they don't want to respect the principle of non-refoulement. So that means they don't want to receive any refugee from any global south, whether it is Syria, Afghanistan. They don't want to receive, but at the same time, they want to claim that they are party to the Refugee Convention. So what are the mechanisms they are adopted to keep these refugees away from the border of the developed countries? So that is called the politics of non-entry. So, in the traditional method, 20, 30 years back, they introduced what is called the visa, the carrier sanction mechanism, and now they are introducing different mechanisms. For example, recently the UK adopted the Illegal Migration Act, and also the UK, there was a deal, UK and Rwanda deal. So all these mechanisms to keep refugee away from the UK. And also now the US is also planning to have a similar legislation. So the politics of non-entry is clear violation of the principle of non-refoulement. So that's why my argument is the developed countries simply they will say that they are party to the 1951 Convention, but they are not respecting the principle of non-refoulement. Even the Global Compact on Refugees, which was adopted recently, that was also soft law. That is also not talks about a clear responsibility of the developed country. So that is one part. That means the global country, the global south now has a lot of pressure to host a lot of refugees, and the developing countries are not sharing the responsibility of the developing country despite their party to the 1951 Convention. And moving to what is India's response to the non-refoulement, if we already ma'am highlighted that, we are not party to the 1951 Convention, and we don't have any domestic legislation on the refugees. And the Supreme Court has played an important role in recognizing the rights of refugees, and that we can see from the lot of the cases from the Honorable Supreme Court. For example, in the case of Khudiram Chakma and the National Human Rights Commission versus Arunachal Pradesh, the Supreme Court held that the forceful deportation or refoulement of the Chakma refugee amounts to the violation of Article 21 of the Indian Constitution. So that means the Indian judiciary, or particularly the Indian Supreme Court, has clearly laid down that the principle of non-refoulement is part and parcel of the Article 21 of the Indian Constitution. The India cannot violate the principle of non-refoulement because Article 21 is part of the principle of non-refoulement. And also the various high courts. For example, in the case of Gurunath versus the Government of India and A.C. Muhammad Siddiqui versus Government of India, the court upheld the customary international law of non-refoulement. So that means the non-refoulement is part of the Article 21, we cannot ignore. And also similarly recently in the Afghan refugee case also the Supreme Court they held that the forceful deportation or refoulement of Afghan refugees, clear violation of Article 21. So that is the traditional method of Supreme Court. So Supreme Court always acted that the principle of non-refoulement is part of Article 21. But recently, in the case of Rohingya refugee case, in the case of Muhammad Salimullah versus Union of India, the Supreme Court has clearly changed its position, and now the Supreme Court says, we are not party to the 1951 convention, so therefore principle of non-refoulement is not applicable to us, because the principle of non-refoulement is part of the 1951 convention, so therefore it is not binding on us. So that's why the Supreme Court clearly says, clearly ordered the government of India to deport the Rohingya refugee to their own place. So that is the changing our old position. Now the Indian Supreme Court treating non-refoulement is not part of the domestic law. So that is one of the unfortunate development of the Indian judiciary. So coming to the conclusion, a global humanist approach to the refugee crisis is required, so both at the international level, even at the Indian level, because the refugees are coming to our country not for not with bombs, not with guns. They are coming just for the protection. Most of the refugees are women and children, and you cannot treat them as threat to your country. So that's why, whether it is developed or developing country, both require the humanist approach to the refugee crisis. And non-refoulement is one of the important, the legal hope for the world's most vulnerable community. You cannot send this back to their own country where they lose their life. And as far as the India is concerned, it is the time, they should also have a law as well as to respect the principle of non-refoulement. Even if they don't have a law, even if they are not party to the 1951 convention, it is the duty of not only the judiciary but also the executive to respect the principle of non-refoulement. So thank you.
Thank you so much, Dr. Balaji Naika. I was making notes in the meantime. Very interesting discussion that we can have after the contribution of Sneha Vatnavis, which will be more on displacement due to climate change. Please go ahead, madam.
Good afternoon, everyone. Honorable Chair, my co-panelist, ISIL members and faculties, Dr. Rashmi, my colleagues and dear delegates. I feel really honored to speak from this platform of ISIL, and that too in presence of Chief of the Mission of UNHCR and UNHCR officials. The title of my paper is Human Rights Implications of Climate Migration, a Global Response Towards a Comprehensive Solution for the Protection of Migrants. In fact, I wanted to use the word climate refugees, but I thought it would have been legally incorrect to call the climate migrants as refugees, as there is no clear-cut definition of climate refugees, which strictly speaking, firstly, does not exist in current international law, and they do not fall within the definition of refugees. However, we find the concept in some doctrines and in some soft law texts, and is becoming very common in civil societies. It is not even that easy to offer a precise definition, since a good number of legal, social, economic, political and environmental circumstances are intervened around this very concept of climate migrants, which makes it difficult to approach it conceptually. What is certain and more important for today's discussion is the effects of climate change process, which are increasingly severe, altering the living conditions, and a large number of our planet's inhabitants are forced to leave their original territories of residence. In some cases, existence of climate change is very obvious and it is clear and manifest. For instance, the disappearance of islands due to rising sea levels. But in other situations, the other implications of climate change, they are interrelated with other pre-existing environmental and social problems, such as difficulty in accessing water, or the loss of arable land due to increased desertification, progressive deterioration of traditional agricultural techniques due to rising temperatures, pressures, and many times there is hostilities from hostile groups or the ethnic groups, and the population already struggling for these scarce resources. So these are all complex circumstances which make it more difficult to define precisely about climate migrants or climate refugees. Moreover, there is no clear consensus on the very concept of climate refugees. Because some other terms are also used, such as climate displaced persons, climate migrants, environmentally displaced persons, etc. So all of them are useful, and based on specific perspective and approach, still there is a conceptual distortion and debate around this particular concept. What is indisputable is the significant increase in recent years of migratory flows, both in internal and external displacements, directly or indirectly related to the effects of climate change, and large number of reports and studies agree that these flows will multiply exponentially in years to come. According to some estimates, in the last decade of the last century, about 25 million people were forced to migrate due to climate change. This trend is expected to continue, with the number of climate migrants expected to reach 200 million by 2050. The world is witnessing increasingly frequent disasters. Some are caused naturally and some are caused by human activities. It goes beyond doubt that the situation is alarming and needs immediate international intervention, because the adverse impacts of climate change are making survival of people in some parts of the world really impossible. Human migration is one of the most serious consequences of climate change, and lack of adequate concept and definition in international law makes the situation worse. Climate change migrants are not considered refugees because they do not fall within the definition of refugees set out in Article 1A, subclause 2 of the Refugee Convention. As Madam Ragini also told, that there is a requirement of persecution on the basis of race, religion, nationality, membership of particular social group, or political opinion. So in case of climate migrants, this particular requirement is totally absent. There is no persecution as such. The climate change refugees do not therefore lend themselves to the literal formulation of the rules developed for refugees, because they are very peculiar and specifically meant for refugees. The fact remains that there is currently no solution in terms of addressing the plight of those who are forced to migrate or who will be forced to leave their country of origin in the future due to climate change. In most cases, climate migrants are considered economic migrants under a strict and literal interpretation of international law, and therefore they lack international protection. Therefore, I will say that the term environmental migration in general and climate migration in particular is a complex issue that requires specific system to address. The former UN High Commissioner for Human Rights described in 2015 that climate change as probably the greatest human rights challenge of the 21st century. The current High Commissioner of Human Rights has also called placing human rights at the core of climate action efforts. This shows the severity of the implications of human rights on the climate migration. The Paris Agreement also confirms that while addressing climate change, states must respect, promote, and consider their respective obligations on human rights and of migrants. Various UN rapporteurs on human rights have reiterated that ecological crisis can negatively affect an array of human rights, including the right to life, health, housing, food, water, and educational, cultural, and collective rights such as rights of indigenous people and the right to self-determination. Another major human rights implication on climate migration is that it may also worsen existing incapabilities and vulnerabilities within society, as it disproportionately affects women and girls, the disabled persons, indigenous persons, racial and ethnic and national groups, etc. So far as the global response for this situation is concerned, most people displaced by climate change and disasters remain in their own countries and become internally displaced persons. The states are supposed to protect, promote, and respect the human rights of internally displaced persons within their territories without discrimination. International refugee law may apply to those who have crossed international border depending upon the circumstances, and international human rights law may apply under the principle of non-refoulement to those who do not meet the criteria for refugees. Under international human rights law, states are bound to uphold human rights of any person under their jurisdiction, which includes people displaced in the context of climate change. A document issued by UNHCR in October 2020, that is Legal Considerations Regarding Claims for International Protection Made in the Context of Adverse Effects of Climate Change and Disasters, and the Paris Climate Agreement of 2015 deserve a special mention so far as global response is concerned. Another important landmark is the Global Compact on Safe, Orderly and Regular Migration adopted by the UN in 2018, wherein it is stated that one of the factors causing large-scale movements of people is the adverse impacts of climate change and environmental degradation. The compact also states that governments should work to protect climate refugees in the countries of their arrival by devising planned relocation and visa options if adaptation and return are not possible. Earlier in March 2018, the UN Human Rights Council adopted an outcome document which appealed to the governments to incorporate the concept of human rights protection into the planning and implementation of climate change measures and also apply principle of non-refoulement. The Human Rights Committee's ruling in case of Tetiota versus New Zealand has gathered significant attention to the world community. The Ian Titoa, a citizen of Kiribati, a South Pacific island nation at risk of losing land due to rising sea levels, applied for refugee status in New Zealand, which was denied, and he was repatriated to Kiribati in 2015. In 2016, he complained to the Human Rights Committee. The committee upheld the decision of the New Zealand's decision, stating that Tetiota did not face an immediate threat to his life. It recognized that the impacts of climate change, such as rising sea levels, represent a serious threat to the right to life for individuals in countries like Kiribati. Furthermore, the committee emphasized that under international human rights law, people displaced by climate change or disasters across borders have the right not to be returned to a country where they would face a serious risk of irreparable harm to their right to life. The committee also noted that without significant national and international efforts, climate change may lead to human rights violation. The Tetiota case is particularly noteworthy. Despite the unsatisfactory outcome for plaintiff, it opened the door for climate-related refugee claims. It suggests an alternative form of international protection through judicial recognition of the principle of non-refoulement, grounded in the obligation to protect fundamental rights, especially the right to life, potentially threatened by climate change. The human rights must remain a part of discussion on forced displacements due to climate change and ensure that affected people can seek protection through national and international legal channels. I would like to conclude on a very positive note that international cooperation is essential to protect those displaced by climate change. This includes sharing expertise, financial support, and best practices to enhance adaptation strategies. Policymakers should integrate climate migration into global and national agendas aligning efforts with sustainable development goals. Strengthening cross-border legal frameworks is key to ensuring climate refugees receive the same rights as traditional refugees. So, international cooperation is crucial to protect all individuals displaced due to climate change. With this, I conclude, and I thank ISL for giving this wonderful opportunity to speak at this international conference. Thank you so much.
Thank you so much, Snehal Fatnavis. We had up to 1:15 today because we started 15 minutes later, I had not realized that you were here. I'm very happy you are here. Welcome, Rajshri Singh. So we're a bit delayed because of, I gave the others a bit more time thinking we had one panel member less, but we, of course, are very happy you are here. So please go ahead. I hope people have time to postpone their lunch a little bit so we can finalize our discussion here.
Good afternoon, everyone. I'll try to finish it within the time limit as I'm hungry also. So I'm honored to have the opportunity to present my research on climate refugee, the legal paradox right against the adverse effect of climate change. So as we all know, the unsustainable practice of economic growth and Anthropocene interference in the environment is driving climate change and is creating environmental degradation at an alarming rate. The effect of this climate change is such that it increases the frequency of flood, drought, desertification, and sea level rise, and putting the immense pressure on land and water resources. This in turn is leading to a crop fill and limited access of natural resources and displacement, whether it's voluntary or forced, of people for the better livelihood. I'm just putting these pictures, if you can look at it. These are the scenario which is in the different part of the world. For example, for Thalau, this is a Pacific island. And this place is facing a severe crisis related to climate change, as it is sinking also, and people from indigenous tribal are living there, their culture, their civilization, their ancestral livelihood style, everything is getting vanished because of that. And picture image 2 is of Sundarban, where the Amphan cyclone come, and people life already in India, people are very poor and they don't have a proper livelihood. When these kind of cyclones come, their life and livelihood get affected to an extent which we cannot even imagine. The third example is of Turkey and Syria. As we all know that Turkey is the biggest place for climate refugees, where 3.2 million people live there as a refugee. And when the 7.8 magnitude of earthquake hit the place, we don't know whether we should save ourselves or the refugee who are residing in our country. So these are the precarious situations which are in all across the world. And after looking into this, I have actually adopted the doctrinal methodology for this paper. And as we can go for IPCC report, it states that 50 million to 1 billion people can migrate due to climate change from 2016 to 2050. According to UNHRC report in 2022, 70% of the refugee and asylum seeker fled from the highly climate vulnerable countries, as increased from the 56 in 2012. The situation is all across the world kind of same. We don't know whether we can, earlier the debate was like protecting the environment, but now it's tilting toward protecting people from the adverse effect of environmental change also. So if you look at the judgment of State of Netherlands versus Uganda Foundation Hazard 2015, it upholds that there is a direct correlation between the anthropogenic greenhouse gas emission and global warming, emphasizing the potential ramification of exceeding 2 degrees Celsius temperature rise, which could threaten the right to life and disrupt the family life also. We can look at the international organization IOM report. It states that 26.4 million people have migrated due to the internal displacement happened due to the disaster. And if you look at these people who are displacing because of the climate change, they are firstly this term has been coined by Azam Al-Hawani in 1985, and it states that people who have been forced to leave their traditional habitat temporarily or permanently because of the marked environmental disruption and environmental triggered by the people that jeopardize their existence or seriously affect the quality of their life. IOM states that the movement of people or a group of people who predominantly for a reason of sudden or progressive changes in environment due to the climate change are obliged to leave their habitual place of residence or choose to do so either temporarily or permanently within the state or across the border. After realizing these things are happening, I delved into the other part of my research paper on how right to life and climate change is related. And the first judgment which come into my mind after researching is Jabiko Naramoga's project case, in which the ICJ judge Veera Mantri noted that the protection of climate is a vital part of contemporary human rights doctrine, and it is an indispensable requirement for numerous human rights such as right to health, right to life itself. Budagaya versus Russia, in which European Court of Human Rights held that the state duty to protect life extend to the protection of from the natural disaster where the risk is known. Recently, in 2024, Varian versus Switzerland, the European Court of Human Rights states that right against the adverse effect of climate change as a basic human right. Even in our country, M.K. Ranjit versus Union of India 2021 held that right to life under Article 21 of the Constitution include right against the adverse effect of climate change. Now I'll focus on one of the pertinent judgment which comes from the Ordinano versus Italian apex body, and it grants the climate refugee status for the first time to a person from Pakistan who was suffering from the human trafficking as well as the flood situation in Pakistan was so severe that person fled to Australia and asked for a climate refugee as a person to grant them a status of climate refugee and asylum, where the Italian apex court gave him a right of a climate refugee. And after that, I went to delve into the Bordeaux Court of Appeal of France, where it was upheld that the decision to grant Bangladeshi national who was suffering from serious respiratory illness a temporary residence permit, the court took into account the environmental factor, particularly severe air pollution in Bangladesh, which could exacerbate his medical condition. So, the Bangladesh has a huge amount of air pollution, and this person was going through asthma. So he got the climate refugee status in France. Recently, in May 2024, Cruz Glacier versus Garland, the Court of Appeal of USA denied to grant climate refugee status and did not grant the status to a person who was from Guatemala of his own state as a climate refugee, because he did not find them as a particular vulnerable social group. So these are creating somewhere in the countries where people are much more on a humanitarian ground, giving them a right. On the other hand, there are states who are much more concerned about securities, and they're not considering, even in the judgment it was written that people, just because he's a poor, he cannot be considered as a vulnerable. Now, the second part of my paper delve into the Geneva Convention. As we all know, and we discussed by each and every panel member, that the definition of refugee is not apt for the people who are suffering because of the climate. Similarly, Paris Agreement, even COP28, loss and damage principle come, but it does not recognize particularly for protecting the people from climate. If we look at the Sendai framework for disaster risk reduction, there is a principle of disaster rehabilitation and reconstruction, but they lack the provisions for protecting the people who are displaced due to climate change and across the border and all. So the third part of my paper delve into what's the international legal jurisdiction and how the international courts are dealing with the climate refugees. So the first case, as discussed by ma'am also, of Titiota versus New Zealand, where it was stated that he got the non-refoulement status of as a climate refugee, but it was in the judgment it was said that there was no right of violation of fundamental right to life because we cannot see the foreseeable effect of climate change in your territory. While there was a dissenting opinion of Justice Duncan Laki Muzumuma, who argued that difficulty to accessing of fresh water because of the environmental condition should also be enough to reach the threshold of showing that right to life with dignity has been compromised. The second case, which is very important, is a Daniel Bailey versus versus Australia. In this case, people from Torres Island were demanding that their right to life has been violated, their cultural and because they were indigenous, they have the indigenous civilization. So they were demanding that their cultural, their civilizational rights were violating because of the climate change, and the island is sinking. So in this case also the European Court of Human Rights United Nations Human Rights Committee agreed that their cultural and their family life under IPCC Article 27 and 17 has been violated, but there is no foreseeable foreseeable scene of sinking island in the near future of 5-10 years, so their right to life is not violated. After that, we can look at the judgment of Jos Noni Vendo versus Department of Arakawa. This is also a very interesting judgment in which the Colombia, what happened is that there was a forced displacement in 2011 in Colombia region, and there were people who were also similarly affected by the environmental disruption. So recently, under Congress Law 448 or something, they were granted the right for right to life has been violated and all. There were two people who filed that our right has also been violated, and it was granted, and the Constitutional Court affirmed that, even ruled that the environment and climate-induced migrations is a form of displacement deserving special protection. While the court recognized there is a legal gap for such victim under existing law, it is mandated that Congress to legislate on the matter and order authoritative and immediate protection in the line. So while concluding, I would say that there are a lot of countries who are putting their security and sovereignty above the right to life, but we should also understand that the effect of climate change is not limited to one place. Even somebody is doing something that can affect the another state. Recently, I visited the WTO organization conference, and the delegate from Nepal said that we have a zero emission of carbon, but we are suffering, and that time flood had came in their country. So we have to be much more humanitarian. We have to understand that each and every individual life on this planet is valuable, and we should respect that, and we should consider even if they are migrating because of the climate change. Thank you so much. I hope I have adhered the time limit. Thank you.
Thank you so much, Rashri Singh. It was complemented well the discourse of Snehal Vadnavis. I open the floor for questions. Let's take 3 first, and then maybe answer those before we move on. Who wants to take the floor? Please go ahead. We do need a microphone.
Yeah, thank you, Chair. My name is Dr. Santosh Upadhyay, and one of my colleagues is also there. I have heard about Article 21 and principle of non-refoulement. Though I'm not the expert of this subject, but it's not a question, but like a comment or something. If we analyze Article 21 of the Indian Constitution, it does not protect any self. It only protects the procedural niceties that, okay, right to life and liberty can't be compromised without the procedure established by law. It means if procedure established by law, and it is the just, fair and reasonable, what is glossed by Maneka Gandhi, rights can be interfered with, can be regulated with, can be dealt with by the state in very manner. So when we say that in one case non-refoulement has been declared as part of right to life under 21. And in another case, some deportation has been ordered. So I think we should keep these things in mind, that what Article 21 is. Maybe I'm wrong and I'm subject to correction because it's not my area and I've not read those judgments in detail. Another thing, like a perplexed issue that always keeps me haunting for last 6-7 months, the difference between rules and principles. Those Supreme Court judgments also many times overrule this difference between rules and principles that is advocated by some jurists like Dworkin and any kind of thing. When we say principle or principle of non-refoulement, principles are sometimes subject to wider adjustments, they are subject to amenability, they are subject to various conditions. So absolute and rigorous compliance with the principle, maybe it's sustainable development, precautionary principle, all these are subject to something. Larger kind of attitude are there. So in this respect, when we talk about principle of refoulement, what is its obligatory character and what is its like penumbra of adjustment and all those kind of things? I would like to hear something about that. Thank you.
Thank you so much. Just take another 1 or 2 questions if there are any. Yeah. Oh, sorry. Yes, go ahead.
Hello.
And then you go.
Hello, am I audible? Am I audible? Yeah, okay, thank you. So non-refoulement is actually an interesting and a core element for international refugee law as such. So as Sir has also pointed out, the evolution of non-refoulement and how the approach of the state in present times is much more hostile towards this principle. The last judgment by the Indian, as pointed out, the last judgment, Muhammad Salima, from the Indian Supreme Court. So what I wanted to ask is, as states become hostile towards this core principle, how do international refugee law move forward or the way forward for the protection of refugees? Thank you.
Thank you so much. And there's one more question here in front.
I'm Professor Amit Singh. The question raised by Santosh, he has been we have been fellow colleagues in Center for International Legal Studies, Jawaharlal Nehru University. So, in addition to what he has asked, actually, in the Supreme Court judgment on Rohingya issue, the government's affidavit says that we are not party to the Convention on Refugees or the additional protocol, and therefore we are not bound by the the principle of non-refoulement. This is an untenable position actually, because we all are aware that this principle of non-refoulement is considered to be having attained the status of customary international, and therefore state obligation is there. Even if you have not consented to a treaty. So on to this, although Supreme Court has actually said that we need to take Rohingya issues from humanitarian and human rights perspective, but the state has taken the security issues and label them as illegal immigrants actually. So my question is also on to if any of the panelists can take what I think we have been a host of refugees in the country. We have had ad hoc policies towards granting refugee status to some of the Tibetans. We have the Tamil refugees of Afghanistan, etc. There have been certain positions of government of India why India has not signed the convention, why it is not signing the convention in the near future. If any one of you could answer to assuage the express consent of the state of India to these conventions, how we should in a forum like this and academicians could persuade the government, especially to go for it and adopt at least a permanent law and policy on the state of refugees. Thank you.
Thank you so much. I would like to.
Very quick question. I'm shifting my question towards internally displaced persons. If in near future we are seeing the adoption of international convention on the protection of internally displaced persons, as till date we don't have any international convention. There is only one regional convention, that is Kampala Convention for IDPs. So my concern, as UNHCR deals with the internally displaced persons also, so they are the people of concern for you as well. So whether we are seeing in very near future any adoption of international convention on IDPs? Thank you.
Thank you. All right, so I give the floor now. We have, fortunately, a lot of experts around us. I will just give, first of all, Ragini on the comment on the Article 21 of the Indian Constitution, and also in relation to the Supreme Court on rules and principles. And then others, if they want to add, please do so.
So maybe I'll add a little bit also about the Supreme Court case, because it's also linked to the whole question of, as you rightly actually mentioned, from a UNHCR perspective, I mean, I cannot comment on the affidavit filed because the people who have filed the affidavit are the right people to. But from an UNHCR perspective and international law perspective, the way UNHCR understands the principle of non-refoulement, it is, as you've rightly mentioned, it's also attained customary international law. It does not, as the other speaker also mentioned, it's not only about the principle of non-refoulement as it is mentioned in the 1951 convention. It is there in CAT, it's there in ICCPR, it is there also interpreted as part of right to life, because sending people back to a place where their rights, their basic life is at risk, is a violation, seen as a violation of right to life. That is how it is interpreted also within the Article 21. So from a UNHCR perspective, whether a state is a signatory or not to the 51 convention, the right argument is that the principle of non-refoulement applies on all, because it's also attained customary international law. The reference to the Salimullah's order, which came up in a couple of times, interestingly came up in the context of an interlocutory application. There was actually a group of Rohingya refugees detained in Jammu, where an IA was filed in this petition for seeking the release from detention, and also asking for a stay of deportation to Myanmar because of the situation there. And I don't remember the words correctly, but definitely the order came in the interlocutory application, where the Supreme Court actually said that the due process of law should be applied. And the main petition is still pending before the Supreme Court, where one of the questions eventually probably would be argued and decided is whether the principle of non-refoulement is binding on India, also in the context because India has not signed the 1951 convention. So this larger question is actually still pending in the ongoing Salimullah cases petition. So based on what we believe is the international law, what we believe has been the jurisprudence in the country, as UNHCR, we are quite hopeful that the matter will eventually get settled in the way it ought to be. I mean, sometimes affidavits could be filed because of whatever reasons, but we have a strong belief in the strong judiciary we have in the country. Yeah, I hope that sort of answers all the three questions linked to the non-refoulement. Thank you.
Thank you so much, Ragini. I'm just looking at the other panel members if they want to add anything.
Yes. Thank you for the question. So with respect to the Article 21, so we know that right to life and personal liberty is subject to the procedure established by law. The same Supreme Court has given two different decisions. So non-refoulement is part of Article 21, and recently non-refoulement is not part of the Article 21. At the end of the day, what we required is not the law, We need humane approach to the law. So that is missing in my view, because so of course, the Article 33 of the 1951 Convention says principle of non-refoulement is subject to the conditions. It's not absolute right. The state, whenever they want, they can say that the refugees are threat to our community, our country, and we will not receive. That is clear. But at the end of the day, what is required is refugees are people who are leaving their home. They don't want to leave their home. They are not coming for tour. They are coming, they are not able to stay in their home. So that's why it is required human approach, and we have to consider Article 21, right to life, that prohibits the unlawful deportation, or so the right to life or the life to be treated seriously, not the law. Thank you. And also with respect to the internal displacement, I have a different perspective to that. So why the internal displacement? Now if you go to the West, now the more talk is of climate refugees and internal displacement, because they want to focus, they want to shift their focus to the other areas. Internal displacement regime was created to stop refugees from leaving their own countries, so that the countries will handle the refugee, they will not come to the other country. So that is the reason why the displacement regime was now in the news. But as far as the law is concerned, most of the displacement are in Global South, Africa and Asia. And in one of the paper, I argued that the Kampala Convention should be the model to the Asia. Similar to the Kampala Convention, we should have also, we should have the similar convention in Asia. Thank you.
All right, and I just maybe, since the question was also addressed to UNHCR and internally displaced, let me try to answer that. So there's a difference between the mandate of UNHCR towards refugees and internally displaced. UNHCR got our statute clearly defines our mandate, right? Related to have a supervisory role on the Refugee Convention, 1951 Convention. So there's never a dispute on that. That's our mandate, right? But on internally displaced persons, that came later through different resolutions in the 90s because of an increased number of internally displaced people, meaning not crossing the border and hence not being considered as refugees or asylum seekers. And UNHCR has a different role. I mean, the mandate is different because UNHCR will only support internally displaced persons in the country upon invitation from the government itself, and also under the leadership of the UN resident coordinator or humanitarian coordinator, but not as a single UN agency. And hence, also there are some other conditions that will be looked at before UNHCR will step in, meaning is there access, what is the access to the internally displaced, what is the security conditions, what are other UN agencies done, what is the position of the government, etc. So since people have not crossed the border, it is a different regime, right? The sovereignty of the state is an important component, and you all having a legal background, you know very much that position. So hence, having an international convention in the same way as people who have crossed the borders, I think it's more challenging in that way. Do I respond this sufficiently? Yeah? Okay, I think we're getting to the final part of the session. I think I smell the food also, and I'm sure you do. Maybe just to also say a little bit about the discussions on people who are displaced due to climate change and other disasters. Yes, just to firstly say that climate change firstly produces a lot of internally displaced persons. Climate change does not immediately create people who cross their borders. They first try to find places within their country. There are situations in which people may have a valid claim for refugee status, right? And Snehal Fatnavis mentioned it. It is related when there's adverse effects of climate change interact with armed conflict and violence. That's where the Refugee Convention steps in. UNHCR talks about persons displaced in the context of disasters and climate change. We don't use the word climate refugees or environmental refugees. I'm not even able to pronounce it properly, excuse me for that. Because we have the Refugee Convention, that doesn't mean UNHCR takes the hands off on this particular topic. I really want to emphasize that. We talked about a global compact on refugees. We talked about the Refugee Forum. There are pledges related to climate action. That is for people who are, like you mentioned, the Syrians, for example, in Turkey, who were affected by the earthquake, the disastrous earthquake, right? UNHCR really advocates for governments to include refugees and asylum seekers who caught up in climate issues or on the natural disasters to be included in anything that is in place for host communities. UNHCR also supports any actions that are needed for people who had to flee their country because of climate and, for example, are from communities that are not having access to services because they belong to a certain minority, or human rights activists who have addressed climate change and are at risk of persecution in their country. So if there's a link to human rights, for sure, the Refugee Convention could apply. But then also we should not limit ourselves, and I think the 4 presentations we had, I think definitely shows how important it is not to limit ourselves in any discourse we have to one particular convention, but we look at the human rights aspect. We take the humanitarian laws. We take the Convention on Torture was mentioned. Of course, the refugee law as well. But we need to show states that there's not, that refugees could fall on a wide, diverse range of different instruments. If we're going to limit ourselves, we limit our discussion. Refugees are human beings, somebody mentioned. They are citizens. They have the right to life, they have the right to freedom. And that could be under the Refugee Convention, but definitely under human rights, different human rights laws. Domestic laws. We talked about the Constitution, Article 21. The discussion is, regardless what your status is in the country, you are a human being. You have the right to life. You have the right to freedom of movement. You have the right to work. Everything falls under the fact that you need to be able to take care of yourself. And I think that is also very much the focus on Global Compact on Refugees. See them as human beings. See them as people who need to take care of themselves, who need to be self-reliant, for whom, yes, there should be solutions. Host countries could often them. And the one that I didn't mention earlier was to take off the pressure for host countries, and that's what you're mentioning as well. Yes, countries like the Western countries should step in. That's where the Global Compact on Refugees is very much focusing on responsibility sharing. Responsibility sharing is very important. So you support financially, but also offer solutions in the countries, be it through third country solutions, but also offer self-reliance, offer ways that people can take care of themselves. And have the right, basic human rights. Basic human rights is not only in the refugee law, it's in many different conventions. We need to really take that into account. Also on climate change. Let's not focus only on the term climate refugees. Under what different conventions, on what different international laws and domestic laws, people can have that protection. People should be supported and have the human rights. It's not only by using the word climate refugee. I think we really have to look at those different international and national laws that can give that protection, can give that support. That would be my final words. Thank you very much for this session. And I wish you a very good continuation of today. And enjoy your lunch for now.
Thank you, ma'am. I now request Professor Anupam Jha to felicitate the chairpersons of the session, Ms. Margaret Wienma and Ms. Ragini Juch.
Sir, one group. One group. Sir, इधर ही है. Yes, ma'am. Great work. Yes, thank you, ma'am. Thank you.
Thank you so much.
Yes. Good afternoon, everyone. I request all the panelists to come on the stage. Good afternoon, everyone. I welcome you all to the session. The session is panel discussion on teaching and research in international law. The chairpersons for the session are Dr. V.G. Hegde and Dr. Manoj Kumar Sinha. Dr. V.G. Hegde is professor in Center for International Legal Studies, Jawaharlal Nehru University, New Delhi. Before joining JNU, he has worked as senior legal officer in the Legal and Treaties Division, Ministry of External Affairs, Government of India. He has received a PhD from Jawaharlal Nehru University, New Delhi. He has to his credit several publications in national and international journals. Our next chairperson is Manoj Kumar Sinha, who is currently working as the Vice Chancellor of the Dharmashtra National Law University, Jabalpur. Prior to joining the DNLU, he served as the Indian Law Institute as its director. He did his doctorate in international law from JNU, LLM from the University of Nottingham, and his LLB from the University of Delhi. I now request the chairpersons to take over the session. Thank you.
So, good afternoon to everybody. First of all, I sincerely apologize for starting this session about 15-20 minutes late. My co-chairperson, Professor Manoj Sinha, is here. And because we had to think about the sitting arrangements, because this is a large sort of, colleagues who are going to speak on various aspects of teaching international law. This is not only on teaching, it's teaching and research in international law, because this panel interestingly contains both practitioners and also academicians. People who are practicing international law, also equally important. We have very senior colleagues working in the ministry or who have worked in various international organizations, and we have Major General Nilendra Kumarji, who is from the armed forces. So we have a colleagues here from teaching and also from the practice. Someone like me, we settle between teaching, practice, and all kinds of things. So, but that will make an interesting mix of teaching and research in international law. I'll just take 2 minutes and then request our co-chair panel, Professor Manoj Sinha, to speak. The one thing about teaching and research in international law, it's a big challenge, particularly when you look at the importance of international law is increasingly becoming very important. If you look at headlines in the last, I don't know how many years, even these days, everything is about international law. You look at today's newspaper, the conflicts which are happening around the world, the other business or trade related matters, all kinds of things. If you open a newspaper, it is the international law which actually comes into the picture. But international law doesn't mean that everything is actually, it interfaces with different aspects of our life. Also various different courses, discourses. And that's the reason why it is very important for us to teach international law. At least I believe that some of the, as has been done in India, particularly in JNU, that the basic principles and ideas of international courses of international law should be taught. That's very important, because today whenever you are working in the cross-border context, you need to keep some of the basic issues, like issue of yesterday when we were discussing about arbitration, or we are talking about investment, or if you are talking about any area, environment, then you need to understand it's state-centric, but again, it's not totally state-centric. So it is also, you can see that Supreme Court and other courts are also dealing with international law in various ways. So we need to understand basic principles. Sometimes we have said, even I have written as well, that sometimes our own Supreme Court has made mistakes in actually quoting some of the basic principles and guidelines as part of international law. That's not the Supreme Court's fault, but because it is the people who actually, the colleagues who actually brief the judges or advocates, they also should have an idea about what exactly are the basic principles of international law. Sometimes there could be, I'm not saying that sources of international law itself is a very complex issue, how to find the sources of international law. And today, as we have discussed in the last 2 days here in the conference, various domestic legal system, domestic laws actually, even within our own country, have had impact coming from international law. Some of the laws have been established because of certain obligations India has, in various international treaties or Security Council resolutions, etc., etc. So I think that is how, and definition of international law definitely has changed. I'm not talking about international law in last 20, 30 years ago as we started our career. I mean, before that, of course, our teachers as well. It was very core international law means that you talk about succession of states and then interrelationship between municipal law, international law, then, essentially immunity and diplomatic immunity, etc., etc. These are available in all the standard textbooks. But today, this is gone beyond that, actually. Today, we are talking about impact, which is, today, in case if there is a decision or meeting of World Trade Organization or climate change or any other international organization, it has a direct impact on all of us. See, and it has a cross-border issue, as already I mentioned. And then, all the time, when we are interacting with our social media, etc., we are either violating or doing something in relation to in transnational context. So anything which is in the transnational context becomes international law. So that is where the interface between private international law, environmental law, you can economic law, I can go on actually. So in this context, I think we need to discuss today. It's going to be a very interesting panel. I'm sure it's a cross-section of our colleagues are really highly experienced and have originality in their ideas. I'm sure they're going to speak. But I will leave with one small incident which happened in Indian Society of International Law many years ago. almost when we were celebrating, I think, some international conference. I still remember Ian Brownlee. I'm sure all of you remember. He's one of our great international lawyers, late Ian Brownlee. He was also there. He came with Richard Falk and many others to our Indian Society of International Law. So he began his speech, because I remember still vividly, and I'll end this with interesting quote from, or the story from Ian Brownlee. He started saying that when in teaching only, he mentioned, when he was teaching, I think in Oxford, I think, or Cambridge, wherever he was teaching, he said, students ask first question, is international law, sir? So even in England, they ask this question. I'm sure everywhere students ask this question. Then Brownlee said, I told that guy, I thought Brownlee is going to say something very profound. Brownlee told the young gentleman, can you see outside? Can you see outside the window? Yes. Can you see a very big car? It's my car, he said. So I am an international lawyer, he said. So that's what he said and ended. Yeah, I don't have to give you any more proof that I am an international lawyer. So that sums up the role of international law. And of course, Ian Brownlee is Ian Brownlee, and you have such great research scholars, and they don't have to explain. We don't have to explain today, justify today for anybody that this old question which comes up. But without international law, as I always quote the Anne-Marie Slaughter in many years ago in Harvard Journal of International Law, said the future of international law is domestic. Our honorable judge yesterday mentioned very nicely that the international law is now being firmed up by the courts, by the domestic courts, by the domestic players in every place. There is a whole dialogue which takes place between the judicial sort of exchanges that take place between the judges, etc. So it is now part of our sort of a, Penathon, I can say. That's what we are doing. So obviously, in this background, I just thought I'll put the entire sort of discussion in a context. I'm sure all the colleagues who are very well traversed and practiced in the area of international law will come out with their own interesting ideas. And then it's one of the major one of the major objectives of Indian Society of International Law to disseminate and teach international law. That's why we always have a session on teaching and research in international law. That will be the most important session in our context. So with this, I welcome all my colleagues here on the dais, and also all of you for this particular session. And let me hand over the mic to my colleague and Vice Chancellor of the National Law University, Jabalpur, Professor Manoj Sinha, who also has a huge experience both teaching and practicing international law. So he will say a few words and conduct the proceedings on behalf of all of us. Professor Sinha.
Should I speak or? All right. Thank you very much, Professor Hegde, sir. And let me start with what sir has just mentioned about the Professor Ian Brownlee. And we met number of times, and finally we met in the last time, I think in 2009. And then the same year or 2010, he passed. He met an accident in Egypt, and he he's no more. But he was very upset when you say Professor Ian Brownlee in the last time in 2009. He said, "You don't say me professor. I am Ian Brownlee, and now I'm practitioner of international law." So what happened all of a sudden? He shifted from the hardcore like an academician to become a lawyer and say practicing lawyer. Even he refused. He said, "Don't call me professor. I'm Ian Brownlee. I'm practicing advocate," and that is the. But as sir has mentioned many things, let me start with the journey from the Indian perspective. And when we study the international law, we should also look into the parallel international organization and international relations. A sound understanding of international law develops if you take note of the scholars of international institutions, international organization, and international politics, and then you come to the law. So that is the approach we need to follow, and luckily we have in the MA in International Studies in JNU. That is the approach, and 2 papers we studied also. It's a very comprehensive. Some way how much we can incorporate, that is there. the contribution of the eminent person. So I feel, and I very young scholars, because Upadhyay, many of you you are here. You must see the 10 volumes of the Indian Yearbook of International Affairs, which is stacked in the library with a rare documents and great contribution of Professor Alexandrovich. The person who came, he established a Madras Center Constitutional Law and International Law. He wrote on the constitution. So a professor who was appointed as an international law expert wrote on the constitution, wrote on the Mughal Empire, wrote on the number of aspects, and his contribution is immense. You go in the library in the Indian Society of International Law, and 1959 he left after 10 years, the books. But luckily we have in the library, and many times I'll read and photocopy. So you should look into those kind of documents. That is the first contribution of the Alexandrovich. Recently, some scholar from Europe, they have compiled all the contribution of Alexandrovich is there. We have to also take note of our own Professor B.S.N. Murthy, that he contributed in the book of Sorensen in international law, and he's a great scholar. He's like, contribution of M.K. Nawaz, many article 1971 Indo-Bangladesh. I learned a lot of things from his writing, which published in the Journal of the Indian Law Institute. You don't need to go to the outside. You have to come to the Indian Society of International Law, and these are the things are there. Contribution of M.S. Rajan. If you want to look into the how League of Nations and functioning of the United Nations, you have 2-3 big volumes, which is available, I feel, only on the JNU, not in the other library. And maybe a Ministry of External Affairs also. Appadurai, the contribution of, and then our own teachers, Professor R.P. Anand, Professor Rahmatullah Khan, Professor Chimney, Professor Tyagi, list goes on. So they are the hardcore academicians. And the other hand, we have practitioner like, starting with the P.C. Rao, जिसको मैं जान सकता हूँ, फिर याद होती P.C. Rao, P.S. Then Neeru Chadha ma'am आए, Nagendra Singh आए, Narendra Singh आए. Nagendra Singh, Judge Nagendra Singh has a huge contribution in the international law. So first you read the contribution. If you focus your study in the class, you will never develop interest in the international law. You focus on yourself. Because class is not interested in, like, undergraduate students, 90% students. I'm teaching after many years public international law, and I find it's very difficult, but somehow I engage. So I feel students are more interested to learn and practice in the domestic law. That real aspect we need to recognize and go on. But our duty is how to integrate the concept and principles and doctrines of the international law while teaching in domestic law. Even at the constitution, when you are teaching, you can cite the Bisakha case. You can cite the other important cases like MC Mehta environment case, other cases. There are a lot of cases where Supreme Court has extensively took the route of the international law. So constitutional law teachers can also teach the international law while teaching and making students familiar with the international law. Environmental law teacher can also take the note of the international environmental law. So these are the things are there. So there are two things when you go in there. And the second point quickly, just before, I met Ragini ji. Ragini ji hai yahan par, abhi nikal gayi. So Ragini is the legal officer in the UNHCR office. And she said one point, and she chased me. I was the other side. She said, "Ki Manoj kahan ho?" Tum bole yahan Jabalpur mein. Then she said, you start teaching refugee law. So the moment you moved out from Calcutta, refugee law stopped. So I think some branches of international law has a mobility character. It comes with the teacher, it goes with the teacher. So teacher who knows international humanitarian law, he teaches, and when he goes out, the international humanitarian law also go along with him. So it's a mobile courses. It's a branches of international law is not static or permanent. They become mobile courses, particularly international refugee law, international human rights law, international humanitarian law, and other. Of course, trade law become a very important, IPR become very important, people are taking. So branches of some of the branches of international law has a deep root in the law colleges, whether it's a Delhi University, other that is more interrelated with, that sir has said, trade law. The international trade law has become a very fundamental subject. Rest are it moves according to the teachers. Somebody asked me, can you name any scholars in the space law or air law? So I said, I remember only Banerjee, Reddy sir, and the Balakrishna Reddy were like 3, and then Professor Mani when he was there. So I could not find 4. And this is some way we, in general, as a teacher, like you all are sitting here, you have to take note how to make subject interesting, not to only think about the public international law. A teacher who teaches in the university environmental law paper, environmental law is a more or less elective or compulsory paper in many universities. But when they teach environmental law, they don't teach international environmental law. Nobody stops you to teaching international environmental law in the paper of environmental law. But you want to start from little bit reference of Stockholm Declaration, then Water Act, Air Act, and then MC Mehta को पकड़ के आप खत्म कर देते हो किसी तरीके से, वहाँ तक ही आप जाते हो. You never think about the COP and other concept, which luckily some of the young scholars are today talking. Many people think COP is cup, जिसमें चाय पीते हैं, but it's not cup, it's a COP, conference of party. So बहुत लोग को इसमें confusion है, कौन कप से बोले, 26 में भी कप हो गया, 27 में भी हो गया, तो वर्ल्ड कप. So we have हर साल होता है. बायोडाइवर्सिटी का भी कप हो रहा है. अभी मुझे पता लगा 16 बायोडाइवर्सिटी का. I was not aware about the COP 16 which is related with the bio. Even I was not aware. मैं भी कोई दूसरा कप होगा. तो ये कप को भी हमें समझाना है बच्चों को क्लास में. तो आप जब इंटरनेशनल कंसेप्ट का काफ़ी स्कोप है डोमेस्टिक पेपर में भी पढ़ाने के लिए. So you teacher, unless you understand that, you you focus on the sir को मिल गया 13 टॉपिक्स लेंगे, निकाल देंगे सेमेस्टर, चल जाएगा, काम खत्म हो जाएगा. You have to go much deeper, and in the process, the beneficiary is a student, and highest beneficiary, personally, it goes to me or sir or other. The more you read, the more you learn. So you are the major beneficiary than the students. Your teaching idea, your interpretation, your application, presentation, all becomes different when you teach something different, international law. Don't stay I started with, I'll just conclude. यही प्रॉब्लम होता है, जब माइक आता तो लंबा खिंच जाता है. So when I started, so I see my journey, it moved in a different way. I started with the international law, landed in the Indian Law Institute, and then some teachers have gone. And then in there, I started teaching legal research methodology, constitution, environmental law, law and justice in globalizing world. I never made a complaint I could have enjoyed without teaching there. That was not my job. But I thought, I must learn something, and that I took a challenge and I taught there. I'm here. I also started as a vice chancellor. I'm teaching law and justice in globalizing world. In the current legal method, I said legal method in first year, when you go, you find lot of things. So many things you learn. So with this, I end here. We'll have more opportunity to discuss. And I request our chairperson, sir, to how to allocate the respective speakers. How do you want to conduct? Milan Kumar, just say senior to junior or junior to senior. How do you want to move?
Mix both, I think, as per the schedule. Yeah, I think we can have about 7 minutes. I think that will be good, because we have almost about 7, 8, 10 speakers, some online also. I think more of reflections then of course, obviously it can be developed into a paper. May I then start with Major General, because he's also our executive president, also a very senior member of the Armed Forces, judge, the court, Armed Forces, the Judge Advocate General Office. So let him. So I don't have to introduce him. He is very well known, and is an authority on international humanitarian law, and has been teaching international humanitarian law. Sir, I request you to speak. Or you want to speak that? Yeah. 7 minutes each participant. Yeah. Then we can have interesting discussion, at least 10-15 minutes.
Okay. Right, friends, with the introductory remark that have been said by Professor Hegde and Manoj Sinha, I'll take on from there. Now, firstly, I'd like to clarify that after my 39 years with the military, then I had the opportunity to head the Amity Law School for 7.5 years. So that gave me, I think, some insight into law teaching. Now, right at the start, since we are talking of international law here, I would like to inform some of you who may not be knowing that on YouTube now, I have a playlist called Nurturing Smart Teachers. And the purpose of this playlist was to get hold of eminent teachers known for their contribution in teaching, specialization, and achievements in a particular subject, and then they should speak for 30 or 35, 40 minutes on how that subject should be taught. So it could be of use to existing teachers as well as aspiring teachers. And I'm happy to tell you that out of those 48 different subjects that have been covered, they are freely available on YouTube. There are, I will name it, there is Comparative Constitution by Professor Pradeep Kulshrestha, International Cybercrime Law by Pawan Duggal, International Relations Manoj talked about. So there are 20 lectures by Mr. Lalit Mansingh, who was Foreign Secretary under under Atalji and then India's ambassador to US. International Trade and Economic Law by Rashmi Salpekar. Private International Law with relations to children and marriage matters, Advocate Anil Malhotra of Chandigarh. International Humanitarian Law, Umesh Kadam. International Investment Law by Professor N.L. Mitra. Law of Treaties by Anupam Jha. Then International Environmental Law by Chandra Bhushan. Competition Law by Avinash Dadhich. IPR by Manish Arora, and International Human Rights and Criminal Law by Manoj Sinha. Now that's fun. Now with that I will move on to the teaching of international humanitarian law, with which I have been connected while in army, then at the MIT and subsequently. Now this international humanitarian law, it's a matter of great concern that India, right since its independence, has been drawn into various armed conflicts. They have gone on. Only a couple of days back we have read about Doklam and Galwan matters being resolved, Kargil, and all wars. We take pride in saying that we held 93,000 prisoners after 71 war. Unfortunately, there is very little literature available on IHL. And with that difficulty, I found that out of the subjects that have been prescribed by the Bar Council of India, IHL, though it figures there, hardly any law college in India offers IHL as a compulsory or optional training program. However, there were two colleges, National Law University, Bhopal is one, there is another one I won't like to name, where I was connected with the teaching of IHL. So the problems were that there was no, incidentally, India has no case law except one matter relating to Goa, which reached the Supreme Court, whether India's occupation of Goa was under the dispute. Otherwise, per se on IHL, there is no case law. There are certain matters which reflect or which border on international human rights law that have been agitated with regard to the situation in J&K or Northeast, but not on, say, Geneva Conventions, additional protocols, ICC, or whatever. Now, these are the problems. I have a full paper on this, but within the 7 minutes that are available, there is a need to decide what should be the learning outcome. Resources development, I would advise that adjunct faculty may be used, because even at the LLM level, there are hardly any law universities which offer a specialization in LLM. So where are you going to get the teachers from? There is a need for enhanced teaching materials, curriculum integration, exchange of faculty, etc. There is a full-fledged paper on this. But I feel that we need, particularly in the area of international humanitarian law, while we are talking about international law, that clear focus should be given to draw up a program with proper learning outcomes. What would be the faculty recommended reading, compulsory reading, and how should the question papers be framed? Professor Anil Mitra has promised me that he would speak on this issue relating to framing of questions, question papers, and also what should be the project assignments that should be dished out to the students to enable them to demonstrate whether they have really absorbed a particular given topic. And therefore, I think I would end here by saying that number one, kindly see these videos regarding the teaching of international law, and I have named out the eminent faculty which is associated with the subjects of their choice or a specialization. And secondly, IHL needs to be taken up, and perhaps the society may like to take an initiative in that regard. Thank you.
Thank you so much, Mr. Major General Nilendra Kumarji, and he has been very active in recent times in getting very good videos on, particularly one on the Fali Nariman was one of the greatest videos I think I can say. He's very active. So thank you very much for your ideas, and he is also our esteemed Executive President of the Indian Society of International Law. I think his words are really important for us. Now, let me now go to Dr. Luther Rangreji. He is the Joint Secretary of the Legal and Treaties Division, Minister of External Affairs. But at the same time, he also taught at South Asian University, and also he also worked in various capacities at different places, and also one of our chief legal negotiators, legal advisors for the climate change negotiations. So he brings us both the practitioners and teachers' point of view. And so over to you, Dr. Luther. Yeah. Yeah, you can be 7 to 8 minutes. Yeah.
President Parekh and all friends and colleagues in the Indian Society on the dais. I think there should be first a course correction in the title. I see it every year. I had pointed that out. It should be Teaching, Research and Practice in International Law. I think, teaching and research are important, but as Professor Hegde was saying, practice also forms an essential part. In fact, in international law, if you see, all the practitioners are either legal advisors, or they have been legal advisors in the foreign ministry, or they have been teachers. So it is, in other countries, they interchangeably play this role of being teachers as well as practitioners in international law. And as Professor Hegde said, I have had the opportunity to serve in an international organization, also work in a university for 5 years in SAU, and be also in the Legal and Treaties Division of Ministry of External Affairs. Having seen this, these three areas, I think it is important to understand three aspects of international law. One is, how do you perceive the discipline of international law? The second is, how do you look at the relevance of international law in the present day world? And the third is, how do you, or what do you need to do, say being members of the Indian society, to improve the effectiveness of international law? So coming to the first part, I think there has to be some purity maintained in the discipline of international law. Although there may be voices that say that international law exists in a particular place, but it's domestic law that really puts into practice what you agree at the international level. But I think there are certain rules, principles, as Professor Manoj Kumar Sinha was saying, that there are principles which need to be taught and ingrained as principles of international law. To give you a simple
implication for global governance, recognizing non-state actors for some challenges. One, it weakens the traditional idea of state responsibility because now state actors also have international rights and responsibilities. Next, accountability becomes more complex. How do we hold these actors responsible when they violate international law? Next, non-state actors play a significant role in addressing global issues like environmental protection, which impacts how global governance works. Moving next. There are three major concerns going forward: accountability, sovereignty, power dynamics. Accountability, how can we ensure non-state actors are held responsible when they violate international law? Sovereignty, state may lose some control as non-state actors gain more power. Power dynamic, the rise of non-state actors changes the balance of power, and we need new legal frameworks to address these. Moving conclusion, to sum up, international legal personality is no longer limited to states. Non-state actors like corporations, NGOs, and individuals are now recognized under international law, which brings both benefits and challenges. While this helps address global issues like human rights and environmental protection, it also complicates traditional concepts like sovereignty and accountability. We need to develop new legal frameworks to ensure that international law can effectively manage both state and non-state actors. Thank you.
Thank you, Dr. Sandhya, for that lucid and very precise presentation. Thank you very much. And then now we have with us Dr. Bula Srinivas. He is teaching at South Asian University, also a former legal advisor with the ICRC. So over to you.
Thank you, Professor Hegde and Professor Manoj Sinha, for the introductory remarks and focusing on teaching and research of international law. I'm not getting into the research part of it. I will reflect a bit on the teaching part of international law, and particularly, and all those reflections are completely personal experience of gaining as to how bit of my 10 to 12 years of experience of teaching. From there, what I see is teaching of international law is not just as international law, but teaching international law with certain critical reflection. So broadly, I put my title, it is not reflected there, is that navigating between the mainstream and the critical. So generally, like when we teach, of course, there is a set syllabus, which is a set textbooks or the authors, but there are fundamentals which are already laid down. Probably we would be dealing with those fundamentals with our own engagement based on our own readings that we do. But inevitably, we are dealing with some of the what we call as a mainstream international. Means there are certain like state. Like we start with what does it mean when we say state? There are 4 components to the state. What is sovereignty? So there are fundamentals which are already set, which almost is seen as you can't make any amendments to them. Therefore, you have to deal with those fundamental categories. But when we look at most of them, like for example, Professor Manoj Sinha has pointed out, going back to Alexandrovich, how Alexandrovich looked at the history of international law in terms of origins of international law, particularly law of the sea, which was to some extent followed by reflected later on by Professor R.P. Anand. So they challenged the fundamentals of international law. Now, is it possible to, in our everyday teaching, to challenge these fundamentals of international law. That is what we broadly call as mainstream of international law. Now, when do we say it is mainstream of international? Okay, is it only 2 minutes left for me? Okay, so what is the mainstream of international law? Most of the times we see what is the mainstream of international law. It is very difficult to define what constitutes the mainstream, but we can identify the constituent elements of the mainstream of international law. What is generally said is that there is something called a neutrality of the rules, autonomy of the rules, independence of the rules, which are generally called as part of the legal formalism. So there is formally, when I have to look at it, so these are the qualities that we look at it as part of international, which are generally referred to as part of method sense, as formal way of looking at international law. Now, what is the framework that is very close to this formalistic view of international law, which we broadly call it as a positivism of international law? That is what we say, that positivism has its own great elements to it. There is no denial of that, which occupies almost large part of international law that we teach and engage with it. But when we have to challenge those fundamentals of it, somewhere invariably we need to question them. That means that we need to question those fundamentals. Question those fundamentals from which perspective? Now, I am keeping it open as critical. For example, somebody is trying to look at it something as third world approaches to international law, or somebody goes back to McDougall's and says policy-oriented approach. All of them have really challenged the fundamentals, like critical legal studies, feminism, all of them. So I'm not looking into each of the critical perspective, but putting all together as critical perspectives, how to deal with them in the classroom. That is the most challenging one, because it is a set thing that is already given to us. We cannot deviate from that, but we need to teach critical perspective, like how to bring Alexandrovich into teaching part of it, when already something set, history is already set. So it becomes extremely difficult to say that, okay, all are equal in the sense critical perspectives, like the way third world approaches looks at it, and the mainstream is one and the same. I don't think it is a convincing thing. I don't think the students will take it so easily, because somebody has to get trained in mainstream so that you get a job somewhere else. So if you start looking at only Alexandrovich, it becomes difficult unless Koskonim is also there, somebody has written a history of international law, because they have to know both of them. So therefore, it becomes difficult when they move out of the university to project whatever their marketability of their expertise. So therefore, it becomes important. But still, if you have to deal with the questions of teaching critical international law, now broadly, I think it can be done 3 ways, which at least, again, I am saying it completely from my own experience, I can see. One is to formulate a separate subject as a paper and say that, okay, these are the critical methods of international law, and you teach only them. So either it could be a compulsory or an optional, but depending on the student's receptiveness, probably you will be teaching it. But it is not going to disturb other papers, like others are studied and you are teaching something as a method as a separate subject. So fine, it will, maybe some students may be interested, but many may not be also interested, but at least you are able to do that. But somewhere I think it is always seen as an alternative to the mainstream. Like the biggest problem is that mainstream is there, you teach something alternative as another perspective. The first challenging task is that there is what we call as epistemological equality. That means that all the perspectives are equal. Mainstream does not have any kind of higher status than the critical ones, that even to prove or establish that or to convey that message, many a time it becomes very difficult. But somehow, that is the reason why I say that when you create a separate paper as a critical methods, it is always seen as some alternative, whether one can look at it or not, it is an optional one. The second possibility of dealing with is that probably in every subject that you teach, probably if you have a 15 weeks of a teaching, the last 3 weeks you keep it for critical approaches to the subject. For example, refugee law you are teaching, humanitarian law. Then after 12 weeks of completely teaching the fundamental mainstream, then you come back to those 3 weeks and get it done. So maybe you are providing other perspectives also. But the big problem with these both are, there is a lot of academic bureaucracy that exists. Means that your faculty committee has to approve this syllabus, then it goes to board of studies. Many a time there would be objections. They will be going to the even readings of it, why this reading is there. So all those bureaucratic challenges, of course, you would be overcoming them. But even after overcoming it, then again somewhere it looks very peripheral to the mainstream. The third one, which I feel is a very possible one, but extremely difficult one, is that without mentioning critical, how to teach critical. Means that almost every day that you teach, it should become part of your everyday teaching. Now, it doesn't have to face the problem of academic bureaucracy, but it becomes extremely challenging for each teacher to engage with those perspectives in every subject without telling that I'm teaching critical methods. Now, that I think probably is the easiest way in terms of overcoming this, but most difficult way in terms of everyday dealing with that part. So it all depends on, of course, each individual's teaching, but I see that I think all these, I have a kind of an impliedly experimented with the 3 of them, but I find the last one is better, but that doesn't happen in one day. It becomes very difficult and it's always a work in progress type. But just to end with, I have 1 minute, is that, but why do we really even to teach critical at all? Now, that is a fundamental question, even before saying that, okay, we need to teach critical international law. Now, it becomes difficult, but it becomes important in the sense that, like in the beginning, Professor Hegde and Professor Manoj Sinha have pointed out that somewhere I think we need to take the history from different parts of the world, because the history of international law is dominated by a particular version. So therefore, you need to have essentially a critical method. Like, for example, if you see about the International Court of Justice and the judges. Now, if you look at from South Asia, most of the times probably would have discussed about Veeramantra, which is very important from Sri Lanka, or about the Indian judges, but we rarely discuss about Judge Jafrullah Khan from Pakistan. In fact, he was the first Asian president of the International Court of Justice, and one of the most important decolonial cases, decolonization case, Southwest Africa. He was central to all of the cases, and he was recused, in fact, forced to recuse from the cases of Southwest Africa. Then he comes back to the court, changes the entire course of the Southwest Africa cases. Now, this history is actually not known, and rarely, I don't think any article is written other than one article by Victor Curtin recently, that just in Asian Journal of International Law. We don't even know the history of it. Judge Jafrullah Khan. But he was one of the most important critical voices for the decolonization from 60s and 70s, both as a judge and as a representative of Pakistan in Security Council and General Assembly. So this is completely a history which has been left out. So therefore, these are the things which have to be dug, and the only way is to adopt some method, some critical method to say that, okay, there is some voice which has been left out. There is some perspective which has been left out. Like, for example, we teach all the General Assembly, just 30 seconds, sir. The General Assembly resolutions from 1960s to early 1980s. But that is also the phase of extremely important General Assembly resolutions which were passed from 1960s to 1980s, especially starting with the decolonization one. But they were not contextualized as part of this is something, a history which needs to be looked at from the process of decolonization rather than as part of another incident which has taken place in 60s and 70s. Because that is also important, that that whole process ended by early 1980s. So the entire third world assertion almost got scuttled by 1980s. So unless we tell the story part of it, how this failure had happened, it becomes difficult. Even to tell the failures, probably we need to tell an alternative story and history for which it requires critical perspective. So thank you very much for that. Yeah. Sorry.
Thank you very much. I think we can all come back to this in the discussion. I think we need to hear more. We have with us Professor Asha Verma from School of Law, Manu Rachana University. She is going to speak to us integrating human rights and humanitarian law education, a synergetic approach.
So good evening, everyone. So thank you for having me here. I know it's very difficult to sit, with open eyes after having a heavy lunch, and it's very tough to sit through 3 days of serious talks, especially with all the festivities going on. And I really appreciate everyone sitting here. It's with the heavy traffic out there. It took me 3 hours to reach from Chhatarpur to this place, and see, I'm standing here in front of you. So thank you for your time. So respected chairs, Dr. Manoj Kumar Sinha sir and Professor Hegde sir, who are the renowned personalities in international law, my fellow panelists and esteemed audience. So I'll start my topic of presentation is integrating human rights and humanitarian law education, a simple overview. I'm not from the international law background, but my area of interest is international law to some extent. I will start my session with some of the ground realities. Being into being into this academics for last 22 years, what I have seen is we all are talking about why we don't teach human rights or humanitarian. Why can't we integrate law and or humanitarian law? So if you see the ground reality, you will find that when we sit as panelists to ask questions from the prospective students when they five for 5-year law, for 3-year law. So in 99.99% questions, the students, when we ask, okay, just tell us what you are going to be. So most of the students, without any exceptions, I only 2 or 3 students in my 22 years of career would have answered. Otherwise, most of the students, they say that corporate lawyer. What do you want to be? I want to be a corporate lawyer, or I want to go for litigation, especially civil or criminal litigation. But you will not find a single prospective candidate who says that I want to study humanitarian law or human rights, or I'll choose international law. So this is the ground realities. It could be because of many reasons. We do not have proper legal internships for them. We do not have externships for them. We do not have proper moot courts. I remember I was, when I joined as Dean ILM Law School, 3.5 years back. So the first task that was given to me was to conduct the moot court at a national level. So for BCI, we cannot use the national, but at the national level. So I asked my moot convener, okay, why don't you, use an international proposition? So the first answer, he was a very good, teacher, coming all throughout his, career was from NLU, 5-year NLU, LLM NLU, PhD from NLU. And he was a very good mooter in his career also. So he said, ma'am, we will not get good teams, or we will not get enough teams to party. Either we'll get only 4 or 5 if we keep this particular thing. If we keep, criminal law or, something, criminal laws, amalgamation of certain laws, say criminal law or constitutional laws. So in that case, it's very easy for us to get the teams. So this is the ground realities. We are talking about international law. We are sitting here, but yes, this is the ground. Anyways, now in recent years, the people, they have started focus more on combining human rights and humanitarian law in education. There are certain important aspects to this, because these two areas are very closely connected with each other. Teaching them together in schools or you say universities. Why I'm saying schools, because now you find 11 and 12, they are also studying legal studies. So if we teach the integrated courses for both these laws, it would give students a complete picture of how laws protect people both in peace and war. Now what has been happening is either the students, they are going for studying humanitarian law, in case if they want to study some for conflicts, if they are studying human rights, if they want to study some domestic conflicts. So, but if we integrate both of these laws into their curriculum, it will help future lawyers, professionals, academicians, or advocates to deal with today's complex issues. Now the question arises, why this integration matter? The answers are very simple. We all know this, because this is a very simple topic. We all know why this is required. The first of all, both the types of law, they aim to protect people's dignity. So this is the common goal for both we ultimately we are studying, or we are learning humanitarian law or human rights law, so to protect the basic human dignity. So when the goal is common, so why can't we integrate both these things? Then overlapping is also there. If I ask, generally what happens, the other ground realities I would also like to say, when the student, especially a 5-year student, when they go to 7th semester or 8th semester, so we ask them, okay, see, choose some electives. So even in 7th semester or 8th semester, the students generally they do not know what is the difference between humanitarian law, international law, or human rights. So when we say, okay, why don't you choose? Why don't you go for this international law, electives? So they said, no, ma'am, there is no employability, there is no practice, there are no case studies, there is not enough material. This is also another. So today we are teaching. I have introduced 2 subjects from the coming semester. One is sports law and one is artificial intelligence. So we are talking about artificial intelligence, where we know that there are no case studies, there are no legal material, nothing is there, but still we are very hopeful that okay, this is a good emerging areas. But we are not talking about humanitarian law, we are not talking about human rights, which is the basic fundamental right of a person. So then there are certain modern conflicts also, where we have seen a number of conflicts in last 3-4 years. I'll tell you one of my experience. In last 3 years, I have been to many international law schools, Australia, various parts of Australia, London. Then last year I was in Paris and Germany. So when I asked these people, students, okay, see, what is your area of interest? So I was surprised that most of the students, 60-65% students, they said international law. And as in India, only you will find only 2 to 5% who has an interest in international law. The reason, it could be the employability, but yes, it is there. The difference is there. So if I say what are the benefits of combined education, so there are many benefits if we integrate both of these laws together in the curriculum. Learning both laws gives student a better understanding of legal protection in different situations, or stronger advocacy and policy. I'll just take 30 seconds. All right. So what are the challenges to this integration? So first of all, BCI, we know that everything is regulated by BCI. BCI is the most, I would say it's a watchdog basically. You can't teach this, you can't teach this, you can't do this, you have to do this, and then NEP has taken over. So obviously in that case, when Professor Sinha was talking, we just teach Stockholm Declaration and then we just move on to MC Mehta. Sir, teaching everything in 44 lecture, it's very difficult for a faculty. They are doing everything. They are doing administrative response, starting from a student taking admission until the student gets the degree in their convocation. So the faculties are busy. So then the other thing is resources needed. As I said that if my mood convener said it's very difficult to get the teams if we keep the proposition on international law or humanitarian law, or because the students they either you do not find the students or you do not find interest of the students in these areas. Internships are also there, and the as far as India is concerned, I would say that employability is the major factor that why the students they generally do not choose international law, because ultimately they would say, okay, what will I do after completing this degree? So they know after studying criminal law, after studying cyber laws, so they have safe career. So I would say there are many examples of success. Just 1 second. See, ICRC has the International Committee of the Red Cross Society. It works with schools to teach humanitarian law alongside with human rights. So these are some of the success stories. We have also seen that Harvard, if you see some of the courses offered from the Harvard, so they have combined courses and real casework, giving students a very practical experiences. Then University of Pretoria is also there, where some of the, though it is more based on African issues, but yes, their master's programs includes both areas focusing on this thing, right? So I think due to time constraint, I will not be going into the details. So thank you so much. If you have any questions, so let me take this. Thank you.
Thank you so much, Professor Asha Verma. I think that's an interesting practical propositions you have given, looking at the interests of the students. I think largely we agree. Now let me call upon Dr. Ashna Singh. She is online. Are you there? Online. Dr. Ashna Singh from National Law University, Bangalore. NLU, Bangalore. Are you there?
Yes.
Yeah. No, that's Akila. Ashna Singh. Ashna. Yeah. Please go ahead. So you can speak. Ashna is from National Law University, Bangalore. She's going to speak to us. You have 7 minutes. Yeah. Please go ahead. We can hear you.
So my work focuses on teaching of critical international law, and I've titled my paper as Teaching Conceived Critical International Law in TWAIL. And I am basically writing about caste in international law, basically caste critique in TWAIL. I develop a lot on Buddha Sir's work to think about what is what are the meanings of certain terms as understood by Dalit critiques, such as civilization. So I've quoted Phule where he says, slavery in the civilized British government under the cloak of Brahmanism, exposed by Jyotirao Govindrao Phule, which is in the beginning of his book Gulamgiri. So, I'm just, these are more like provocations, and I'm just asking questions regarding how was Jyotiba Phule thinking about civilization and India as a civilization, and how does TWAIL think of civilization? So there is that critique over there, or when the TWAIL critique or even the FWAIL critique is about land, indigenous land, etc. And there was Ambedkar on one side saying, I have no homeland. So, what does that mean? So these are the kind of articulations I feel are missing within the TWAIL, the rainbow of TWAIL. And that's something that Buddha Sir also writes about in his article, where, he's given example of how Gandhi, Nehru, etc. have been analyzed from the perspective of TWAIL, international law, etc. But there's barely any articulation of Ambedkar and, might I add, even Phule in understanding international law or a third world critique of international law. I also refer to Vasanti Venkatesh's article where she talks about how caste compels us to think of hegemony beyond Eurocentrism and colonialism. And so that sort of got me thinking about, when we think about the global north in the global south, I think that we have to move beyond the capitalists, the industrialists, and even the state, and think about the people. It is the people, the neighbor, or the society which is the oppressor, the primary oppressor in the society, and the state and the capitalists, the industrialists, etc. perhaps come later or are comprised of these people. So therefore, this entire critique of international law, which is based on sovereignty, etc., it got me thinking about how Ambedkar was thinking about the sovereignty of the untouchables. And therefore, for him to be advocating for communal electorates in that scenario, instead of seeking sovereignty for India as a nation, for which he was termed as a colonial stooge, etc., is something I think is worth thinking about when we are thinking about TWAIL, which misses out on articulation of caste itself. And I was reading one of Andy's blog articles on teaching international law, and he talks about how he starts his class by thinking about sovereignty, where is this class situated, in which country, in which continent, how did this country become sovereign, for example. And that again got me thinking, when I'm teaching international law, I'm thinking about multiple kinds of sovereignties that exist, right? It's not just state sovereignty, it's the Brahminical sovereignty or dispersed sovereignty of the Brahmins that exists, and the sovereignty of untouchables that Ambedkar was sort of, countering it with. So therefore, I feel that TWAIL does not account for such nuances, and especially the TWAIL critique is a lot about how there has been epistemological injustice and epistemological erasure of, the third world, or the knowledge that is in the third world, or statist thinking in the third world, or internationalist thinking of the third world. There's been an erasure of that, or a downplaying of that. And I feel that there has been an epistemological injustice within the TWAIL field itself, when they don't account for the Dalit critique, for example. I'd also like to just add a point about, also about how colonialism, another critique that TWAIL makes is of how colonialism has impacted our resources, drained us of our resources, wealth, monetary wealth, and natural resources, etc. But when if you refer to the Mandal Commission report and how it talks about how the largest taxpayers in this country have been the SC, ST, OBCs, and so it is their wealth and the drain has been basically out of them. And so therefore, what you see today in this, the world of fail, there's barely any articulation by Dalit people. And whereas there's articulation of the indigenous aspect of the indigenous aspects, for example, which is well articulated in the fourth world approaches towards international law. So I was thinking, where do we place caste? I would not like to place caste as a category included in race or descent. That's a little oversimplified. So I don't know, I thought of calling it as the third and a half world. Again, it's just a provocation, and please feel free to disagree with this. So yeah, so I think, yeah, that's those are largely the points that I wanted to make about thinking about hegemony, which is beyond Eurocentrism, and colonialism, to think about hegemony based out of caste, which is not just states colluding with each other, or capitalists and industrialists colluding with other capitalist industrialists in the first world, but also to think about how the common person, the common man has had a role to play in the building of this hegemony, and how that impacts an articulation of international law, especially a third world critique of international law. Yeah, thank you.
Thank you, Dr. Ashna Singh, for that precise presentation within the time limits. Now let me go to Dr. Akila. She is also teaching at the National Law University, Bangalore. She is going to speak to us about this.
Good afternoon. Thank you, ISIL, for this opportunity. Thank you, Professor Hegde, Professor Sinha, the chairs of this session. I would also like to thank Professor Srinivas Bura, Dr. Ashna Singh, Rohini Sen, and Professor Danushka for putting together this panel from NLSIU Bangalore. So we have proposed this panel on teaching and learning of our understanding of international law. So what I going to do, and of course I'm slightly intimidated on speaking about this topic in the theme teaching international law, because the very room has professors who have taught international law for decades now, and some of them here have taught many of us here. So I'll try to be as coherent as possible and as short as possible. So what I have thought to do today is to try and ask if there needs to be a re-examination of teaching pedagogy of international law, or learning methodology of international law, particularly in the context of growing integration between the legal systems and inward-looking normativity of international law. And from past 3 days that we have seen, there have been many panels and there have been different discussions, and some of them have also shown that how different sectors of domestic law have been mostly internationalized, and we see that there is overlapping normativity, which is why I'm not going to really enter into that area of growing integration, because all of us in this room quite agree that there definitely is an integration. I just would like to make one point here, and that was primarily inspired by one of the footnotes that I found in Professor Vijay Hegde's article in the Leiden Journal, where he identifies that how there have been 13-14 instances where the international law have been before the district courts, so let alone the Supreme Court and the High Court, but the district courts are also exceedingly engaging with international law. So after having said that, I think we'll spend 1 or 2 minutes on looking at the inward normativity. And that word quite struck me, because now what we see that the inward-looking normativity, which was coined by Professor Andre Nelomper, who was the chair professor supported by 2 co-rapporteurs, Yuval Shani and Antonio Zankopoulos, who identified that international law is no more outward-looking, it's inward-looking, where it requires the state to ensure that their conduct gets decided particularly to line with international law. So you either positively act or you abstain from acting. For instance, like the way we do with the international investment, where we abstain ourselves from interference. So that way we see that growing inward-looking normativity that is present. And since this has also been my topic of interest, I simply started wondering, are we doing enough while we teach international law? And all of us in this room would agree that the minute I speak about international law, municipal law interface, be any textbook or how we structure our course, we have one dedicated where we touch upon the two traditional theories, and then we do 2 or 3 state practices, come to India and discuss 1 or 2 celebrated cases and end it there. Is that what is required, is the question that I pose. And also that's one prong of the argument that I intend to make. And also flowing from this is to see how the sectorial regimes and the very international law study group on domestic courts engagement with international law talks about the sectoral regimes. The sectoral regimes where we don't really look at the bilateral relationship but go beyond and look at the multilateral relationships. So those again, the ones who teach environmental law, human rights, do we go back and question the nature of international law, or are we happy enough to just, welcome it the way we have? I'm just quickly going to my second prong of the argument, and that is trying to locate if we are academically examining these decisions. And I'd like to limit today's discussion to 2 particular cases that we often celebrate. One is the Vishaka versus State of Rajasthan. The other is the Nalsa judgment of 2004. Vishaka versus State of Rajasthan, how much ever we celebrate it being the case for sexual harassment at the workplace, if we critically look at the very judgment, we see that the caste dimension to Vishaka basically missed. It was more or less treated as that class representation where we were speaking of protection against sexual harassment in the workplace. So that intersectional lens is something that was missing. Similarly, also in the Nalsa judgment, if I were to take your attention to paragraphs 1 and paragraphs 129, and paragraph 129 is that direction which the Supreme Court gives in terms of recognizing the rights of transgender people, their self-identification, etc. And the 8th directive, and if you allow me to read, says that the center and the state government should take steps to create the public awareness so that the transgender will not feel that they are also part and parcel of social life and not to be treated as untouchables. So the reference or associating the transgender people to untouchables sort of creates that position where we are speaking of mutual exclusivity. You either be a transgender or you be untouchable. So somewhere looking at these decisions that we have mostly celebrating, welcoming international law with open arms and saying that let's internationalize, we are missing out on that critical lens that is essentially required in looking at how international law essentially is brought into Indian decisions and how as students we are engaging with these decisions. So I think with these 2-pronged argument, I again would welcome a few suggestions or questions that you have. But the argument that is not really subscribing to any one particular critical perspective, like Professor Bora rightly said, that every perspective that we have definitely has some kind of limitation in terms of inclusivity, but integrating them, possibly trying to build on them, and then looking at how the entire interface basically is between different sectoral regimes of domestic law as well as its influence on international law would, I think, be an interesting pedagogy to take. Thank you so much for this opportunity.
Thank you, Dr. Akila, for your presentation. Now let me move to Dr. Santosh Kumar Upadhyay. He is teaching at University of Delhi, Faculty of Law. He is going to speak to us on a jurisprudential inquiry into the sources of international law and international obligations with special reference to the UNGA and UNSC resolutions.
Yeah. Thank you, chairs, Professor Dr. B.G. Hegde sir and Professor Manoj Kumar Sinha sir, my co-panelists, esteemed delegates here. Very warm good evening to all of you. As my topic is jurisprudential inquiry into the sources of international law and international obligations. First time when I proposed this topic, I was quite fearful that whether it is easy to do jurisprudential inquiry into the sources or international as such. Giving the critique of Austin or Holland or even HLA Hart that there is no rule of recognition in international law, is it apt to do some jurisprudential inquiry? But I got the impetus when I teach sources of international law to my students. It is almost customary and habitual that each of the textbook of international law quote that Security Council resolutions are not the source of international law, but they are the source of international obligations. And UNGA resolutions, successive resolutions on the topic, may generate customary principle of international law. So I prompted at why this debate and what the meaning of this, not a source of international law, but merely the source of international obligations. I explored next, and then I found even in the treaties, we find the distinction between lawmaking treaties and treaty contracts. And the very obvious distinction that is made in many books, the treaty contracts are very small, between small states, between very some particular aspects. So treaty contracts are the source of international obligation, but not the source of law. But the lawmaking treaties are the source of law, as well as they are the source of international obligations also. So how this difference makes it, and what the meaning of all this difference? Whether merely a consent of a treaty or just to signing a treaty can formulate international law as a sources of international law, or it may restrict it's only to the particular aspect, like a very bilateral treaties between two states or three states, particular thing. Ian Brownlee talks about like, and then we have to explore about what is law, what is rule, and what is obligation. Obligation may be particularized in respect of individuals, in respect of particular transactions, but rules are such that remain in continuity. It does not last with the performance of one or another task or obligations. Rules are of perennial in nature. They may be changed, amended, but there is a subtle difference between this. When we go, and we all of know that, like the smooth transfer between sources and treaties, like what has been observed by ICJ in Nicaragua case, that the treaty provision can also develop into a customary principle of international law, but not all the provisions, only the norm-creating provisions of treaty. So this difference of norm-creating provisions of treaty that can develop into customary principle of international law and other provisions that are not norm-creating treaty, it somehow says that what do you mean by law? Law must be norm-creating, and obligations must be the particularized understanding, particularized decision about those norms. Subsequently, when we also discuss this case, like nuclear weapons case, in that also, while discussing the UNGA resolutions and their legal status, ICJ was of very much opinion that, okay, UNGA resolutions, though they are not binding, but they have the potential to develop into a customary principle of international law. And it depends how states reflects upon them. It depends what are the mode and tenor of the participating states when they are being discussed and how they are being used. But again, the problem arises when we did not find any such kind of discussion in respect of Security Council resolutions. We also teach extradition and all the principles of extradition, like double criminality, this and that. We found it, okay, these are the principles of customary international law, because most of the bilateral extradition treaties have been entered on such terms, and this principle can be chalked out from the bilateral treaty and can be discussed in the classes. So can it also be said that repetitive Security Council resolutions on particular aspect can subsequently develop into customary principle of international law on the line of UNGA resolution, or it was merely the source of obligations? Security Council is the source of obligation is very much fine, because in international law we have very much established sources of international law under Article 38(1)(a). Though this 38(1)(a) is basically for the ICJ statute to define disputes in front of ICJ in accordance with the international law, but most of the scholars have accepted it as a source of international law. And if we find it, we find customs, treaty, we always find the space of consent there. Though we discuss that, okay, ICJ can also develop like personality case in any cases. But the effect of consent in the whole discussion of custom and treaty, consent is very much there. And if international law has well-established sources to say that Security Council, where only 15 states sits there, and voting and resolutions can be passed by 9 states consenting by P5, definitely it has repercussions when we admit that it is the source of international law. It is source of international obligation, and it should not be the source of international law. That is all right. But this discussion somehow also got struck when in the Kosovo advisory opinion, when it was thought that, said that, okay, the local institutions of self-government in Kosovo are legally can they declare independence. And in that way, the institutions that have been established by Security Council itself, ICJ has said that in the declaration of independence was not in the capacity of any institution of the Security Council, but any organization can declare independence anytime, independence of anything. So this dilemma is what is the international law, what are the international obligations, and the customary thing that Security Council resolution is always a term as like sources of international obligations, sometimes problematic and haunts. What do you mean in practice actually? Because Security Council also made resolutions in respect of terrorism and another thing that are more or less a norm creating provision. Even if a matter is being discussed in front of Security Council and Security Council is seized of the matter, a question can be raised to the advisory opinion for the ICJ. But in this whole debate of security of international law, sources of international law and international obligation, my last proposition, and I want to say that this inquiry is like there are many instances where this distinction is blurred, but it is paramount for developing countries to maintain this distinction between sources of international law and sources of international obligation. When we teach in our classes, it must be bear in mind that Security Council resolutions are the sources of international obligation and they are not the sources of international law. Law is prospective or of general character, but obligations are particularized in time and space. Thank you.
Thank you very much, Dr. Santosh Kumar Upadhyay. Now we have the last speaker, Dr. Vikas Ram Tripathi. He also teaches at University of Delhi. So he's going to speak to us on the implementation of Indian knowledge systems in teaching and research of contemporary international.
Thank you, sir. The respected chair, the Hegde sir, the respected co-chair Manoj Sinha sir, and my co-panelist and the dignitaries of the dais. So today I'm going to talk about the Indian knowledge system, that too in the background of new education policy of the government of India came in 2020, which talks about implementing the Indian knowledge system at the all level of the education, including the higher education also. So particularly how it's a really challenge that how we could going to be implemented into the teaching and research of international law. So with this, let me begin with, and I parallelly request you, all of you, to be kindly think where we can apply these principles. So the one principle that's coming from Indian knowledge system is the Ayam Nija Paraveti Cha Gadanacha Laguchet Sam Udar Charitanam tu Vasudhaiva Kutungam. So this is mine, this is yours, is the calculation of people of having narrow thinking, whereas for the people having broad thinking, the entire world is the family. So this is the one principle we have to think where we can be inculcate or and again before I move on, as a matter of literature review, Manoj sir is here. Sir has done a great work into the international humanitarian law and the war of Mahabharata. So how the 7 rules of Mahabharata was been compared and could be implemented and teach while teaching the international humanitarian law. Apart from that, I remember while going through this research, late Professor R.P. Anand sir, who has worked also on this aspect. Professor B.C. Nirmal sir has worked on aspect. Apart from that, I remember Professor Ved P. Nanda, who has done also the Vedic principles in international law and Vedic principles. So, and there are many more. My research was a bit limitation period. With this, I would come to my presentation, and I request kindly show my PPT. I think it is here. So, in the meantime, likewise, another principle is Sarve Bhavantu Sukhina, Sarve Santu Niramaya, Sarve Bhadrani Pasyantu, Ma Kushit Dukbhag Bhavet. So this is another principle which we can think of. So let all be happy. Let all be without any diseases and all that. I will quickly come. I don't know how it is not getting connected.
Vikesh Tripathi, sir.
Yes, sir.
Vikesh Tripathi, last speaker.
Yes. So how to implement this? See, the Indian knowledge system represents India's ancient intellectual and legal heritage, deeply rooted into the discipline like law, governance, philosophy, and ethics. So relevance to the contemporary international law in today's globalized context, integrating diverse knowledge system is the essential to enriching the international law perspective. So therefore, the objective is to explore how IKS principles can be deepen our understanding of international law and bringing a pluralistic approach to its teaching and research both. The essentials of IKS in the legal thoughts, of course, dharma. Dharyati dharma, so justice and moral, something that can be, perceived, something that can be taken is called dharma. So dharma is the right conduct, is the right duty, and that too, in the right circumstances. So something that is dharma at a particular circumstances, it may be even just opposite when the circumstances are different. Bhuchitam kim na karoti papam. So bhukha admi kaun sa pap? The hungry man will do all the sins. So see, the point is that what is the right conduct and right duty, what the dharma keeps on changing according to the circumstances. Now, dharma yevo hato hanti, dharmo rachita, tasmad dado dharma na hantabhyo mano dharmo hato vadit. So if we will protect the dharma, we will do the dharma, dharma will protect to us. If we will destroy the dharma, dharma will destroy to us also. So, and let me give you the disclaimer also. Never correlate dharma with the religion. Dharma is altogether a different context, and I can give you the references also anyway. So, from dharma, it's the nyaya, the another concept. Nyaya when talks about equity and fairness, so emphasize the impartial justice, paralleling the foundational principles in modern legal system. Then artha also, the governance, so discuss state duties and governance, echoing the focus on diplomacy and state relations in international law. I will be moving quickly due to paucity of the time. So again, the Chama, the doctrine of Chama is another Indian knowledge principle. Forgiveness. So Chama Danam, Chama Satyam, Chama Yasascha Putrika, Chama Yasam, Chama Dharma, Chama Yavastit Jagatam. So it's from Valmiki Ramayana. So forgiveness again. So the next principle is the non-violence. Ahimsa Paramo Dharma. But let me complete this. Dharma hinsa tathaivacha. So that's the complete context. But we can take even half part, ahimsa paramo dharma. So non-violence is the highest dharma. That is from Bana Parva of Mahabharata. It could be the another relevant thing in teaching of research and international law and research. Now, dharma is a universal principle. Dharma and justice is a universal principle. Dharma signifies righteousness, moral duty, ethical obligation, and underpins the justice in ancient Indian philosophy. It represents value that transcends the culture and notional boundaries, advocating for moral conduct and practice globally. Application in contemporary international law, how we can. So justice as a universal value. The essence of dharma aligns with the modern interpretation of justice as a fundamental human right. So justice is impartially in action. Bhagavad Gita. Justice is impartiality in action. Influence on legal frameworks. Principles derived from dharma can enhance the understanding and implementation of justice in international relations and conventions. Now, the comparative analysis with the international law could be impartiality. The Mahabharata illustrates the importance of impartiality in judicial conduct, paralleling principles found in the Universal Declaration of Human Rights, UDHR, emphasizing non-discrimination and equal treatment. Shruyata dharmaswam srutva chapyavardhatam atmanam pratikulani paresam na samacharit. Padam Puran, atmanam pratikulani paresam na samacharit. So what we expect from others, we should also do the same to the others. We should not do something which we do not like. That's what the phrase of meaning, Padma Purana. Now the sovereignty and rights. So dharma emphasizes respect for individual and collective rights, resonating with the sovereignty principles recognizing in international law. Now the comparative analysis, certain key principles, dharma versus human right. So both concepts advocate for fundamental right and responsibility, emphasizing ethical conduct in personal and social relations. Both frameworks, that is dharma and human right, they prioritize the protection of individual dignity. Dharma serves as the guiding principle for justice and moral duty, paralleling the principles found in international humanitarian law. Now, Artha, the statecraft versus the international diplomacy. Kautilya's Arthas outlined the statecraft principles that align with the modern diplomatic principles. So concepts like realpolitik and strategic alliance in Arthashastra correspondence to the contemporary treaty law and international negotiations, emphasis on the practical application of power and ethics in governance. Now, Nyaya, the justice versus judicial fairness. So, Nyaya represents the fairness and impartiality which are foundational in both IKS and the modern legal system. So, both stress the importance of unbiased judicial process to ensure justice. So, with the kind permission, sir, I will come to the conclusion. So, now the pacta sunt servanda agreement must be kept a fundamental principle in international law, ensuring that the treaties and agreements are honored. So, alignment with the Indian knowledge system, truth as a universal obligation. Satyam bruyat, priyam bruyat, na bruyat, satyam priyam. Manusmriti. So, speak the truth, speak the pleasantry, do not speak the unpleasant truth. So, the another principle, satyameva jayate, like taken from Mundaka Upanishad, could be the another examples. I will be moving quickly. Then sama dama danda bhed is the great principle where we can see taken from Arthashastra into the diplomatic principles. We can think of how to be implemented, and time and again it has been implemented. So the wise conquer by means of conciliation, bribery, punishment, or showing desertion. This is the Arthashastra, Kautilya's. Integrating IKS into international law education. I will be summing up with this, please. So, course module. Design the module that compares the IKS with the international law framework, highlighting their interconnections and practical applications. Interdisciplinary approach, encouraging integration of insights from philosophy, ethics, and sociology to enrich understanding of IKS. Historical legal analysis, examining historical Indian legal texts alongside contemporary legal documents to trace the evaluation of legal principles. Cross-jurisdictional comparison should also be done, analyzing similarities and differences between IKS and other legal systems. Case studies should be done. Workshops and seminars should be invited, research projects, and there the Indian Society of International Law could be the great role to be played. So with this, finally, I will very quickly, promotion of ethical frameworks, enhancing diverse legal system, broadcast principle of universal legal principle, cultural awareness and sensitivity, comparative analysis skill, and in environmental ethics, core Vedic principles like Matribhumi Prithvi Aham Prithibhya. So the Prithvi is the mother and the land is the mother and I am the son. With this, I will be jumping the ADR and this, and now conclusion. So, Sa Vidyaya Vimudhe, Vishnu Purana, knowledge is that which liberates. So, Indian knowledge system contribute to profound insights to international law. So, principles of dharma, justice, nyaya, equity, and satyam, truthfulness, advocating universal values. So, this research demonstrates that in creating international knowledge is the legal education deepens the understanding of justice, diplomacy. And with this, ultimately, we as scholars of international law, the student of we have to be thinks the challenges and how in the line of new education policy, how we in the classroom teaching as well as while doing the research, as and when we can make it contemporary. With this, thank you all for kind attendance, and thank you for the chair for providing me this opportunity.
Thank you, Dr. Vikas Ram Tripathi ji, and he has given us one of the perspectives on how to teach and research in international law. Now we have almost had 9 presentations on various aspects of teaching and research in international law. I do not want to take any more time. I just would like to, maybe we started a little late, so we can have few questions. Maybe I'll have 2 or 3 questions together, and be brief because we have already shot beyond 4 o'clock now. We have another 5-10 minutes only. Then of course later we'll sum up and then finish. You can, from there you can speak. Be short.
Yes, sir.
Identify yourself.
I have some. This is Dr. Anand Krishnaraj from Chennai. I'm teaching international law in Vellore Institute of Technology, Chennai campus. I have a question to 2 speakers. First one, I was thinking to ask Professor Bura how I teach international law, but leaving aside, I want to go to the last presentation, which speaks about the Indian knowledge system. What do you mean by India? Because it's Sanskrit or Hindu knowledge system, which you were saying for the whole time. And you quoted Dharma. Dharma is not, I have written an article about comparing Dharma and Aram principles. Aram is a Tamil principle. Dharma is not universal. There is separate for Sri Dharma is different. Rajya Dharma is different. Varnashrama Dharma is different. So each individual has a different Dharma. A Dharma for a particular person, like a king, is not equal to another person. So the Dharma is actually seeing partiality. It is not equality. And second thing, you speak about Vasudeva Kudumbakam, this all spoken around. Vasu is a clan in the Vedic period. And it speaks about that. It is not universal, international or universal brotherhood, something like that. And you again quoted Ramayana, Mahabharata. Ram never forgave Sambhuga, who was doing
You can
yoga.
keep to the second question, yeah, please.
Yes, sir. So I just want to put my understanding about teaching all these things. I don't know. Just I have some questions.
Let us. Yeah,
Yes,
we'll
sir.
answer.
So another question is it's about critical international law. So Dr. Bura was saying that whether you can go for a separate course on critical international law, or it could be at the end of the semester, within 2 weeks or 3 weeks. But please correct me, sir. I teach, like, whatever the topic which I have taken, I teach them with the critical perspective also. I teach the mainstream as well as the critical perspective immediately. And before that, I used to go to the history part. For example, if I am teaching some particular topic, refugee law. So the refugee law, if we have to go back to South India, there is a concept of Jainism. They had a concept of protecting the people. It is called Anjanan Pugalidam. Anjanan means the person who got fear, and there's a sanctuary for them. So that kind of old ancient history of the particular area, and then we go, obviously every topic touches on colonialism, the critique of colonialism, and then I teach them the mainstream. So I just have a critical approach to the history, where the concept comes from, where the human rights comes from.
Okay.
And then
yeah, he will
Thank
note.
you,
I
sir.
think, yeah,
Thank
we
you
have
so
very
much.
short time. Dr. Jacob, yeah, please.
Thank you very much. I will brief it. From the perspective of a practitioner in two jurisdictions in India as well as civil law, India being common law as well as Germany being a civil law, I have 2 points to make from the practical perspective. Because whatever the law we teach, whatever the legal subjects we teach, it should be from the practical perspective. Otherwise, I, being a lawyer, suffer a lot in various Indian high courts because judges don't know the private international law, judges don't know the public international law. And my clients back in Germany or Europe, they are the law houses. They complain to me, what is this, Mr. Jacob? We are getting always some kind of denial or adjournment. In Delhi High Court also, very recently, we have faced the same problem. Proper law is applied in an international contract wrongly as a default law, the lex fori as a default law. In Madras Thiruvannamalai District Court, we have produced international documents before the district court in accordance with the principle of Hague Convention. Judge doesn't know. In Bombay High Court, we have produced documents and argued on a matter of international testamentary law.
Okay.
So what I suggest that it should be.
What's your question, sir? You come to the question.
It's only a suggestion.
The problem we have question, a specific question, if you have, you ask.
Yes, sir. It's only a suggestion that we should, teach the legal subjects from person.
Yeah. Anybody else? Yeah. Please identify yourself. We'll take 2 more questions and then we'll ask the panelists to answer. Yeah, please go ahead. Yeah. Mike.
Okay, thank you, sir.
Coach, yeah. Please identify yourself and then I think we'll take 2 more
In
questions and
Varanasi,
finish.
we have a center for convergence revolution for religion, and then in US, recently it has been announced.
Questions asked.
What I want to add to this is just one shloka that I used to add in my teaching for IPR, and that was Vidya Dadati Vinayam Vinyate Ati Patratam Patrakatu Dhanam Apnoti Tato Dharmam Tato Sukham. Here Dharmam is righteousness, nothing more. That's what I wanted to add, and it is Samkritam, not Sanskritam, Samkritam. Thank you.
Okay. Please identify yourself.
I'm Dr. Amit Singh. I'm an eternal student of international law and also teach at Mano Rachana University currently. Some sort of reflections are also not very pinpointed question. One question, of course, and that is my observation reflection is based on all of the learned scholars who have presented their thoughts on. I take it as a challenge of mainstreaming international law in our law schools. With my limited understanding, I have been teaching in this subject for 14 years. I suppose any lawyer or any law students taking any career in legal profession would not be successful without a thorough understanding of international law, especially if we are in 2024. We also realize the benefits and advantages of globalization.
No comments.
Although late, Chinese have understood this very soon.
Come to the question.
So this is observation, sir.
All the quotidian-
Question is basically how to diffuse the understanding of international law in the common man's and in the masses, or rather I would say how to
disseminate
how to democratize
Yeah.
the understanding of international law.
Yeah. Last, I think we'll take the last question, and then anybody who is very. Yeah, I think there are many questions, but we have to end sometime.
Sir, my name is Dr. Amrendra Rajit from Law Faculty TU. My question is related to the practical problem what we are facing, especially in the case of PG courses. In LLB, public international law is compulsory paper. But in case of PG courses, a student used to choose for judiciary examination and they prepare accordingly. And no one opt. Even when I joined TU, I started law of C, but hardly 7 students opted it, and out of 7, 5 said that, sir, we will not come regularly. Please, I said that, okay, it is better that you should shift to the other optional paper. So, in traditional university or even in the national law university also, LLM at, international law at LLM is not an optional paper in many universities, and day by day it is decreasing. How it can be improved?
Okay. I think now we will start with Dr. Luther about the practice point of view. If you have anything to say, Germany and things, then we will.
Yes.
Baad mein. First, let us finish off with Dr. Bhupesh Srinivas. He asked about the Germany laws.
Yeah, as regards, Mr. Jacob, your question, I think to be very frank, you can't expect judges to know all of these. There have been instances, I will not take names, where even the Supreme Court judges have asked the Indian Society of International Law, what are their views on this Hague Conventions on inter-country adoption as well as child abduction. So I think you can't expect these judges to know. But yes, there is the National Judicial Academy, and from the Legal and Treaties Division I have gone there with a whole full course for these High Court and Supreme Court judges. They need to know this. One can't just say that you don't need to tell them. They are specialists in their own domestic laws, and there are so many laws in the country, unlike international law. Of course, international law also has streams. But yes, these are differing systems, but there are, there are, occasions where you need to, actually sensitize these judges to this. Maybe the Mufasal and, magisterial courts, even there are training programs for them too, at district level also. But these judges need to get some training in that, and there are areas where they can be.
Thank you, sir. So actually, see, there is dharma even of understanding also. So when I say Udhar Charitanam Vasudhaiva Kutumbakam, see, let's see in the complete context. The entire context is I am Nija Pareveticha. This is mine and this is others. Itself is, what boundary created by a people, how you are thinking, how you are perceiving these things from narrow point of view. So this may be, it's my bottle, it's my stage, it's my hotel or something. And when we look to from broader perspective, so it's the entire world is the family. So that is how it should be in complete consent. Now the next thing is that as a speaker I have a dharma, as an audience you have a dharma. So likewise, I just tell you, dharma is not simply a right conduct. So dharma is a right conduct in the given circumstances. That's why I change you. That is one thing. Like for you, there may not be Sarve Bhavantu Sukhna as your dharma, but for me, it may not be Ahimsa Paramo Dharma as a dharma. But I don't think no one up in this hall will be disagree to is that the Ahimsa should be the first and foremost principle that should be respected in the law.
Okay.
No one will disagree to this that the Vasudhaiva Kutumbakam, where we should, as a word for word peace, the entire objective of the international law, one of the major objective. So word peace, we could be disagree with this. Now coming to your second point that we'll talk about the Sambhog story. So to my understanding, I understand, this story comes to the Uttarakanda, the last part of the Ramayana, whereas the last thing, sir, that may be letter additions. So I will not go to that extent. And I quoted in my study the very principles, the very other scholars, those they have worked on dharma. So to that extent, I think we should take this doctrine dharma in a broader context. And that's how we can implement.
We'll discuss in the tea time. I think we are really, organizers are saying that we should finish now. And now we'll ask Manoj, all of us can discuss and exchange the articles and read it. And now we can, I'll request my, very short.
Yeah, very short. Very quick to Arjun's question is that, yeah, I agree with you in terms of international law, how the critique part has to be done. There are challenges with making it as a separate subject, challenges with making it as a few weeks one. So that is where I said that how to bring it in an everyday teaching is extremely important. But again, going back to the last debate between vacation, the question is that the critique part of it. Now, why we need to emphasize and critique is somewhere, like for example, if you quote Manusmriti, probably also we need to read that extremely important text along with what Ambedkar said about that. So that is most important. When you talk in terms of ahimsa, probably, how historically certain set of people have been subjected to structural violence, how do they perceive ahimsa, like the way the concept of ahimsa? Is it something that a meaning is always universal, or is it meaning is subjected or defined in a historical context? So probably I think these are all important texts, but there are also critiques to it. Probably I think we cannot ignore that as part of the Indian knowledge system. So thank you.
Okay. I think I'll ask, I think with this we'll conclude, but Professor Manoj Sinha will make a concluding speech and then summarize everything. So we'll finish. No. 3 minutes. Already now.
No, I have 7 minutes is visible. All right. So,
You are a chair, so you can use your...
No. So chair has I want to carry my chair also. The most important part, as my young friend just he has mentioned, he teach history when he teach the refugee law. That is very way I also believe that we should go into history. What we are talking about, we have not gone in the history of that Indian Society of International Law. We were not sitting here today had V.K. Krishna Menon did not insist upon Jawaharlal Nehru to create an institution for international law. And that is the reason how Indian Society of International Law was established in long time back in 1959 in Scindia House. It would have not been possible today to be here if Judge Nagendra Singh and also Krishnamurti and others insisted Indira Gandhi to give a plot in front of the Supreme Court that we need a place where we have our own building and we can disseminate and teach international law. And subsequently contribution of many people, including Professor Lakshmi Jambolkar and Professor R.K. Dikshit, Professor Anpi. So they created an institution to teach international law in India. They thought that how Indian society can offer a degree. They went to the Delhi University and 2 courses were affiliated from the Delhi University. This is how Indian Society of International Law evolved. We must take note of, and I request all of you, today, whatever meal you had here, whatever place you are in air-conditioned sitting, because of the great contribution and time spent by these people, you must acknowledge and give big round of applause for all that. Let me come to today, it's a great opportunity for all of us to hear a perspective from different way. And perspective led to the confusion and criticism also. I think we have perspective from 2 speakers on the international law from the national law schools. We have private university, we have central university, and then state university as usual, always they disappear. So state university representation was not there here today in that particular sense. But we have different perspective. What I personally feel, the students and South Asian University perspective, SARC perspective, the perspective in the modern national law school, if I say, they believe in more critical thinking. And if I compare some way, if you watch a movie by looking into the critics' comment, you will land in a very wrong movie sometimes. So criticism is good, but we have to also balance on the content part. And my difference, like, my Buddha Srinivas and myself, for a long time back, we discussed. But I'm happy with the critical legal thinking is very important element, as you both have and your colleague has mentioned, in Teach the International Law. And of course, the criticism has almost transformed the international law. What international law was in 1945 and what it emerged in the 2024, and in fact from the decolonization process itself, the shape of the General Assembly and the criticism, they started the concept of right to development. In the human rights context, people refusing to accept the content of the human rights, everything already changed because of the participation of the third world countries when emerged. And that participation sometimes also created some kind of difficulties. The removal of Commission on Human Rights to Human Rights Council, because US could not get a seat in 2001. Sudan became the member of the Human Rights Council. Libya represented as a chairperson in 2003. They said, what you are human rights talking about? Sudan is sitting as the chairperson, Libya is the chairperson, US could not get a seat because Commission on Human Rights from 18 to become 53, and then it's the equitable geographical distribution principle that led to the killing of the institution, and that has come another institution is there. These are the issues we have to look into all the perspective in a very holistic manner. Let's start with the quickly, just 2 minutes I'll sum up. And I think I start with the Major General Nilendra Kumar sir. He spoke about and he has contributed significantly, and he was nice enough to say that I have also contributed. YouTube he has developed. So that is the one source we have, and we should use it. He has mentioned about the how to frame syllabus, project, assignments, other things. Luther says has given 3 important points. He says how you perceive international law, how you look at the international law, and then he said, I think third point, I'm not quite sure what you become member of the Indian Society of International Law. So that is there. But Luther says a wide experience. Then we come to the Sandhya. Sandhya has talked about the number of things and you have cited the important case of the 1949 reparation case, and you have also said individual there. And then non-state actors, I'll leave it there because there was a very interesting story when in 1999 or sometime, LTT, they sent a request to the ICRC office that we are signing for Geneva Convention. And that became a big subject before the representative of the ICRC, whether non-state, because they were very happy. They are also coming forward and saying, and they finally concluded treaties, multilateral treaty, only state can become party. But we acknowledge that you want to respect. So this kind of challenges are also there in that particular sense, I say. Professor Srinivas and our young colleague Archana and Professor, all three have emphasized on a new approach in teaching of international law, critical aspect, critical legal thinking in that particular. And as I believe, we have to encourage our students to think critically overall for all subjects, whether it's a constitution and other things. In case of Akila, I just wanted to add something. If I look into the Visakha judgment, I look into the aspect, how Visakha judgment has, other aspects you could say, there's no point, how that has simplified application of international law in India by Justice J.S. Burma. They said keep the both concept. So some way we take help, our judges are saying. And then I bring in another case, Nilavati Behra versus State of Odisha, how court has used and provisions which we have a reservation, like Article 9, Paragraph 5 of the ICCPR, which says that India there is a right to seek compensation in case of unlawful detention. There, Justice Burma has cited in Nilavati Behra that we have an obligation, so we go beyond what there. And there are a number of cases which I suggest all of you to look into. Nilavati Behra, chairman railway board versus there. Then PK Kaul case is there. Then Nomgyal Dolgar case. Some high court judgments are equally very important in international law. Vikesh, your topic, like, and Sati Upadhyay ji, aapki bhi, you have mentioned, but what I was thinking about, when you have reframing of syllabus, I feel that is necessary. And I see we can draw some inspiration from the law and justice in globalizing world, and how we can take theory part here in the international law. And I thought what you are talking about, or you have in your mind, cosmopolitanism. It talks about individuals are not confined to a territory. Individual is become global citizen. So if I have a rights and duties, not because of I'm Indian, because I'm these citizens of the world, and this has exposed by the long time back, Immanuel Kant. So I think the cosmopolitanism, nationalism, and communitarianism, these are the ideas who support the international law, like Charles Bees, Thomas Fogge, Brian Barry. You include all this in your study, and you can make, like, your teaching, that is I expected. And because your subject, created very heated, a hot discussion, and I think we have to relook. But this is the good, and we have to also very sensitive. When you go in the class is not what I think. Class, we have to think the last person in the class, and then I have to develop my syllabus. So if it hurts some way, we have to see how our idea has to be shared with all this. With this, I end, and I think thank you very much, Chairperson, sir. You have given 7 minutes. Fir bacha hi hai. Thank you very much. Thank you very much, sir. Thank you.
I thank all the panelists for the presentations. Thank you very much, all of you. Please.
This society was because of Krishna Menon, not Krishna Murthy.
Krishna Menon.
And this land was
Krishna Rao
allotted. Please. This land was allotted by Jawaharlal Nehru, not Indira Gandhi. Please correct yourself.
Okay. Thank you. Batra, Dr. Batra is one of our old members. Thank you, Batra sir. So with this, I think we conclude this session, and I thank all of you for joining this debate, and we'll continue the debate in the tea time. And thank you. Oh, okay. 1 minute. Thank you all.
I now request Dr. Shikhar Ranjan sir to felicitate the chairpersons of the session, Dr. V.G. Hegde sir and Dr. Manoj Kumar Sinha sir.
अच्छा, okay.